So, like, this whole thing with and not paying me alimony, and I want you to know, like...
What do you think you would settle for?
It's like $61,000. I'm supposed to settle for what he's trying to throw at me or nothing? I know he's a piece of shit.
Send me money.
They're trying to throw me at a $61,000, $6,000. I'm not doing that. I'm not surrendering ever.
You could go through this trial and you could walk away with nothing.
What you're trying to do is you're trying to get me to surrender. Like, I could have been living comfortably. If he throws his crumbs and his peanuts at me, ain't gonna make nothing different. I'm not surrendering ever.
Welcome back. Today we will be looking over a recent filing of Sarah's, and by recent I mean like 3 months old at this point, but recent to this channel. So we're still waiting over 7 months for your Honorable Judge Jackson to get back with any kind of final judgment. Hold up, pause everything. I was in the middle of doing this video, and then lo and behold, finally after 10,000 years, Judge Jackson finally released her final judgment.
It's over! It's over! It's over! It's finished! It's over! It's over! It's over! It's over! I made it!
I am sorry, Miss Jackson.
I'm sorry, Miss Jackson. Ooh, I am for real.
I spoke too soon. I had lost all hope.
I lost all hope today. My car broke down.
But we finally made it after what, 7, almost 8 months? I thought your Honorable Judge Jackson
Miss Jackson. Ooh, I am for real.
had given up, and no one would have blamed you because Sarah exhausts everyone. But no, we finally have your Honorable Judge Jackson's 17-page final judgment, and I couldn't be happier because we are one step closer to shutting the book on this woman for good. Now, like I said before, I was in the middle of another video when this thing dropped, and it was still relevant, so I decided I'm just going to combine both of them so I can pivot and keep moving. And it was covering the letter Sarah sent in between the time of the final trial, the final hearing on August 25th, 2025, and the final judgment. Because Sarah Catherine Boone Paulsen...
Excuse me. I am better than you. I am better than you in every single... You're eating my peach.
...is impatient, and she's not going to wait on anyone. So she just had to send a letter in the meantime while waiting for this. So if you're watching this in the future, you can just hit the timestamp below and skip ahead. If you're watching this for the first time, we're going to take a little field trip first, and then we're going to get to this final judgment. But first, if you're new here, welcome to the world of long-form rant content, where there is no structure or goal. It is just me reacting to whatever I want to react to, however I want to react to it. And the video's finished when it is finished. I assert no authority or expertise on this channel. These are just my opinions. You take what you take, you leave what you leave. But if you leave a like on the way out. That's just good home training. And a comment and a subscription and whatever else you're supposed to do here. And with that out the way, let's rewind and get into this mess, because a lot is happening right now. I got this letter from Tanika's 2 cents. Thank you for sending this. And it's basically Sarah just complaining in the meantime that Brian has already implemented the rules that he has been arguing for this entire time. So he cut back her 9, 10, a million phone calls. I tried calling 9 times today, 8 yesterday. His phone so I can speak to him after trying 8 times over the weekend. I am floored. You nor he answered the phone after calling 3 times on each. I try calling you every night. I call every night to one phone call, and she can't take it. So like everything she does, she has to go complain to the judge, as though the judge is going to release a judgment before her judgment. But whatever, she has to complain anyway. All right. Respondent's Notice of Information. Comes now pro se respondent, Sarah K. Boone, and respectfully submits her notice of information for the Honorable Court's consideration while this family law matter remains open and pending final judgment since the trial held on August 25th, 2025. In the interim, the respondent makes the following statements for awareness of the petitioner, Brian C. Boone, continuing to inappropriately withhold rightful and reasonable parental time between mother and son, for no reason other than retaliation and disregard for the court's authority in his harmful, self-implemented rules, which are not in the best interest of the child. So out the gate making nothing but accusations and little side jabs, being like, since the final judgment on August 25th, 2025. Yeah, I think she knows. You're putting that in there because you want to say, what's taking so long? And this whole time, he's still doing all of this illegally. She does this thing where she asserts conclusions, but not whatever the violations are. What is being violated? She's saying he's withholding appropriate and reasonable time. How? What was established? Did you have written down in your parenting plan, I'm entitled to 7, 8, 9, 10, a million phone calls a week, and if you don't do that, then you are inappropriately withholding parenting time? Or does the parenting plan say 50-50 time sharing, and you just haven't done that for 5 years? 1. In the absence of a modified court order since the trial and after both parties' closing arguments were submitted, the respondent has experienced increasing unilateral restrictions imposed by the petitioner, vastly limiting her contact with her minor son. These restrictions of the petitioner include: A. Permitting only one telephone call per week between the respondent and minor son without a court order authorizing implementation of such restriction. He doesn't need a court order authorizing it because this is also him coordinating it and paying for it. If you were paying for these calls, you wouldn't need him. Your son could pick up the phone on his own because you would be able to put money on it. But no, he is giving you one phone call that he will pay for. Now, if you came back and say, I put money on the phone and I have money for him to answer the phone calls, and then former husband absolutely will not let my child pick up the phone, then there's an issue. Still not the time and place to bring it up. Time and place to bring it up is before this happened. But whatever, she has to scream into a brick wall just so she can say you didn't listen. During the Christmas and New Year period, B. Denying the respondent all holiday parenting time, stating it was, quote, his Christmas, according to the parenting plan, and she is, quote, not family to her through their son while on the telephone prior. C. Prevented telephone communication during the child's 2-week winter break by not providing funds for the respondent to call her son. And that's my point. It's not a violation because that was never a provision of the parenting plan. At no point does the parenting plan ever say that Brian has to provide funds or even provide a method for you to contact your child. That's on you. But she sure has pulled this before in the text messages, or Brian has pulled this when he's like, you need to calm down because it's my Christmas. Since you want to have a death grip over this parenting plan, leave us alone, and I have an actual reason this time. You told me when on the phone lying about everything when I was trying to check status of anything since returning from your vacation, that I was not permitted to see my son during any of the holidays, including Thanksgiving, Christmas, and New Year's, stating, quote, it's my Christmas and holidays this year, Sarah. I'm still dumbfounded you are enforcing the parenting plan while I'm incarcerated. You've had him for all the holidays ever since I've been here. That was you being cruel and controlling and you throwing your weight around. There's a lot. And depriving me time with my son like you do with everything. Why? Beyond ridiculous. Why don't you enforce or abide by the alimony section of the agreement? And she got so mad at that. How dare you enforce the parenting plan while I'm here? But also, how dare you not follow the parenting plan and add funds? She wants to enforce parts of it like it's absolute law and ignore the parts that she can't do. But she revealed that they said she's not family through her son. Does that mean the son told her that he doesn't consider her family? Or was he talking with the son, and because she likes to use the son as a go-between, was asking Brian something, and then Brian responded to her through the son? Maybe it was that way. Either way, damn. D. Refused a pre-discussed 15-minute remote video visit on Christmas Day for the 6th consecutive year to allow the minor son to open the respondent's gifts she privately arranged, then pressured the child to open without her in front of the petitioner's family.
I'm here to tell you right now, we don't care.
Let me tell you something.
We don't care.
Jerry.
Now, this is just silly. This whole thing is just absolutely silly. You are messaging a judge saying he denied a previously discussed phone call as though we don't know words mean things. Just because you discussed it doesn't mean you agreed to it. You discussed a lot of things. You discuss everything. Rarely does anyone agree with what you have to say. And you're going to tell a judge lawyer whose whole career is built on knowing what words mean that, oh, well, they discussed it, so how dare he not do that? He's in violation. And in violation of what? Of Christmas gifts. You're upset because you specifically, Sarah Catherine Boone Paulsen, didn't get to witness your son open gifts you had arranged for him. Translation, shit you still didn't pay for. But because you didn't get to see the joy on his face that he would have attributed to you, even though you weren't the one who actually got it for him, then Brian is violating the child's rights. Oh, and he's forcing him, pressuring him into opening it with his family and not mine. Or does it make more sense that she hounds him saying, save it for a video visit, make sure not to open your presents. Did you get our presents? Make sure to hold off until you open them in front of me. It can't just be, oh, open those presents and then give me a call and then give me all the praise about how much you love it and like it. No, we have to write a whole letter because he opened them without you. She's a child. She's literally a child. E. Declined a pre-discussed in-person visit with the respondent, which was the last opportunity for the minor son to see her during his entire two-week holiday break before returning to school. Wherefore, due to the absence of a modified court order generated from the trial, both parties' closing arguments, and the case as a whole, the respondent's concern is the petitioner will remain non-compliant in his unreasonable actions and comments such as the aforementioned, or worse, which are not in the child's best interest and continue to impede the meaningful relationship with her minor son. And I want it to be a joke when I call her a child, but no, literally. She is tattling to a judge. He's calling me names, or worse. He said I'm not family. He declined a pre-discussed phone call, a pre-discussed visit, not agreed upon, not set in stone. It wasn't scheduled on the books, and then he decided not to show up. It was never agreed upon. It was never going to happen. And then the irony of her keeps saying, without a modified court order, he is being non-compliant when she is still being non-compliant. Every other week, you need to be up in front of Brian's front door, knocking on the door saying, hi, can I pick up my child to follow the current unmodified parenting plan, which tells me I'm supposed to have my kid. Oh, wait, I can't do that? Okay, ignore that. That doesn't matter. How dare you not bring him over his 2-week winter vacation? And you know it's because their excuse is, well, during school it's too busy. Okay, well, you have your break coming up. You were there the whole 2 weeks and you didn't come see me once? No. Because people need to enjoy their breaks, not add more work by going to prison. It's just like silly's the best word for it. And it just shows she don't have any real friends because the people, her flying monkeys, are boosting her head up saying, yup, this'll get them. This'll get the judge to side with you. No, it's just going to be another I told you so moment of, why are you doing this? This only makes you look least credible, more complaining, more abusive, less complicit, incapable of any kind of boundaries. It just speaks to your character more. You are not going to wait for the judge to give a final order. You are in discomfort, so you're going to assert yourself again. The respondent respectfully requests this honorable court to graciously consider the post-trial developments in this notice to understand the negative efforts continued by the petitioner and her positive determination in still avidly trying to spend time with her son, however, whenever, and wherever possible, and which are in his best interest at all times. Respectfully submitted on this 9th day of January, 2026. Sarah Boone, Certificate of Service, blah. And there it is, her letter before the final judgment, her impatient. I would like you to please consider. What does that mean? It means I'm still making argument even after closing arguments have been submitted. It's taking you so long, and I'm worried you're not going to side with me, so I need to tattletale one final time, and I want you to consider it, which could be considered ex parte communication, because it's just one-sided communication with the judge for your own personal gain, and she would get in big trouble if she did actually consider this. I bet you she read this, laughed, and kept going. It's just, I think it just confirmed pretty much the similar to what happened with Kranick, where he wrote the 16-page order taking her lawyer away, and then I'm sure he probably felt apprehensive of, okay, how's this going to go? And then the next millisecond, she submits another aggressive letter, just abusing the court system, trying to get someone else in trouble, or just insulting them.
What doesn't anyone know already about my case? How about my side in everything about everything? Be correctly understood that I am not the problem. For reasons I am on malappointed by the court attorney number 8. Judge Kranick, I am trying to receive, please, a copy of her withdrawal to better understand her reasons for the undisclosed departure from my case. No attempts was made on her part to solve or remedy in some type of discussion professionally beforehand. Therefore, I am having to include you in this request.
Which then only solidified his decision of, oh, no, I was correct. I made the right one. And so I hope when Miss Jackson saw this, she's like, yup, I made the exact correct decision by stripping everything away from her. More or less. Speaking of, let's now jump over into the final judgment, which you all came here to see. See, exactly. Linda's even ready too, so I'm not going to leave her waiting any longer. Let's dive right in. Alrighty, supplemental final judgment on modification and relocation. This cause having come on August 25th, 2025 for consideration of petitioner father Brian C. Boone's supplemental petition for modification of final judgment, quote, modification petition filed on April 12th, 2022, and verified petition to relocate, quote, relocation petition filed on February 14th, 2023, and respondent mother Sarah K. Boone's motion for contempt, quote, motion for contempt filed on April 11th, 2023. The parties having appeared and the court having reviewed the court file and being duly advised in the premise finds and orders as follows. 1. Petitioner seeks modification of the party's final judgment and relocation to Gainesville with minor child. 2. Petitioner's modification petition is granted in part, and petitioner's relocation petition is granted. Based on the following. 1. Modification petition. 3. In his modification petition, petitioner seeks a modification of shared parental responsibility for the party's minor child the termination of alimony, the termination of child support, and attorney's fees and costs. See Modification Petition at page 4 through 7. 4. On June 15, 2018, this court entered a final judgment of dissolution of marriage, quote, final judgment, that adopted the parties' marital settlement agreement, quote, MSA, and parenting plan, quote, parenting plan, that were filed on May 9, 2028. See final judgment at page 3. 5. The parties were awarded shared parental responsibility for the party's minor child, and petitioner was ordered to pay monthly child support of $100 and durational alimony of $1,000 per month for 84 months. See final judgment at page 5, 6, and 8. And there's a little one thing. Let's go to the one. The alimony payments were to start on May 1st, 2018, making the 84th payment and final payment due on April 1st, 2025. 6. In his modification petition, petitioner alleges the final judgment should be modified due to a substantial change in circumstance. To wit, respondent's, quote, was arrested and charged with second-degree murder of her boyfriend.
Why is this happening?
Because George is dead.
Someone needs to call Brian, please.
Okay.
Or can I not make the phone call? So what am I supposed to do now? Someone needs to call Brian. But how long will that take? Because I need to talk to Brian.
The party's minor child, quote, has lived exclusively with petitioner since respondent's incarceration, and respondent, quote, does not have the financial need for alimony or child support. See modification petition at page 3. 7. Respondent filed a 9-page handwritten response, quote, modification answer on May 16, 2022, generally denying all of the petitioner's requests for modification rather than responding to each paragraph and the modification petition. Welcome to detour number 1 or 2? Detour number 2. Because basically this first part was just Judge Jackson establishing the base facts. She was arrested, they were divorced, this is a mess. Now, Judge Jackson is being extremely kind when she says that she, in general, just expressed disapproval of everything that Brian submitted and didn't respond to the thing paragraph by paragraph. Yeah, that's a little bit of an understatement. And it's one of the letters that we actually do have, and it says it's from May 1st, but Mr. Martell filed it with the court on May 16th, so that's why it's referred to as the May 16th thing, even though the letter we're about to read says May 1st.
Petitioner filed a handwritten document on it's dated May 1st of 2022, but it looks like it was filed with the court on May 16th. And there was a notice of filing by attorney Martell. Looks like he may have received a copy of it and he filed it with the court. Is
it an answer to our petition?
Yes. And it looks like you may have filed a notice of filing just to make sure it got into the court.
Yeah, I no objection.
All right. So I'm going to receive what is presented as Respondent's Composite Exhibit 7, which is that notice of filing by attorney Martell, as well as the actual handwritten answer. I'm going to receive that into evidence as Respondent's Exhibit number 5.
May 1st, 2022, the marriage of Brian C. Boone, Sarah K. Boone, case number da-da-da-da. Dear Sir/Madam, I am writing in regards to a summons I received 4/22/22 stating a lawsuit has been filed against me in the aforementioned matter. As instructed, this letter will serve as my personal/individual written response to the supplemental petition, joint stipulation, and notice of appearance included. I am in the process of trying to obtain representation for this and diligently working day by day, doing the best I can, and am literally able with the little to non-existent resources I have available. Please know with great emphasis that I am doing everything possible to defend and protect myself as a person and a mother foremost, while incarcerated temporarily
We, the jury, find the defendant guilty of murder in the second degree.
Ms. Boone, court sentences you.
Electric chair.
Oh, shit. God damn it.
Electrocute that bitch. And I want you to pour some water on her first.
To life in the Department of Corrections.
I have nothing and no one to help me as both my parents, grandparents, aunt, and uncle are deceased. I have an older brother who is unable to be located and a younger brother who is currently deployed in Africa for the Marines. I also have no counsel of any kind. Per the summons packet, I have tried to contact a referral servants and legal aid via phone with no success due to the numbers being, quote, unauthorized in accordance to the rules of OCCD. I am working expeditiously to find an alternative way to contact and figure out some type of facilitator in the meantime. Your patience is greatly appreciated. As said, I am doing all I can to stress my dedication as well as the seriousness to this matter as a concerned parent and how it is of the utmost importance to be rightfully conveyed and understood as the very competent, caring, loving, hardworking, determined person that I am and whose, quote, mental ability to co-parent is undeniably obvious and without any doubt should be included in the ongoing nurturing of our son. My decisions, ideas, opinions, feedback, rules matter. To be excluded in any way just because of my current temporary
to life in the Department of Corrections
circumstances and location is wrong, unfair, and unacceptable. It makes absolutely no difference where I am. Jail, space, Australia.
Girl, prison, honey.
I am not and will never be useless, especially to our son. I am still his one and only mother who loves, cares, and adores him beyond measure and makes his safety, mental, emotional, physical, and spiritual well-being my priority and will for the rest of my life. I will never stop being his mother and using my God-given talent and rights as his mother to remain so. One obscure, unfortunate incident does not define me as a person or my entire existence.
I'm pretty sure this is the first time she made that horrific statement and then just continued to repeat it for years on end.
These inaccurate, unnecessary modifications, the relief he is seeking could have been avoided until he decided to involve our son and my maternal rights again. One obscure, unfortunate incident.
I'm sorry, what? As though, one, it worked the first time. Two, it actually means anything. In order to call someone's violent, torturous murder, and even if you don't think that you're a murderer, just say killing, a horrific killing, an unfortunate, obscure incident, as though we don't know exactly what happened that night, and because of her.
But you all have more information than I do, where it's like, yeah, you might want to, or yeah, you might want to.
I'm sorry, what?
Like, we have more information on what?
Like,
We told you everything that we have. You know everything that we know. And most of it we got from you. Most of it we got from you.
like, I don't know if you all have looked through my phone yet and seen any of the pictures and the videos that I have taken.
Mm-hmm.
And at one point, I started documenting everything.
Okay.
So you all will see in my pictures. So when you all see my phone, you can see all of the damage he has done to me and the videos. He's dancing with my dog. You can see that too on the pictures, him loving the dog. He loves the dog.
For terrorizing and threatening my blind and deaf dogs by leaving the gate open I built to keep them safe, telling me he hoped I'd find their bloated dead body in the pond or scrape their remains off of the pavement.
Him loving the dog. He loves the dog.
Insane. Also, by the way, in this whole opening, she hasn't once addressed the actual petition. whatsoever. Not anything in the provisions, not anything they're asking for, not anything she wants to argue against. She's just all blanketing. I have nothing, I have no one, I'm so sad, I'm so pathetic.
Send me money, send me money, send me money. How can I send you money when I don't have a job?
How could anyone do this to me? I'm trying everything I can, and just because I murdered someone, that shouldn't change anything, so how dare you even submit this? Yeah, she was doomed from the start.
I want my son to know and show him I am always willing to exceed any limitations placed upon me that would hinder my relationship with him as his mother and being included in every aspect of his life, then, now, and future. He is my life. Who is former husband to assume and to, quote, think his sole decisions are the best, fairest, and most successful for our son? I have God, my giving heart, functioning well above average. Functioning well above average, brain and bold voice to be my son's best advocate, as well as my own. I matter. If needed, our son should be included and asked his thoughts of his father attempting to remove my right in being his mother, and only ever be able to ask about his video games and what he had for dinner. Nothing of moral value or life defining. I am not the worthless, mindless, heartless, unproductive, non-contributing, poor and pitiful footstool he would like me to be and tries to make me out as to others. It makes no difference where I am. It's who I am. Mother, now and always. And again, one incident does not define me or my entire existence. I have so much to offer in so many ways, and it would be extremely detrimental, as well as a great loss, to not be able to continue in the shaping of our son and his very extraordinary life. Is former, quote, husband able to handle the consequences, burden, and heartache should his decisions jeopardize or harm the best possible outcomes and inhibit the absolute success our son could have been or had?
And it's when we get to this part where I'm like, are we being punked right now? Like, this is you. This is you. The self-awareness, but also the lack of self-awareness is mind-blowing to such a specificity. Is former husband literally just sub your name in and it is you? Is former, quote, wife, is former, quote, Sarah Boone Paulsen able to handle the consequences,
Guilty of murder in the second degree,
burden, and heartache?
Court sentences you to life in the Department of Corrections.
Should his decisions jeopardize or harm the best possible outcomes and inhibit the absolute success our son could have been or had?
Obviously not. She was supposed to pick up her son from school that day.
That's fine.
She directly affected the outcome of his life from the moment she killed George. Insanity. To write this from jail for murder. Wild.
How will this sole great responsibility, should it be awarded, affect the former husband's mental ability going forward, as all instances, scenarios, and situations are not the same? That is why there are two parents, both to broaden all horizons, outlooks, and futures for their children, and in which I am so desperately fighting now to continue to do for mine, and all for the right reasons. I am no longer going to willingly make it easy for former husband to advantageously rob me of my last and only minute life resources out of bitterness, greed, and spiteful opportunity.
And this is where she tells on herself. She point blank says, I am no longer going to make it easy for a husband to take everything away from me. What does that mean? Translation, I'm going to be as difficult as possible until the very end. I will never conform. I will never surrender.
I'm not doing that. I'm not surrendering ever. It's still the same thing. It's still the same thing. What you're trying to do is you're trying to get me to surrender.
Why? Because you brought my mom rights into this. So now you're deserving of going through years of litigation until you give me what I want. And then I'm going to throw a fit when I still lose anyway. She says, all for the right reasons. Again, this is the time for you to name those reasons. What reasons? You still have not addressed his original petition to modify. And when I saw this letter, I didn't realize that this was a response to the initial petition. I thought this was just one of her endless letters to the judge complaining about the developments of what's happening. But no, her first response to all of this is this. And up front, out of the gate, she says, I will no longer make it easy for you. I will put you through hell. We will drag this out as long as physically possible.
Be paying me something, or at least, just something. I would have something in my drawer, and it's just, like, out of $61,000, I'm supposed to settle for what he's trying to throw at me or nothing? Like, I could have been living comfortably.
Yeah.
Not being, like, shaky and, dysfunctional and just...
Have you thought about sending him a letter and him and his attorney and saying, hey...
I'm not doing that. I'm not surrendering ever.
I would be concerned that you could go through this trial and you could walk away with nothing.
What do I have now? Hey, what do I have now? It's still the same thing. What you're trying to do is you're trying to get me to surrender.
But that's okay, because it's all for the right reasons. It's all for my son. And that's why I'm saying you're trying to advantageously take all of my minute resources left that I have in life. Why? Because it's bitterness and spite, taking advantage of the opportunity. That's how she boils this down to. She keeps repeating nonstop, he's doing this for no reason.
Why is this happening?
Because George is dead.
As though she is not a convicted killer.
Find the defendant guilty of murder in the second degree.
In her mind, no reason he could be doing this other than he doesn't like her, he's bitter, and he's just trying to take advantage of her situation. What's the situation? You being imprisoned away from society because of your terrible, violent nature.
Ms. Boone, court sentences you
Electric chair.
to life in the Department of Corrections.
But there's no other reason. Right.
At my weakest, broken, most vulnerable moment, he is attempting to take full advantage of such with this unwarranted, vicious attack, thinking, hoping, and assuming I will wave a white flag, which I do not own.
And what you're trying to do is you're trying to get me to surrender. I'm not surrendering ever.
Especially when it comes to my son. He is wrong in doing so, knowing fully the playing field is not and has never been even. All odds are against me due to my monetary restrictions and lack of support system. It is illogical and futile to try and have a conversation or discussion that is real, rational, or legitimate with former husband about anything. Then during our marriage and now. His superiority complex and ongoing dishonesty have made it very difficult and sometimes impossible to work with him. This in turn has compelled me now to bring to attention some of my concerns in the egregious decisions he has made prior and during my incarceration, as well as from my son personally stating, quote, Dad's laziness, empty promises, and disappointments. Son knows without any hesitations or doubt, I will do anything, anytime, anywhere, all within reason.
And she doesn't say that because she's actually trying to be reasonable. She's saying that because she can't follow the parenting plan. I will do anything for him at any time, anywhere, except actually follow the parenting plan and take responsibility for raising my child. I'll do anything but that. That stuff is so annoying to me because it's acknowledging your situation without acknowledging it. You'll acknowledge that you can't actually do things and you want us to be okay with that, but also you want us to believe you can do everything without any proof. Also, unfortunately, your son, quote unquote, knowing this about you doesn't mean you have a legally viable argument, nor that you're going to win this. You could say your son knows anything. There's no way to fact check it. And that doesn't combat any of the modifications that Brian is asking for.
To help him, which is why I, his mother, have been his go-to person in many ways for many things throughout his life, including while being incarcerated. Former husband is penalizing me because I care nonstop and I have regular ongoing concerns, questions as our son continues to grow that are important, needing to be discussed. Our son can and will grow better, stronger, brighter with my decisions included also, as they have been since I brought him into this world. Former husband and I did this together, and I may be obsolete to him, but I am not to my son, nor will I ever be. So stop trying. When trying to speak to or with former husband and have an opinion, idea, belief, feedback, etc., that is not in line with his or his parents, I have been laughed at, completely ignored, and disregarded, given the silent treatment, berated, and made to cry or hung up on, most every time in front of our son. This, to me, is setting a poor example of how a man, husband, should treat a woman, wife. On top of being a bully, son hears and sees how former husband, his father, treats, degrades, and judges me, his mother.
Do you get it, everyone? Do you get it? She's a woman and he's a man. And that's supposed to change all of this for some reason. She does this all the time, and it is so plain as day manipulative of, I'm not responsible for anything because I'm just a woman, and he's being so mean to his woman. What is the precedent he's saying? How a man can treat another woman.
I had nothing to compare to. I've never been hit by a man ever before in my life. I was raised hitting a woman was wrong and should never happen. No excuse.
No excuse.
She can get a bit violent when she drinks. That was part of it.
And you said when she drinks that she can get physically aggressive?
She can. I mean, she did it to me a lot, where she'd hit me and stuff like that. I mean, she's tiny.
What do you mean hit, though?
She'd punch me. I mean, more arms. She many times would use her claws. I mean, I had scratches on my neck at times, on my arms. I mean.
And we were informed of some injuries that he has. So he's got scratch marks to his back.
I know what that's from.
Okay. Because there's also sex?
Yes.
Okay. Because there's also like a scratch on like the back of his neck, like kind of like going, but it's like going straight across.
I have no idea what that's from.
Things like that where she'd dig with her claws.
Did you ever see marks or bruises on him?
Yes.
Okay. Like what?
Scratches on the neck.
Scratches.
You know, that's what he was explaining to me, is she was always the touchy one, the aggressive one, you know, not that she was hitting him, but she would be like in his face, or she might, you know, push him, or, you know, little things like that. She was always drunk, and she's very hands-on.
No excuse.
How about how a woman can murder another man? What kind of example are you setting, inmate? You were trying to condemn Brian for setting reasonable boundaries and trying to put your son first. Meanwhile, what you are teaching your son is that no matter what, a woman is allowed to do anything she wants to you. She can hit you, she can spit on you, she can choke you, she can do anything, she can say anything to anyone, slap you around, and if you do anything, if you try to assert yourself, if you hit back because you are being assaulted, you are the monster. You are the woman-hating monster. I cannot stand this defense because it actually just undercuts the women who actually go through this every single day. The women who actually aren't believed, who actually face violence on a daily basis, and their accusations and pleas for help fall on deaf ears. You have a microphone, a megaphone, everyone who's been trying to listen to you, and you just keep dragging this out again and again, avoiding all responsibility. And when things get too close or you get pushed into a corner, remember everyone, I'm a woman, I'm his mother. That means things apply to me that don't apply to you, and also punishments don't apply to me that would apply to you. And another thing, this is me from the future while I'm editing this, Emily D. Baker also just released her reaction to Sarah's appellate brief, which, oh my gosh, now that that's come out, that's going to have to be a video at some point in the future. I just can't mentally get there yet. However, she reread Sarah's god-awful sentencing statement before she jumped into that, and she made this point as well and did it a way better job than me and called out some hypocrisy I didn't check beforehand, and I was like, damn.
I forgive Patricia. Patricia A. Cashman. Sorry, that's a real deep cut color guard meme. I don't know if the Patricia soundbite has made it out of the banned world on Instagram.
3, 4, 5, 6, 7.
Patricia!
Get it together, sweetie. We have a show this weekend.
I also just love how much of a band mom Emily D. Baker is. It's incredible to me. And one of her kids, I think her son, does drum corps, and I almost did DCI as well, but then they were like, you have to do this much practicing, you have to do this much physical activity, and you have to go to this many places. I said, nah, I'll see y'all in the stands. But every time she brings it up, I'm just like, I feel you. I am a Carolina Crown sun, a Blue Devils moon, and a Boston Crusaders rising. And for those who get it, will get it.
If you are in any of the band or color guard world on Instagram, Patricia! Get it together, sweetie. We have a show this weekend. Well, that's a deep cut. I forgive Patricia for her mean, snotty, egotistical attitude. Ma'am, who's upset with Patricia being an outspoken woman?
I have also added to my statement as a result of your blindness and impartiality. Foremost, you're disgusted me as being an outspoken woman, determined defendant, and proactive client.
You're calling your female attorney snotty? You didn't call any of your other attorneys snotty.
I don't understand what it is that she has against me. I have told her from day one that her snotty attitude was inappropriate.
Her snotty attitude was inappropriate.
You didn't call any of your other attorneys egotistical. You didn't call any of your other attorneys mean. You said that they were greedy and selfish. Why are you coming for your female attorney like that, Sarah?
The tea is exceptionally good today. Who made this? Very delicious.
Why you gotta call Patricia snotty? Patricia! Because I bet Patricia said the exact same thing to you that all the other lawyers did, which is no, we're not doing that. But no, Patricia gets called snotty. Sure. She forgives Patricia for having boundaries. That's me reading between the lines. She forgives Patricia for being mean, snotty, and egotistical for her attitude, because Patricia was giving attitude. The other lawyers were just greedy, but Patricia has attitude. No, ma'am. Patricia's just telling you the same thing all the other lawyers told you, I'm sure. For being helpless, desperate, simple-minded, weak, and inexperienced. I'm just a girl. I forgive myself for just being a girl. The thing that makes me so mad about this is that self-forgiveness is needed for many things. So many carry around shame that is not theirs, carry around pain that is not theirs, carry around a weight of something that is not yours to carry. And there is room to forgive yourself because it's not your fault. This is not that. Ma'am. Also, you don't get to hit someone and be like, you can't hit me. I'm a woman. That also doesn't work, Sarah. Nope.
It just makes her look genuinely pathetic and desperate. When you have no actual arguments for why you deserve what you're claiming, and your only argument is your biology and your ability to give birth. And because of these two things, it's okay that you're a killer. How dare he give you the silent treatment? How dare you be laughed at and made to cry? How about being made to die? Zero self-awareness. If I was you, I would never bring up discomfort again. I would never bring up that I feel cramped. I would never bring up how much I feel like I need to be set free, that I don't want to be locked in here anymore, when that is exactly what you did to George. What is it that you always said? George insulted you and made you upset, and you told the police they need to put him under the jail. Under the jail.
It's not having anything else because you're taking him down. Put him under the jail.
He's going.
Under the jail.
Okay.
So where do you think you belong?
Under the jail. He's going. Under the jail.
This is extremely confusing and sad to our son, as he knows I only discuss, or try to, anything that pertains to him. You told me to send to you the same time I sent sons, and which I will purchase for myself and through someone else. You will not allow either way, and I still have nothing, anything I need or want. Books, food, stamps, socks, etc. You keep making me ask for updates like it's coming, and you've told me so many times in the past years it is. Nothing. Why would you do that? I can do everything without you except supplying funds, which is your responsibility of alimony. I do not have to speak to you or waste money on messages. I do not have to be ridiculed and abused or laughed at or called names. I've tried everything with you and provided innumerable, simplified solutions. You make everything difficult, more confusing, annoying. Going forward, when I have to call again from no responses, please do not call me names and lie. Please
Send me money, send me money, send me money.
provide funds for all the aforementioned you keep telling me you will, and I need. No money is spent frivolously, except for all the messages you won't respond to, and I keep having to send from no updates or completion of anything, including for our son. To Brian. Phone call confirmation, commissary, soap for son, hymnal, keep it kosher food pack, pizza and wings hot meal, birds and blooms magazine renewal. You stated to me to call back Monday for order info. Per the phone call we had today regarding my reasonable requests I am still waiting on for you to order, as said some years, months, weeks, and after I heard you physically typing on your computer said reasonable requests to know and remember. I am forwarding to you again should you not understand, after stating you do. From any of the now 118 tablet messages I sent to you previously, and you do not respond to any to date, and the 104 recorded telephone calls asking the same questions. No money is spent frivolously, except for all the messages you won't respond to, and I keep having to send from no updates or completion of anything, including for our son. Why do you make the active ongoing decision to not order any of my reasonable requests, including for my son? Why do you keep lying about placing orders for any of my reasonable requests, including for my son? Why do you tell me to call back or you will respond to a message for order confirmation numbers and you do not order? As stated, this will confirm you placed the order. He hears me being told indirectly I am unimportant. This is unacceptable, damaging, and mean. Also having lasting effects, an inherited trait led by example of his father, and serves no purpose, quality, or value. A bad decision.
So now her son abuses her too. But it's okay. It's not actually his fault. He just has a bad inherited trait led from his father that serves no purpose or value. Translation, he makes me feel bad, so it's Brian's fault.
And another thing, because I thought I was done there, but I'm not. Because I remember in a prior letter, she also brought up her son as like, I want my son, but I'm being abused by them, and I don't need this version of my child. I don't need to be abused, this and that.
No one listens to me. I have made the active decision to not call for an undetermined length of time so I can take a break from the beratement. I can only take the terrors inflicted by former husband in doses. Right now, I've gotten my fill from both of them. If my son wants to speak to me, he can write or schedule a visit, which I doubt will happen from the lack of encouragement and inclusion of me to have a relationship with our son by former husband. Please understand, I can only take so much on top of everything else. I love my son. I need my son. Just not this version. Not right now.
Because she wants to control him. Everything she says is about control. She doesn't want this version of him, meaning she doesn't want him. Fun little note to parents out there, you can't choose who your child becomes. You can help them, you can want to guide them, but they are their own individual people. And the more you try to control them, say, I want this version of you, the more they will depart from you as they get older.
What former husband is trying to do is sweep me in a dark, bleak corner and keep me there, hoping I find no way out. Yet again, another tone-deaf BS statement. He is trying to lock me away and hoping I find no way out. No, that would be locking someone in a suitcase and making sure they have no way out. You didn't hope George couldn't find a way out. You made sure he couldn't.
And my fear was that he was going to break out of the suitcase knowing that it was a broken suitcase.
The suitcase is downstairs because I was telling you we were going to do donations.
The suitcase originally is in our closet, buried all the way to the back. If you, I know the CSI people saw our closet. Our closet needs to be cleaned out really bad. My son's clothes need to be cleaned out really bad because they don't fit him anymore, and I'm tired of looking at them. So he took it upon himself, including that suitcase, to take it downstairs so we can get all of our clothes, our donations and everything, and just leave the whole thing. Leave the whole thing by the clothing and shoe thing at my son's school.
And because it's not a very good suitcase, what was the question? I'm sorry.
And his hand started to come through. His hand started to come through this way. And so I shook the suitcase. Trying to get his hand to go back in, shaking it, and telling him that, please stop doing this. Please stop doing this to me. Please stop doing this to me.
So his hand actually got out of the suitcase?
Yes.
And you went to the suitcase?
Yes.
And shook it?
Yes.
Electric chair.
Holy shit. God damn it. And you flipped the bag around several times.
I didn't do that intentionally.
You didn't intentionally flip the bag around?
No. Why would I do that?
Well, you
Good
told us
question.
you
You
did.
did.
When he was upside down.
Right.
Well, you had to put him upside down.
You can't get in a suitcase upside down because the...
Oh my gosh.
When you put the stuff
and that's
in where his body was?
That's the unfortunate thing too, is nobody else was there. That's the
We have a
unfortunate
video
thing.
showing the suitcase in several different positions.
Did that force his hand to go back in?
No.
So you're shaking it. Were you shaking it to try to get the suitcase, his hand back in?
Yes.
How long did you shake it?
I don't know.
Electrocute that bitch. And I want you to pour some water on her first.
But his hand was still out.
Yes.
Was he trying to get out?
Forcefully, yes.
Was he angry at you?
Yes.
Were you in fear?
Always.
We had a good day.
Mm-hmm.
It was a good day. We've had good days lately. It's been good.
Were you in fear?
Always.
Like, I don't even know where this is coming from.
If he would have gotten out of the suitcase, what would he have done to you?
Like he used to tell me, he probably would have made me unrecognizable, or I would have lost my life.
Which is absolutely insane to have those words come out of your mouth. And I don't know why the prosecution didn't say objection speculation, because it's the most speculative question out there. She doesn't know what he would have done. He didn't tell her, as soon as I get out of here, I'm going to do X, Y, and Z. My belief is if he was finally let out, he would have ran away from your ass, running in the street, screaming, "This just try to kill me," locking me in a suitcase. "Anyone help me. I don't have a phone. I don't have a car. I don't have a place to live. I need help." That, based off of the videos you took, is the more likely action here. That question is ridiculous. If he had reframed it and said, "What do you believe he would have done?" Still a BS question, she doesn't know, but that would be more towards her mental state of mind, because that's what the question's getting at. The question is, what did you think would happen if you let him out? Were you in imminent fear? Which is still BS, because he is confined in a suitcase. We're taking a little detour 2.5. whatever this is. Her testimony and cross-examination is like one of the only big videos that I haven't tackled yet. I'll get there eventually at some point, but it's just a mess and will take a whole long time to get through. So I just want a mini rant on this, because this answer alone is enough to get her life in prison.
Ms. Boone, court sentences you
to life in the Department of Corrections
with credit time served.
She has no idea. And she kept trying to speak over again and again because she had a story that she wanted to tell, but then didn't know how to tell it. But it is absolutely bone-chilling to hear her say he tried to get his hand out. You know, originally she says his 2 little fingers.
Oh, he decided to hide in there. So, being silly, he and I were sitting there laughing at it, like with him in there. And then, so I didn't zip it up all the way. But, I mean, enough to where his little fingers were out there and whatever, but still having a good time and whatever.
And that's what they argued was the overt act in order to run battered spouse syndrome. As soon as she saw his 2 little fingers, obviously she was in fear for her life.
Were you in fear?
Always.
But still having a good time and whatever.
Despite having no injuries that entire day, bragging about it the next day, saying, "If I have nothing on me, of course I didn't hit him, beat the shit out of him, lock him in a cage, kick him down a flight of stairs, taunt him, film him, and then leave him there."
He nor I.
Well, he's dead as a result
Laid
of your
hands
action.
on each other.
He is dead as a result of
I
your
understand
action.
that. That's why
You two didn't lay hands on each other.
No. No. I don't have anything.
I don't have anything.
You're right.
He doesn't. Whatever that is, whatever it is.
He does.
See, this is what happens. It's not fair that you guys, just because he has those, automatically blame it on me.
You made those injuries.
I did.
But that's okay, because those 2 little fingers, which is now being upgraded to his whole hand, was out of the suitcase. Was he trying to get out? Yes, forcefully. Of course, he's trying to survive. You thought you were going to convince a jury by saying he forcefully tried to get out when I told him, "Please stop doing this to me. Stop doing this to me.
Please stop doing this to me. Please stop doing this to me."
What is that thing you are doing? Trying to survive. If you had just stayed in the suitcase until I was done having my fun torturing you, I would have let you out. But no, you kept complaining. "I can't breathe. Please help. Baby, please, I'm serious." Well, maybe you should just shut the fuck up. That's on you.
That's on you. It's on you. You should probably shut the fuck up.
She didn't give a single ounce of a shit about him and what could have happened and what did happen. The textbook definition of depraved heart second-degree murder. So anytime she says, I should be free, why is this happening? It's happening because you demanded it happened when you demanded he stay locked in that cage. Which is why it's insane for her to say one obscure, unfortunate incident should not define me. What's the obscure, unfortunate incident? Was beating him up with a bat the obscure, unfortunate incident? Was locking him in the suitcase the obscure, unfortunate incident? Was kicking him down the flight of stairs to where your neighbors say they heard the loudest bang they have ever heard while living there next to you?
Right around 10:30, 11 o'clock maybe is when I heard like it get escalated, you know, like it's like the voices got louder, they were yelling, whatever, and then like it got quiet for a little while, and then I heard this really loud like slamming noise. Excuse me.
Do you know about what time that was?
Right around 11:15. It was about 15 minutes span there, you know, and then
when you say a slamming noise, does it sound like something hit the wall?
Like something like was bouncing down the stairs between the railing and the wall and the stairs. Like all the way down, like, you know, and it was clear because like my roommate even said it too, like he heard it up here and it kind of went away from him, and he's the front room here.
Around 10:30 or 11 o'clock, there was a very loud crashing sound where I believe, I'm not sure, I haven't been in their apartment like my roommate, but I believe is the location of the staircase.
Okay, so
a little bit above.
A very loud, you said crashing sound?
Yeah, like it sounded like something had been like falling down the stairs. Because it started up high and then it ended low.
But you have heard loud noises in the past, but not as loud as you had heard on Sunday night?
No, it had never been that. Like, I felt the walls shake as the sound happened.
It was literally right next to me, and I've never felt this before, but that night I was explaining to him the next day because he had said he heard the noise, and I was like, dude, I felt the wall shake. Like, it was literally like such a powerful hit against the wall, like the wall shook, and I felt it. And that was like something that where I was like, I kind of looked at the wall and I was just like, that was a little much. A little much. But like, I thought, and this whole time I really, really thought it was like him, you know what I mean, like going off or whatever. But
and yet again, you have no injuries on you, and he, according to the medical examiner, was absolutely brutalized.
So there were some blunt impact injuries to his head, right up here around the eye and on the mouth area.
Did you notate any injuries to his hand?
Yes, so there were some ecchymoses, or you can think of that as like a large kind of bruise on both hands.
What other blunt impact injuries did you identify?
So there was a series of ecchymoses on the left side of the back, which right about here. There were some on the forearms as well.
He nor I.
Well, he's dead as a result
laid
of your
hands
action.
on each other.
He is dead as a result of
I
your
understand
action.
that.
So,
That's why
You two didn't lay hands on each other.
No. No. I don't have anything.
You're right.
He doesn't. Whatever that is, whatever it is.
He does.
See, this is what happens. It's not fair that you guys, just because he has those, automatically blame it on me.
So odds are that loud bang that sounded like something falling down a flight of stairs wasn't you. Although you want this revisionist history and to swap the roles so that you stay the victim. Was he angry at you? Yes, she says meekly, as though she was in any kind of danger. And her answer even says, as he used to tell me, I would make you unrecognizable.
Like he used to tell me he probably would have made me unrecognizable. For threatening to make me unrecognizable to my son by breaking all of the bones in my face, like his brother Moses did to him after he kept seeing all of the bruises from George beating me. Or I would have lost my life.
What happened that night? None of this matters. That's why it's so crazy, all of this superfluous. He used to beat me. He used to do this. Who cares? Honestly, even if it were true, you were not in danger that night whatsoever. You were the danger, which means you deserve to be locked up for the rest of your life.
To life in the Department of Corrections.
And it's when you see things like this, when you see the testimony, when you hear the phone calls, when you see her sentencing statement, when you see the text messages, and at every single point, she downplays his life, manipulates his death, and still claims to be the victim. And yet she actually thought she could convince a jury that she was defending herself from an abuser locked in a suitcase. And truly, that's the reason why the prosecution didn't object, because they're like, whoa, 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 did you hear that? I'll let the jury just sit with that. She said if she had let him out of the suitcase to survive, that she would have lost her life. Ignore the fact that she has a history of fleeing whenever she's afraid of him or whenever she wants to call the police to get him arrested.
Oh, no, you said you guys have been good. What's your definition?
I've been good. I don't think you all understand. He comes at me all the time. He comes at me. So it's either I flee or try to go upstairs and go to sleep.
You're just sleeping in bed.
As I was last time, he doesn't like it when I sleep. I just try to avoid it, so I go to sleep.
That's usually what it is. And I don't know if you talked to Brian about any of that, but most of the time when I flee, I go over there.
Okay.
And then I walked off barefoot.
Okay. And on the phone, you told me that you attacked him as well.
The next thing I know, he's drinking. So it's like, oh man, I know where this is going to go, so I'm going to go upstairs and read a book. Or I'm going to go for a bike ride, or I'm going to do something else. Where I don't want to drink. I don't want to drink. So when you all see my phone, you can see all of the damage he has done to me and the videos of him smashing my television because he's belligerently drunk. Where most of the time, I just don't want to be there.
I didn't attack him.
That's what you told me.
I pulled him off of me.
He said he has marks because I was fighting for my life.
I was being honest with you.
If she had let him out, she would have died. And if you believe that, then that makes it okay. And just like us, Linda calls bull. Unreal insanity. But this is just how hopeless this whole situation was. This 30 seconds to a minute of testimony makes her more guilty than any defense she could have. She flat out said, I know he's in the suitcase. I saw him trying to get out and to survive. I went over and shook his hand inside. I don't know how long I was shaking it, but I'm admitting on the stand under oath, I did that until his hand went back inside. And we saw what happened on the 2 videos that I filmed of what happens when he's completely zipped in there, which again, this is all a lie, right? Because we saw on the videos, there's no room for even those 2 little fingers to poke out. Maybe there was just enough room for him to barely get the fingers out, but then we see marks on his hands too from where she beat him back in. Then she wants to say, oh, I just used the bat and I just poked him through the suitcase. You know, it's okay. Like, I didn't really hurt him. Ignore the autopsy. That just means she must have the strength of She-Hulk if her just pointing and jabbing the bat at the suitcase with a hard back.
You said you poked him with it?
Yes, I kind of pushed, like I held it with the skinny part here and then...
So the grip here.
Prodded at it, yes.
And you thrusted it into the different areas of the suitcase?
I started with his hand, and his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
You hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase. You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules.
It just piled lie after lie after lie after lie. And she's doing the same thing in this family court. No matter how many times she abuses them, she's still the victim. And you're supposed to just take it, or else you're the abuser. What former husband is trying to do is sweep me in a dark, bleak corner and keep me there, hoping I find no way out. But you being talked to poorly and you not getting the money you want means that he's locking you away in a dark, dusty corner, hoping you can never be set free or never let out, which truly is where you need to be. Never set free, ever. And this just proves it. If you can't even see how tone deaf and insulting phrases like that are, because on some level she has to be aware, right? When she says it's an obscure, unfortunate incident, when she says that you are choking my constitutional rights when your murder victim asphyxiated to death, something just is not all there for her. Just crazy. The, quote, relief he is seeking means to remove any additional work, trouble, effort, concern, responsibility, etc. Which I've never put this together before. I've never commented on it. But she's saying, she's trying to downplay his relief, saying he only wants relief, meaning he doesn't want to do the extra work or responsibility or have anything to do because he's just so lazy in this. Are you kidding me right now? You are, and I've said that she's been saying this of he needs to bend over backwards and do absolutely everything you want to make you a fit parent, which is impossible, but to make you as included as possible. And you're downplaying it. You're saying, how dare he want relief from doing all this extra work after I murdered someone? He should feel happy to want to clean up my mess. Which would make former husband be the reliable, caring, consistent, honest person he should be. How especially to our son, and who I always wanted and needed him to be when we were married, possibly altering the current situation for everyone. Oh, okay. So now it's Brian's fault you murdered your boyfriend you cheated on him with. Just more pure insanity to in the letter say the whole situation could have been altered if Brian were a better person. Then we wouldn't have gotten a divorce and I wouldn't be a murderer right now. Now would I? And she says it like that. She says it with a straight face saying it's your fault that I became a murderer. It's your fault that I'm here. If you didn't act the way you acted, if you didn't want to get the divorce, we could have just worked this out and none of this would have happened. That's how you know she really hates George. Little isms like this, and none of this would have happened. I've said this before. George was just a phase for her. She felt trapped after having a kid. She couldn't be that wild child anymore. Her marriage with Brian was falling apart.
And how long would you say the alcoholism has been a part of her life?
I mean, it's always been a part of her life. It seemed to have gotten worse and worse. I think more or less kind of since we had. And I think a lot of it was the fact that she kind of, I guess, maybe felt trapped or something.
Okay.
That, I mean, before that, I mean, whenever she wanted, you're outside having a drink. Oh, I want to go play pool. You go over across the street, you play pool for a little bit.
Yeah.
That's not happening anymore when she got a kid.
Right.
So.
How old's your son?
He is 9. So, but I mean, she started just getting really angry when she drank a lot. She said last night she fell asleep. There were plenty of times where she just basically passed out from drinking. So,
so you've witnessed her pass out from drinking?
Oh yeah.
Okay.
She was a raging alcoholic who refused to acknowledge it until she found someone who was in the throes of the same addiction she was and took advantage of that and wanted to have this whole perfect life. I know so much more than he does. I know him better than he knows himself.
Let me go ahead and explain myself. So I know. Nobody else knows, but I know. Nobody knew George better than I did. I say that I knew George better than himself. And I tried in every way, shape, and form. Ask everyone. I helped him. I took care of him. I miss him a lot, and I didn't even sleep last night.
I'm going to play this little toy. I'm going to control his life. And then when I've had my fun, I'm going to go back and Brian's going to accept me. Because he just needs to realize the prize that he has. And he's going to get so jealous when he sees me with this person and that person. Oh, wait, I killed them. Oh, wait, I called the police on them 5, 9, 16 times. Well, that couldn't be my fault. Must be Brian. Meanwhile, Brian says, I couldn't take it anymore. Her having strangers at our home, her being so reckless with our child, and he divorced you. And truly, she makes comments like this because she doesn't want to admit that he divorced her, not the other way around.
That was part of it. The alcohol has gotten worse and worse and worse over the years. That's one of the main reasons why I divorced her. I just couldn't deal with it. I mean, it got to the point where, on weekdays, she'd go out, and I guess the George person is one of the people she had met. Because I separated at one point and went over to my parents' house to live for a few months. And I guess she met him over at the pool place or something like that. But I'd come back when we were in therapy trying to work it out. And on a weeknight when he's got school the next day, I've got work the next day, she was out till 3 o'clock in the morning when the bar closes, and she'd bring people back over on the back porch. One time some random person walked in my house and started screaming for Sarah at 3:30, 4 o'clock in the morning when we're trying to sleep. I just couldn't get over it.
If I have no authority, power, or control, there are no discussions or interactions of concerns, ideas, plans, future our son does and will need involving both parents. Me, the other parent included. Not only am I continuously disrespected, I am verbally threatened with some form of this looming lawsuit. In former, quote, husband's original verbal threat made sometime last year, early 2021, to take away my parental rights and funds necessary for my, quote, livelihood while incarcerated, after my sincere, heartfelt begging while sobbing to him while on the phone in the middle of my dorm, I was made to cry over a cheeseburger when explaining to him the amount of weight I am continuously losing weekly due to being sick, and thought this would help me gain by eating. I was still told no. In my desperation, asked, why was he doing this to me?
Why is this happening?
Because George is dead.
Now, she has such a weird relationship with threats where she doesn't believe them. She thinks everything is a threat. Oh, you're threatening. How dare you threaten me to hang up? And then they hang up on her. Thank you for your time earlier. I didn't appreciate the threat of being hung up on, told to shut up, and I do nothing for my son.
Hello? It's me again. Take it easy.
How dare you judges threaten me? That's exactly what she did. The judges warned her time after time, if you keep this behavior up, you will lose your lawyers.
But one thing I want to caution you about, if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. You have a right to a court-appointed lawyer. There are certain decisions a defendant gets to make in the defense of their case that are absolutely theirs, such as whether they go to trial or not, such as whether they testify or not. But there are many decisions in a case that a lawyer gets to make. And while you certainly have a right to consult with your lawyer and discuss with your lawyer, they don't automatically just do whatever you say. They use their professional judgment and experience and look at the evidence, look at the law, and do the best they can. I have concerns that your expectations of what any court-appointed counsel might do as far as spending time with you and the depth and degree of communication may be unrealistic expectations. You always have the right to retain a lawyer to represent you, and then that's between you and that lawyer. You can demand whatever expectations that you have as part of that agreement. But when it's a court-appointed lawyer, you have to accept and understand that they have other cases, other courtrooms, other responsibilities, And I'm cognizant of that when I'm addressing these types of issues about communication. So that's just food for thought, nothing to do today. I don't need a response from you. And I just wanted to make sure you were aware of that and were thinking about that as we proceeded forward. Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Court sentences you to life in the Department of Corrections.
Thank you, Judge. All right.
I'm not able to say anything.
And she did it again and again and again, thinking she's untouchable and can do anything that she wants, and that because it's her Sixth Amendment right, you have to keep giving her lawyers.
To accept its subpar, nonchalant, hypocritical, next on the list attorneys they keep aimlessly throwing darts for, malappointing, praying they don't withdraw. I have not fired any attorneys appointed in my case. For me expecting the highest equal standards possible, for wanting the absolute best outcome in my preposterous, mismanaged case, and representing myself is not an option, as both judges have now threatened me with, from being outspoken and intelligent in all my observations of the ongoing abuse I am and have experienced.
And then when they finally took that away, she tells Lana, I have no idea this was going to happen. I didn't know this was a threat. No one made me understand that this was going to happen. I thought this was just a threat of something that would happen. And then you actually do it?
I was never made to understand as a threat, not just lip service, that Cashman was my last attorney. My plan is not to go through attorneys. My understanding was it was general context. This is not a strategy of mine. They are accusing me of.
Because it makes it sound like, to me, like I'm being accused of something that was not intentional. I'm being accused of it. Mm-hmm. And a handful of other things that I'm being accused of. Okay.
Yeah. Even though these aren't threats, they're warnings, you take them as threats, and you still don't believe they'll happen.
As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel.
I did not forfeit my right. That was your judgment.
Waived by your conduct the right to court-appointed counsel.
And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. I don't want to be pro se any longer, so I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period.
Same thing with this quote-unquote looming lawsuit. He probably told you so many times, if you keep begging for money, if you keep harassing us, if you keep abusing our son with your vengeful, selfish words, I will take your parental rights away. I will get rid of your alimony. Or you can sit there and take what I give you when I give it to you, and you do it with a effing smile, not like you're entitled to it. And she said, I don't have to talk to you. How dare you threaten me? Okay, fine, we're going to court. What? I was begging and crying over the phone in front of my dorm. Why is he doing this to me? It's not that you just threatened me and warned me time and time again that my behaviors would have consequences, and then I kept doing the said behaviors. What? That's literally how she sounds, though. It's crazy. Fully and completely knowing I have nothing or no one, and how meaningful it is to me to be called son's mother. His response was simply, quote, it will make you say yes now. If you keep doing as you have been, everything will be fine. I have been saying yes, as I had no choice if I'm even asked anything to be able to answer. I am unclear, as usual, when dealing with former husband, of his behavior with these new
revised threats and demands that I have not already submitted to previously, seen, or even knew existed until now being served. I will not be erased or downgraded to nothing because former husband is bored and bitter. Totally unfair, and the cruel ego trip is disgusting and nothing to be proud of. What is the point? There is nothing left other than my dignity, which he'll never have. What would our son say? How would he feel knowing the truth? Please know, I do still have numerous other legitimate concerns needing to be addressed in the petition, and personally, and should be by any decent parent respondent. This is not a one-sided attack and await the opportunity to clarify my specifics if when needed. I, the mother to our son, believe said concerns are very important. I've realized also this quote lawsuit may be my only opportunity due to my restricted resources to have them handled and hopefully remedied professionally, positively, and fairly. I am praying I can be heard, seen, and included by this letter in the ongoing proceedings, meetings, discussions, etc., futuristically. I am hoping also to have some type of representation to amicably bring this matter to a concrete conclusion, being beneficial to everyone. A copy of this letter is also being sent to legal aid. You sent this letter to to legal aid for review and assistance. Wow. No wonder they said no. Dear Miss Boone, we have reviewed your letter requesting legal assistance. This letter is to inform you that the Legal Aid Society of the Orange County Bar Association, Incorporated, will not be able to assist you regarding family law matters.
Bon appetit!
Our office receives hundreds of requests each month for free legal assistance. While we would like to help as many applicants as possible, due to limited staff and other resources, we are unable to assist everyone who contacts us. As a result, we have established case acceptance priorities to address the most pressing needs of our client community, and thus we do not accept matters that involve alimony or custody, time sharing on behalf of a parent who does not have the child residing with them for at least 50% of the time.
Okay. This is in regard to the exercising of overnight, where he stated that it was 30% about for my average. Can you please explain to the court my conversations on more than one occasion of why I would not have 100% or 50% of my time?
In the meantime, I am still, quote, mom, with my, quote, mom rights. The level of this, quote, lawsuit is unfair, unnecessary, and uncalled for. This lawsuit is also from one monotone side of former husband. I, the former wife, have a side also, intellectual, willful, and valuable, deserving to be heard. I am also fully dedicated and devoted to my son and his rights. His uninfluenced feedback should be included, and it is only fair to him to know the extent of the situation and the cruel attempts of his father to his mother. No one can tell the future or assume to. I was unaware former husband had a crystal ball. I have faith and will always, this being something no one can take from me ever. No one either is better than anyone in this or ever. And money can't buy everything, especially love, grace, understanding, and goodness. If former husband is willing to have a rational, reasonable discussion, however mediated, I am more than willing and welcome. If there is anything else I can do to show my very good intentions other than writing this letter expressing my desperation to continue to be included in my son's life, my understanding of the emergent need of counsel and sheer hope of a resolution, I am also willing to submit to a competency test or any kind of test to show my capabilities mentally and full ability to co-parent. I am not the ridiculous, ruthless, degenerate felon former husband slanderously assumes I am.
We, the jury, find the defendant guilty of murder in the second degree.
Life in the Department of Corrections.
I love my son immeasurably and have a limitless abundance of positive, meaningful, solid, contributing life characteristics to share and have my son inherent from me. If you are choosing not to talk to me, I wish you'd just man up and tell me so I can stop looking like the fool you are making me out to be by calling just to be yelled at, called names, or hung up on, which is priceless. I can co-parent. I want to co-parent, especially if former husband is going to positively participate and understand rather than pillage and point fingers. A mother is her son's first love, in which I very much and with every fiber of my being want to still be. Thank you for your time in reviewing my formal written response in part of the petition. I am grateful for your understanding and hearing my side also, which is only fair and right to do. This is between both parents. I await your response and instruction. Please do not hesitate to let me know if anything further in my ongoing unreserved cooperation is needed. I am still in this, still a person whom former husband was married to for 13 years and has known for more than 20. Most of all, I am still the mother of our son and still important in anything, everything pertaining to him, come what may. Sincerely, Sarah Boone.
This was just me trying to be transparent with the petitioner's counsel and describing to them my need and want to be in my son's life back in 2022. Explaining my dedication and my decisions and ideas and opinions, they matter. One spirit enforcement incident does not define me as a person or my entire existence. And I'm trying to be my son's best advocate for myself.
And I'm trying to be my son's best advocate for myself.
And that's her swinging straight out the gate to all of this. First, straight off the bat, she calls it a lawsuit. No trying to compromise, no trying to see the modification. She took it from 0 to 1,000. Didn't answer a single question on there. All feelings, all emotions, all insults, all deflection of blame. And yet she is shocked that this is how things ended. So just imagine when you're a judge and this is the first thing you read from the respondent, her first correspondence. This is her voice. Normally you have a lawyer who will just respond to the actual modification properly and you just move forward. But no, this is her giving her raw, honest emotions, and it sounds like this. How can you believe anything she says moving forward?
Generally denying all of the petitioner's requests for modification rather than responding to each paragraph and the modification petition. A. Substantial change in circumstances. 8. It is undisputed that respondent has been incarcerated since February 25th, 2020. Subsequent to the filing of the modification petition, respondent was convicted of second-degree murder.
Jury seat number 3, is this your choice?
Yes, it is.
Verdict?
And she was sentenced to life in prison.
To life in the Department of Corrections with credit time served.
9. It is also undisputed that since respondent's incarceration in February 2020, respondent has not exercised any regular time sharing. See Florida statute, quote, a parent's failure to regularly exercise the time-sharing schedule set forth in the parenting plan, shall be deemed a substantial change of circumstances for purposes of modifying the child support award. Emphasis added.
And that should be the most blah thing ever. If you're in prison and you can't raise your child, you shouldn't be getting child support. Same thing goes for custody and visitation and time sharing. I can't believe how many times during the trial she kept trying to say, Brian is violating the parenting plan, he's not doing this, he's not doing that, until Your Honorable Judge Jackson had it, and she just became a lawyer and decided to cross-examine her on the stand right then and there.
For also the parenting plan, which is still active, the original from 2018, I believe, I wanted to bring to the court's attention that it's been violated by the petitioner. Again, from previously, now I believe it's a time where it says the parenting plan may be modified or verified on a temporary basis when both parents agree in writing.
All right, Ms. Boone, Ms. Boone, you have to agree that there's a lot that's not being followed with regard to that parenting plan, which includes even the time sharing that you're not able to do at this time.
Right.
You would agree with that, correct?
I understand that, but that is my only stipulation. That's my only part that
All right, you would also agree that that parenting plan was entered into back in 2018 prior to there being any criminal charges in your incarceration. Do you agree with that?
I do, Your Honor. But
okay, and you have to also agree that when the parenting plan was entered into, if I remember correctly, you all agreed to the parenting plan as part of your mediated settlement agreement back in 2018, and at that time, neither one of you were contemplating any type of criminal charges or incarceration. Is that correct?
Hands behind your back. For what? For battery domestic. Me? Both of you. You two hitting each other. This is for real? This is for real. Why am I in trouble though? Because of the marks he has all on his neck and the inconsistencies of the story.
Back. Why? Because I fucking fought back?
So the domestic violence, the original, was dropped. I was never charged with that.
You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate.
So please, if you can,
Dismiss
this case.
Closed.
Drop it.
So they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing? Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information.
She is not that type of person.
Good person.
She's a great person.
Angel. Best thing that has ever happened to you.
Yes, ma'am.
Yes, Your Honor.
Okay. All right, you may continue.
And called out the contradiction of you keep bringing this up when in fact you are the biggest violator of all of this. And she tried to warp it again because in her mind, the law needs to work the way she thinks it should work, and if it doesn't, then it's wrong. So because she's in prison, that shouldn't matter for time sharing. It should only be whether I can communicate with him or not. And she pulled that up on some case law saying that incarceration has nothing to do with parenting and that it should only be in the best interest of the child and if I don't have ability to communicate.
So I would like to bring in the part of the divorce certificate, which includes each parent and everything they're supposed to abide by regarding being appropriate to the other parent. Regardless of incarceration or not. That's what I was trying to say. I've been excluded this entire time, and everyone has blamed my incarceration on it, which it shouldn't be like that because I'm still the mother of my son regardless of where I am.
Which isn't an argument at all, right? She's literally just saying, I know everyone's blaming it on this violent incarceration and life prison for a violent second-degree homicide. However, I'm still a mom, so we shouldn't even be questioning any of this. It's like she didn't even try. If it were really this easy to talk around the legal system, no one would be in jail. No one would have anything taken away from them because they could just say, I'm a parent, so I win. Nar.
And what petitioner has been saying and doing and not doing are unacceptable and to a certain extent unlawful, especially with the active parenting plan. It shouldn't be done anyway, with trying to hinder my relationship with my son. There's no reason for him to do that.
So now it does matter if something is unlawful, but not if something is unlawful that you did. Got it.
In regards to children and the parenting plan, Hunter versus Hunter, the court ruled that incarceration in and of itself is insufficient to terminate or deny custodial rights unless continued contact is shown harmful or detrimental to the child.
I'm not going to be dehumanized by you any longer. It's a choice. You blank gifts whenever your father decides to
Send me money, send me money, send me money.
order. It's the middle of February, blank, and I have no resources, family, or money.
Money.
You have all and do nothing blank this year. Make a video visit telling me you were going to your blank in any way. And after last year lying about making me a card for the blank, father won't even let me have a hot meal ever and keeps lying he blank to want to be a weatherman when you were younger. Here's your chance, blank, about by you. Know that. You're the one in charge.
Also for that case law, the courts have discretion to restrict visitation only to protect the child. The petitioner penalizes the respondent for her incarceration. Also, it reinforces that inability to communicate, not incarceration, is the key benchmark for limiting shared parenting. I have multiple ways of trying to communicate with my son, and I've been trying every single one and trying to share parenting as best as I possibly can while located here.
And you don't. If Brian is the one who has to facilitate this 100%, then you do not have a way to communicate with him regularly, even if we were going down your own logic train. So it's absolutely ridiculous that this went on for years when, because of her actions, things must change. It's impossible to keep the current parenting plan without any kind of modification. Brian didn't have to submit a modification petition, but then they both would be in violation of it just forever. And if she had decided to mediate, worked with them during the mediation process, actually came together with trying to compromise in any way, they could have taken all this emotional language and all her feelings and filtered it in some way, and she could get some things that she wants. But because she kept pushing, me, they said, fine, let's take this to court, where you actually have to battle it out legally and not just off of emotions. And now we're seeing how that turns out.
10. In anticipation of the entry of the original final judgment, Respondent made financial disclosures averring that she was receiving unemployment benefits and in search of a job, and she alleged $5,293.83 in monthly expenses, leaving her with a financial deficit of $4,521. See Marital Settlement Agreement at page 5 and Respondent's Financial Affidavit, 2018 Financial Affidavit, filed on May 9th, 2018, and blah.
Wait, she pulled this tactic twice? So while waiting for the final judgment of her original divorce proceedings to be entered, she decided she was going to send a financial affidavit claiming unemployment, all these needs. She has $5,000 monthly income. Again, just like on this financial affidavit, she just lied her ass off. How do you have no job, living solely off of Brian, in search of jobs? I'm guessing you have a new place now, and you're about to get $1,100 and live off of that $1,100 for years without getting employment. But you submit a financial affidavit saying you have monthly expenses of $5,000. That's just a mess. Like, she's just overinflating everything, just like she did here, and trying to get the $1,000 a month. And so I'm just going to inflate all of my expenses so that the judge will give me more, give me more, give me more.
Send me money, send me money, send me money. How can I send you money when I don't have a job? Don't have a job.
Don't have a job.
And does she or George have a job?
No. She hasn't worked for over 2 years. I mean, my alimony and stuff basically pays for where they live. So, I mean, they didn't need a ton, but, I mean, she was always calling to borrow money. And it's been like 2 years since she got a job. She keeps on telling me she's looking, and she's always finding the good opportunities and everything.
Because I was supposed to have my son today to pick him up from school. Brian usually calls to make sure, hey, are you sure you're getting today? Because I've had job interviews.
And judges can see right through that. So while she said, I have a deficit of $4,000, and if she's saying that while the judgment is still being put into effect, I'm using the word in anticipation, that doesn't sound like she submitted it with the regular evidence that was originally submitted when Brian submitted his and when everyone submitted theirs. It could be, I'm just reading into that word a lot, but in anticipation sounds exactly like what she just did that we looked at the beginning of this video.
And respectfully submits her notice of information for the honorable court's consideration while this family law matter remains open and pending final judgment since the trial held on August 25th, 2025.
In anticipation of this final judgment, she was going to write the judge anyway. She had more things to say that she hopes you will consider. I hope you consider Brian's bad attitude so that you give me more money.
Send me money, send me money, send me money.
I hope you will consider how poor I was so you will give me more money.
Send me money, send me money, send me money.
She always has to have the last word. Incorrect word.
11. Undoubtedly, neither party contemplated respondent's arrest and incarceration when their marital settlement agreement was entered and their parenting plan was agreed upon. 12. The court finds that, at best, respondent's reasonable monthly expenses since incarceration total $145.
Damn, double homicide.
Bitch.
No, I'm sorry.
Damn. Now, I know that was a gut punch to her when she sees, at best, her monthly expenses are $145. After she took all the time to inflate that financial affidavit, I need $250 for food, I need $50 for clothes, I need $200 for communication. She said at best $145 in total for everything. I'm just imagining her reading that for the first time and she's just shaking at how angry she is. And Ms. Jackson is right, at best, meaning $145 is still an overshoot of her actual monthly expenses, seeing how she's broke, she gets everything for free, housing, food, water, shelter, all of it. She just doesn't like it, and that's fine. George didn't like the coffin you put him in, so you can accept your little cage with 3 square meals. Exactly, and Linda agrees. You do not need $145 a month. Linda does, especially after these gas prices skyrocket. She needs more than that just to fuel up for one trip. But Sarah Catherine Boone Paulsen...
There was a clown!
Excuse me. You're eating my peach.
Not you. You can choke.
See respondent's financial affidavit filed on May 30th, 2025 at page 8 with 2. What is the 2? The second footnote. This amount includes $16.67 for clothing based on respondent's admission on cross-examination that the $50 clothing expense is charged quarterly.
And a lot of these, if you see at the bottom, it states estimated for all. The clothing is charged quarterly. It's not every month. And there's limited quantities, and also the prices fluctuate, which is why I included those as my exhibit so you all would understand the most current pricing.
$15 for medical dental expenses,
$70 for hygiene and writing items based on respondent's testimony that the prison does not pay for basic hygiene items like all-in-one shampoo, body wash, toothbrushes, and toothpaste. And $43.33 based on the testimony of a $5 cost for a 30-minute call and allocating 2 calls per week. The court does not find credible respondent's testimony that she needs $250 per month for snacks because her stomach not handling meals, quote, properly. She admitted on cross-examination that the prison provides free breakfast, lunch, and dinner.
The facility that you're incarcerated in, does it provide you meals for free?
It does.
Okay. Does it provide you breakfast, lunch, and dinner for free?
Yes.
Does it provide you any other meal times other than those 3 times for free? Snack times or anything like that?
No.
Okay. Does it provide you things to drink for free?
Water, yes.
Okay.
She provided no competent, substantial evidence of any medical issues resulting in, quote, low blood sugar that would necessitate the need for snacks between her free meals. Oh, Miss Jackson, I was unfamiliar with your game. I love that because I thought that this so far read very professional, very tame in terms of how she's framing things, but I see how she operates now. She's letting her real opinions known in these footnotes, just assuming Sarah probably doesn't even know what a footnote is. So she's keeping it really professional in the standard order, but then in the footnotes is where she shows her real opinions. And she straight up said, I do not find credible the inmate's recount that you need $250 for food every month when breakfast, lunch, and dinner are provided for free. And she's never had any evidence ever. Her only evidence is my grandpa's dead. My grandpa died of diabetes, which means me 2 generations later. She has been in prison for 5 years, 6 years, and she has gone to the doctor's office again and again and again. She's had surgeries, and none of those doctor consultations, none of those surgeries, which they have to do blood work and have to do preparation before surgery, no one told you that you had blood sugar, diabetes, glucose concerns, any of this. Those would have to be factored into your other medical issues and procedures that get done. But she just keeps running with that lie because she wants her snacks. And we've talked about it before, but a lot of times addicts, alcoholics, people with substance abuse issues, when they go to prison, when they don't have those substances, they switch over to sweets and sugar because sugar is also a drug. So it is the next available substance. So she needs this because she was also had an alcohol abuse disorder. So she needs this sugar like she needed that drink.
Well, I don't want to drink. I don't want to drink. The occasional wine, whatever, or if it's a weekend, that's when you have a good time. You don't have to wake up the next day.
That's the only reason she's fighting so hard. She hasn't even asked for any other kind of snacks. Like, she doesn't say, I need this for, I mean, this is also annoying. And some people who don't really have disorders, but just see the quote unquote good side of the disorder and want to harp on that. I have blood sugar issues, which means I need sugar, sweets, and snacks anytime that I want. I had a student who faked having POTS one year and then decided, oh, because POTS, you need salt. And we used to carry little salt packets on us. Because you need a lot of salt intake, that means sometimes we would get one of our actual with POTS French fries and something salty to quickly counterbalance that. So once decided that they were going to fake it so that people would have to go get them French fries and salty junk food and give them attention and yada, yada, yada. Fun fact, that all runs out because disabilities actually have purposes behind their treatments. And when it doesn't actually affect you, it becomes obvious. She has never had these medical snacks from a technical standpoint, as in someone has consistently provided her with the ability to have these snacks, and she's been just fine. She wants to say in these messages and in these phone calls, oh, I feel so weak. I feel so faint. I had to hold the guardrail because of my blood sugar. Oh, da 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 da. And the doctors look at her and say, if you don't take this aspirin and get out of my face. And that's why I love Mr. Owens when she forced him to ask Judge Kranick, can I have some snacks because I'm getting tired doing my murder trial.
Judge, my client tells me that they wake her up at 2:30 in the morning, and then she's kept in a holding cell until she's brought to court here at 6:30 in the morning, and then of course she's brought up around 9, and then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stop allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one. She's asking that, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart to allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch. But she's not diagnosed with any kind of blood sugar.
She's not diagnosed with any kind of blood sugar.
But she says she gets, like today, she's feeling tired and lethargic, and so she feels like those items during a break, that she could have something like that to keep her energy level. I'm asking for the court's permission that she be allowed to do that.
This woman is on trial accused of committing a murder, and she's concerned about her snacks. Snacks.
Snacks.
I, the murderer and suspect in question, need to keep my energy up. Not realizing she is the least important character in her whole trial. Yeah, it's good that she's there. Yeah, it's good that she has the opportunity to testify. Other than that, her participation is not needed for any part of the process. That's why in the Daryl Brooks trial, when he kept causing a fuss, they just moved him into another courtroom. All you have to do is have access to the court. All you need to be able to do is to see them, answer a few questions, give me a head nod, thumbs up, thumbs down, let's keep it moving. But because she thinks she is so important, naturally she needs these medical snacks. Nothing to back it up, just words, just vibes. And Judge Jackson said, no, you're going to have to do a little more to prove $250.
I'm not playing with you. You are going to have to give me something substantial.
So when you indicate here that you have an estimated food expense as of May of 2025 of $250, what is that for?
That is for my low blood sugar, which the petitioner is aware that I have ongoing, and need to maintain my blood sugar. My grandfather died of diabetes, and I have to maintain that with snacks and in between meals. Some of the meals are, of course, unappetizing, and my stomach is not able to handle them properly, so I either do without or would fall back on something that I could order or purchase from Canteen.
So if I understand you correctly, this food expense is not for breakfast, lunch, or dinner. It is for supplemental food that you believe is appropriate due to your blood sugar. Is that accurate?
Yes, and also in regards to the meals not being able to be digested properly.
Okay. Okay.
Primarily for medical reasons.
And through the phone calls, I don't know if I've actually covered this call or not, but I'm just going to jump around them. In one of the phone calls, she admits, oh, I was talking with these other girls and they said that I needed to make my financial affidavit as though I was getting the $1,000 a month and how to divide that for my monthly expenses if I were to get that money.
So I'm not sure what's in the spreadsheet, but I think what you want to show is like...
All I'm putting are dollar signs. Like for under household, I can actually put food,
and it's $400 a month. $400 a month. I went next door. They encouraged me to go next door, write down a 7-day menu of items that you think that you need to eat in regards to your low blood sugar and a normal meal, because they serve greasy food here, which upsets my stomach, which is what I take Protonics for, an actual medication, and then calculated everything for me. So that's what I'm trying to put with just food.
Which the irony here is she never even brought up this Protonics. Like, that's her only medication that she's taking for food, and she never mentions it. Why? Because that is used to treat acid reflux and gastrointestinal issues, not low blood sugar issues, which I wish someone would tell her already, that constantly demanding sugar cookies, all these sugary sweets, does not treat low blood sugar. That is a very quick remedy. What is it? The 15-15 rule, 15 grams of sugar, check back in 15 minutes to see if things have gotten better. It is a quick short-term fix with a quick short-term crash afterwards. Treating low blood sugar requires a balanced diet regularly, which you definitely probably can't get at a prison easily. That's understandable, but the things she requests are not the things that would actually help her. And we've seen that even in the things she wants. She wants these hot meals. The hot meals are the pizza and wings, the burger and wings, the tenders and nachos.
Oh, okay. So really quick before I forget. Please, if anything, may I have one hot meal? May I have a hot meal in between of all the visitation? You don't have to be an approved visitor, but you have to go and you have to order it.
Okay.
I just found out the other day from the girl because I was upset, and she's like, "Are you okay?" And I was like, "No, I feel really bad." And then she's like, "You know, you can get a hot meal in between of everything." And then she explained it to me, but you have to go on and do it.
Okay.
And if I may, please.
Phone call confirmation, commissary, soap for son, hymnal, keep it kosher food pack, pizza and wings hot meal. And I still have nothing, anything I need or want. Books, food, stamps, socks, etc. Delicious delights. My solution to not having commissary. Blank, purchase this food package I've been asking about for well over a year. Have you ordered the Delicious Delights? Blank, one-time purchase, and before it's no longer available? You keep telling Blank even looked up for me online but didn't order back in December after Blank was going to receive for my birthday in October. You told me you ordered Blank, became no longer available. No hot meal again. Why do you keep lying? For months, Blank, October. They have no order in my name. Why do you keep Blank asking you and the vendor in front of everyone for the Blank order? You are such a despicable, lying, sad person. No Blank. Keep lying. Hot meals times 2. Why didn't you order, Brian? They just came without calling my name. And because you will not give me confirmation numbers to ask the rep, I again have nothing for New Year's nor for Christmas. Even after asking over and over and over and over, starting December 6th, today is the 27th, and you couldn't find 5 minutes to order? But keep telling me you would and were going to? Are your holidays complete and even merrier knowing you did nothing so I could have nothing again? Why are you continuously lying to me about everything? Lying about everything. It's just a hot meal that you permit me to have only about 2 times a year, not even for Christmas, but kept telling me you would and were going to. How many more times did you want me to ask? Not even a hot meal for Christmas. Thank you, Brian. Oh, woe is me. Get the F over it.
He's saying, Sarah, Sarah, Sarah. I can't breathe. George has done that in the past before, too, where it's just like he thinks that he's woe is me kind of thing, where it's like, I don't
He's never been locked in a suitcase. That's where he couldn't get out. So
it's kind of, I thought it was
And
the
you know
voice
the oxygen
calling
is
wolf,
something.
crying wolf kind of thing.
Okay.
And again, my plan.
Big fatty foods that would actually work against you and would only increase the reason why you need to take Protonics. And even then, we see what her priorities are when her brother Philip finally bought her a food package after she's been begging and complaining, I'm so hungry, I need food, I need this. So as a good brother, he decides to get her a protein food package, something that would literally help her low blood sugar, her protonics, gastrointestinal issues, like all of it, acid reflux, that would be the safer choice than what she always wants, which is delicious delights. She wants her sweets. So what happens when she finally gets the nice protein things that would be good for her actual health? She tells him, I don't want it. I turned it back in. I'm not going to eat any of that, so I already sent it back. Can you get delicious delights instead? 3/8/24, 1:18 p.m. To brother. Hi. Oh, wow. Thank you, Philip. I received your packages today. So blank. Thank you, thank you, thank you, thank you, thank you. Blank mouth at all. I returned the protein pack. What? I returned the protein pack. I won't eat 90% of it. Seafood blank, keep fresh scares me. One girl got sick from not sealing properly. And blank, please may I swap for delicious delights? Oh my God. You are the worst human alive. You finally get your effing packages you've been begging for anyone to send you a package just so you can feel cared about, and people do this, that, da, 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 da. Oh my gosh, I got surprise packages from you. Thank you, Philip. Thank you. I returned this protein pack because I'm not going to eat 90% of this fucking disgusting, nasty seafood bullshit. Can you please swap it for delicious delights? You know, you're probably telling him you have no food, that you're losing all this weight, that you're not getting any nutrition. And he's like, let me get something that has good protein so that you can actually be healthy. You say, no, I want delicious delights. I'm Edmund from The Lion, the Witch, and the Wardrobe, and I want my Turkish delights. I want my delicious delights, and I will sell out my whole family to get them. So take this little protein bull back. Like, you're so, like, at least just keep it. Don't say, I returned the protein pack. It would even be one thing if you said, I'm going to return it because I don't think I will eat 90% of it, but thank you. Nope, doesn't even matter. I got your packages. Oh yeah, I already returned it. So please swap it for the delicious delights. The refund for the blank should show up in the next few days. When it does, please order the blank. One of the other girls got it and it's great. It has a little bit of everything. I blank, as you can order, I have a better chance of receiving. Please, thank you, blank. You received my message, so I know what's happening next week. Blank you this weekend, but I know it's a game of tag, so I'm sending this blank for you this way. I just want to make sure you know I returned the blank for the refund. I believe the prices are the same, so it's an even swap. Blank are priceless. I look forward to talking to you. Miss you a lot, Philip. Blank you for caring about me. I love you, brother. Thank you forever. Philip, it is never enough. You put in $100 and get her 2 packages. She doesn't even say she's happy with the other package. I would say, oh, thank you. This one package was so good, so delicious. These are my favorites. Although I think, or I might return this protein pack because it doesn't really fit for me. I would really love Delicious Delights. It's the one I really liked, and everyone here seems to like it. So can we please do that? No, I returned it. Thank you for the packages. This other girl got what I want, so I want it.
Okay.
And if I may, please, mini burgers. The burgers are usually uncooked, and I don't like them. At least from county. I haven't had that one here yet.
Refuses the occasional hot meal on a Sunday.
She's not a Christian!
She could be a Jew.
I was made to cry over a cheeseburger when explaining to him the amount of weight I am continuously losing weekly due to being sick. And thought this would help me gain by eating. I was still told no.
No problem. No burgers. I wrote it down. I promise.
Please don't. The girl that I saw one time, she got the nachos and the chicken tenders, and it was freaking gigantic. So I can eat off of that for maybe like a day and a half. Like, save some of the chicken tenders in a Ziploc bag and eat off of it for a day or two.
Okay, so you want chicken tenders, nachos.
Yeah, it comes together. It comes together. I don't have any other information. I don't know how much. I don't know anything about this. I don't know anything about this.
absolute insanity. So the judge saw right through that, and the judge brings up that it was $250, and I think she did end up changing it on her final financial affidavit to food being $250, but she originally was going to ask for $400 a month for food on top of her free meals. A little bit of a quiet one for Linda, but I get the gist. These numbers don't add up.
They're going to want to know, why are you spending $400 on just food? And all of these are estimates, because it says that you can estimate anything on there.
Okay, so
Not what her actual monthly expenses are. So that's why you have $50 for clothing, $250 for food, $400 for communication. None of these numbers made sense, and the judge is saying, sit down. But it is funny that out of all these estimates, the only estimate she gave her full credit on was the medical. She said, I need $15 in medical every single month, and she said, okay, cool, there you go. You would think with all the cancer and diabetes, it would be a little more than that, but that was the actual only realistic number that came out of her mouth that entire trial. But she did get $70 for hygiene and writing items, because she would complain in past letters of, I need deodorant that works, and I need this, and I need that. And that she had to use her bunkmate's deodorant next to her, and now she's being accused of using it all, and now I have nothing to use.
I can't concentrate on this motion that I'm writing and everything. I'm a nonstop dumb bitch. And then, like, everybody turns around and looks, and there's 81 other girls that turn around and look, and they're like, and then they laugh and clap and fist bump and chest bump and all this other stuff when somebody's mean to me. So it's a group effort. I can't ask my neighbor anymore for her deodorant because she's running out of it, and I'm being claimed that I use it all. So now I really officially have no deodorant. So what I did today was I used a bar of soap, and I just rubbed it under my armpits really good when it was wet.
Jesus.
Still disgusting that you're using somewhat stranger's armpit deodorant, but now you have $70 a month to get what you need. And if you spend $50 on stamps, paper, pens, just so you can complain to the world, that's on you. You're not getting more money than that. But then got $43 for communication for the $5 for 30-minute calls, but she allocated twice a week for calls. So even though the order says that she's only going to be forced to have one phone call, this is saying that we're going to allot money in case you have two. So that's nice on that end. You know, she's used to having 5, 7, a million ones, so she's going to flip out. But that allocation is more than fair. And the thing is, she didn't get anything for snacks. She could have probably gotten some actual money if she didn't put $250. Even if she put $50 for additional food throughout the month. That is $10 per week, so I can get a few snacks to hold me over from week to week. She could have made a very reasonable argument for something like that. But no, she has to go above and beyond $250, all or none, and when she gets none, she's shocked, befuddled, flabbergasted, and insulted. But one thing I will kind of push back on Judge Jackson on is when she says that Sarah testified that the prison doesn't provide hygiene items, including the 72-in-1 bath, body, hair, attitude adjustment shampoo. So she got caught in it when Mr. Martell was like, those would be hygiene items, right? And she's like, yeah, they don't provide any hygiene items. The prison only provides hygiene item, hygiene item, hygiene item, hygiene item.
Does the court provide, or does the prison provide you with basic hygiene items?
No. The prison only supplies I believe, 1.5 ounce all-in-one shampoo and body wash, toothbrush, and toothpaste.
Okay, those would be considered hygiene items, correct?
Yes.
Okay.
And even though those statements conflict, Judge Jackson is putting them together when she's saying they provide no hygiene items, such as all the hygiene items they provide. So here, you can have $70. Further, Respondent did not identify to which creditors she was making payments, and she denied owing the Department of Corrections $50. While mother listed a, quote, gifts expense, the court found credible father's testimony that he purchases most gifts for the child on behalf of mother, and both parties acknowledged that father pays for all costs between mother and the child.
I want to be clear, though. Every expense related to you communicating with your son since you've been incarcerated, Mr. Boone has paid for that. Is that correct?
It's my only form of ability
Ma'am,
right now.
answer
Yes.
the question. Has what your communications with the child been paid for by Mr. Boone since you've been incarcerated?
Yes.
Okay.
Next question.
Which has always been insane to me. Like, I don't think she gets, that's not normal. It's not normal for your divorced partner to pay for all of your communication and all of your gifts to your child. Everything she's ever done for her child, she has begged other people to help her do. I remember in the phone calls that I still haven't gotten to, there's this whole Easter present saga where she's begging people to get her son a record. And New York and Julian said they're not going to buy it for him because it's an explicit record and he is a minor. And she threw a whole fit about it.
Have I ever purchased a gift or something for?
With your own money?
Have I purchased any items for our son?
Well, I purchased them.
Your Honor, I need
Hold up, stop.
I need some scope of what time period she's talking about.
All right, I'm going to sustain the objection. Re-ask your question, and you need to put a specific time period in your question.
Within the last month, what have I purchased for our son?
You had somebody third party else, not you, buy him a record for his vinyl player.
Have I purchased previous items for him?
You have had a third party, not your money, not you, purchase some things for him. Yes.
Okay. Said that she sent you the Easter presents for. Have you had a moment, or Julian, or anybody, to figure out what's going on with those? Because he keeps asking me.
Okay, so I'm not sure where any of that stands. I know that Julian had ordered those things and like spent $40 on it. I don't know whether he got the money back.
He did. Got it refunded. And I thought it was you or he that said, send me whatever it is. I think it was you that said, just send me whatever it is. And so I think I sent it 2 or 3 times.
Okay.
Both you guys.
Okay, now you're jogging my memory. There was a piece of music that you wanted him to send.
A vinyl.
When he tries to buy it, it says like explicit lyrics, and the person that's receiving it has to be over a certain age. And he's like, this isn't my kid. I'm not sending this. And I understand why. He doesn't want to be sending a 14-year-old kid something that has an NC-17 rating on it, because that's just going to come back and bite him. And bite you, frankly.
No, it's not. Brian knows that I'm getting it for him because he was originally going to, but said, no, let Mom do it. He'd rather have it from me.
Regardless, if you want, if Brian wants to get it for him, have him get it. I'll try and figure out a way to get him the $40 or whatever. But Julian's not comfortable sending it, and I'm not either. I'm not going to send something that says explicit lyrics to a kid that's not mine, that's 14 years old. It's not going to happen.
Okay. And I'm just confused because one moment it's like, sure, Sarah, no problem. Here, you can get whatever you need or whatever you want. And then now it's just like unavailability. And it's just, we try to do what you tell us to do, and which is what I did with the direct links. And it's just, I'm just really confused of what I'm supposed to do and how I'm supposed to do it and when I'm supposed to do it.
So you've been talking about the Easter thing?
Yes. And I mean, I don't mean to be a complete, whatever, but just like, I know, Nicole and I tried to take care of this from the get-go.
We did everything you told us to do. Nicole gave us the address. We bought the stuff. We sent it.
We got like a $17 present, and then ended up being a $40 thing that you guys just randomly picked out, and that's why it was just on Walmart, and it could have been there on time. That's why I'm saying it just got all screwy and weird, and just like.
No, because we couldn't order it through.
I don't get it.
All right, Sarah.
I know. I
okay,
don't understand.
listen.
I know.
Okay. Listen, you wanted us to buy something for $24. We couldn't do it through Walmart. We went ahead and I picked out some nice stuff for you for $40 so that we could get it there on time.
For sure.
It got there and it was the wrong address, which was not our fault. Sent us that address.
No.
Okay.
And it's not mine either. No.
Okay.
And it's not mine either. It doesn't matter whose fault it is. It's all stupid now. You're all angry at me.
But honestly, getting his Easter present is the least of your problems.
No, it's actually not, because it gives me something that I know brings him joy, and it's natural joy, and it's something that I don't have to worry about with super stupid, awful strings attached. So no, this has been actually a really nice change of scenery, which is why it's actually been making me.
So what do you want me to do? I mean, I'm not going to order an explicit record.
I understand.
So what do you want me to do?
I mean, so what? So it's just extra seconds for you to have to use in order to order the tie set and then send her money?
And do what?
So it's extra seconds for you to have to waste to order the tie set and then send her money? Or are you just going to send her money for all of it?
No, I'm going to get him the tie set and whatever the fuck it is that you want me to send him, but I'm not going to send him the record. If you want something...
Yes, I know that.
Okay, so if you want me to send him the tie set, I'm happy to do it.
Thank you.
Okay, no problem.
So after going through all this and all that, she finally got him this record so she can prove she's the best mom ever. And then in trial, she's like, I get my child all the gifts I want. Didn't I schedule have someone in Australia? And it's funny when she said Australia because she surely didn't get New York to do it.
I'm not playing with you. I'm not around with you. I am not your bed maiden. I am not your maid. I am not your floozy or your... You are going to have to give me something substantial.
I do not feel that it is right for me to have a 30-minute phone call with my son when I'm trying to do everything that I can to be in his life in every way, shape, and form that I possibly can, from having people in Australia purchase him a record. Anything that I can possibly do to go out of my way to do, I've been doing for him. So he remembers and knows that I am in his life and I am his mother, and I am doing everything I possibly can to stay that way, regardless of the petitioner and his counsel's attempts to deter me from being part of that.
And now I guess this makes a little more sense why she went absolutely nuclear in the jail messages on Brian and her son over Easter. I don't know what it is about that holiday and her. I don't know. It's her Christmas. It really is. Or she holds it as equal and is pretending that missing out on Easter is the worst thing you could ever do to a parent. How dare you exclude his murdering mother on Easter? Jesus rose from the dead. George didn't. So I don't know why I'm being punished. And it's just another holier than thou stance to say, look how Christian I am.
She's not a Christian!
Look how this, look how that. And then the messages are just nasty and rude and putrid and not godlike whatsoever. If you believe what you say you believe.
She could be a Jew and believe in God.
It doesn't matter. She's tampering in dark-sided stuff!
To Brian. Phone call confirmation. Easter. When being made to call you from no response to any of my now 105 messages, you are actively deciding to not answer and keep lying, you will. You stated you did not schedule an Easter video visit for the second year because you had, quote, other priorities and plans which I am not a part of. And were confused when you could schedule a 15-minute video visit with me, his mother, who made and mailed an Easter package for him to open on said video visit, and which you withheld from him for 2 days, which you actively decided not to schedule out of the entire day. 15 minutes for me to see my son. And after you told me on the phone from being made to call prior to make sure I could see him this year that you would be scheduling even if in the evening 15 minutes, it's ongoing 12 p.m. while you are not on the porch smoking cigarettes.
I had a cigarette live here. Don't talk to the ex-husband right now. I won't. Can I have a cigarette, please? Ma'am, I can't take anything out of the house. It's on the back porch. Nope, all of it. It's secure, okay? Can I please just have a cigarette? They're on the back porch. Not right now. We can't have you go and get anything. What?
Hello.
Your husband for a cigarette?
I'm sorry?
May you or may I ask my former husband for a cigarette?
Just stay put.
Am I able? Someone asked. I know you said. Wait a minute. My ex-husband. We can't let you guys communicate right now. I know this one's asking me to ask for one. You want me to get a cigarette from him and bring it to you? That's okay. I could probably do that. Ask for a lighter. Thank you. No problem. Asked someone for a cigarette, and it happened to be a guy. So he walked in and got super pissed because I asked for a cigarette from another guy. I walked in and I walked to the back. I just wanted to smoke a cigarette and just go to sleep. I just literally wanted to I'm gonna smoke a cigarette, I'm gonna go to sleep.
You can smoke your cigarette if you want. Do you want to fill out any paperwork? Do a statement? No? Okay. Smoke your cigarette, sit down, smoke your cigarette.
I don't want him to get in trouble, but that's fucked up.
I know.
He's here.
Other one, tattoo.
Yeah, you can stay right here. You can stay right here. He doesn't know that you call. He doesn't know how to
Another
know
black male, another prescription.
So you're woken up to him calling you. Is that what you're saying?
I thought that I'm like, feed the beast. Go outside and smoke a cigarette with him.
Okay.
Try to calm things
21
down.
Echo.
Well, the whole time I was there saying nothing.
97 GD.
Nothing. I was called names.
Okay. So you guys were smoking a cigarette, and he was calling you names, being verbally aggressive with you. Verbally abusive.
Before that, where I'm like, I don't want to get hit anymore. So I'm just going to go downstairs and smoke a cigarette with him to try to calm him down. Go downstairs with him because he gets mad at me because I go to sleep.
Okay.
I go downstairs, smoke a cigarette. The whole time I'm being belittled. That's when I got punched in my ear. On the fourth time. Where I was like, don't do it anymore. Just go downstairs. Go smoke a cigarette.
So most of the time what happens is, because the convenience store where we get cigarettes is here, and then Publix literally is cattywampus to it, would ride his bike to work, but before he would leave extra early and come up to the wall, stand on top of his bike and poke his head over because he would know that I would be outside having my morning cigarette and cup of coffee. I just got those.
Okay. They are not allowed in the jail.
So I can't even smoke cigarettes when I go. So what am I going to do with my purse? Oh, sorry.
Your purse is going to come, but the cigarettes and stuff can't, so.
While you are not on the porch smoking cigarettes and playing on your phone, and he is, quote, still in bed, that you could undeniably have scheduled a 15-minute video visit for me to see my son, for him to open my Easter present I made him, since we are still waiting for him to open his Christmas presents and card from me, and is a completely different holiday 4 months later. 15 minutes out of the entire day. For Christmas, out of the entire 2 weeks. Another holiday I asked, begged you to make sure I am included on and in and well in advance. And after you lie to me, you are going to. You actively deny me to see him. What is this doing to our son? He was expecting this and Christmas, as I stated. You can be an adult and proper parent and include me, his mother, no matter where I am. For a fact, you would not be doing what you are doing if I weren't temporarily incarcerated.
Will the jury find the defendant guilty?
Life in the Department of Corrections.
I'll electrocute that bitch, and I want you to pour some water on her first.
You would wake him up to get him dressed, teeth brushed, ready for all the, quote, plans and activities you supposedly have scheduled for the day, and made sure he saw me, his mother, on Easter to open my package.
Which is also like a no duh. Yes, if you weren't incarcerated after murdering someone in cold blood, they would treat you differently. They would wake him up in time for Easter morning so that you could see him and y'all can pretend to be a happy family for one holiday. Yes, absolutely, things would be different if you were different and didn't do the things you do. But she thinks that everyone is supposed to join in on her delusion. How dare they treat her any differently just because she's in jail for killing someone? The cognitive dissonance you have to have with reality to make that make sense, wild.
I, who am in jail, made sure to make and mail to him and on time to open on the actual holiday, just like I did for Christmas, which was over a 2-week period.
You hear that, Nicole? Julian? New York?
This one right here, I see your heart, and it's ruthless, it's black, it's ugly, and I know why you're in this
Prison, honey.
because you're a demon and you're demon possessed.
Wow.
She did it from in jail, made sure to make and mail. No money to do any of this.
Insufficient funds. You ain't got no money. Woo.
But she made sure she did it. How did she make sure she did it? She hounded you all into the ground and takes every little bit of credit for it because she's an amazing mom.
I am an outstanding mother to my son. I excel at everything.
Which is why I'm glad Brian harped on it of, you didn't buy this.
You had somebody third party else, not you, buy him a record for his vinyl player.
You harassed someone else too.
You made that decision, quote, all the holidays are mine. When I asked you why you are actively excluding me from my son's day and celebration for Easter for the second year. Quote, you're in jail so I don't have to. Include me, son's mother, in his life when I asked why you keep excluding me and stopping me from seeing him.
Why is this happening?
Because George is dead.
Stop being sad, Brian. Jesus died for you to not be despicable, bitter, and the lonely, quote, man that you are. Overcome like he did and like I am. Like you keep telling me as if I wasn't aware already. I'm in jail.
Girl, prison, honey.
In jail, I have more joy, peace, gladness, and hope than you.
Everyone supposes that this is one of the worst experiences of my life, and it's actually been one of my greatest.
And your entire dry, pompous, unchristian-like,
She's not a Christian!
fake family will ever have. Combined. Divorced oldest son. Divorced daughter. Perverted spinster younger son. Sad, secretly depressed, lonely, closet case mother-wife. Arrogant, narcissistic, self-righteous father-husband. You reap what you sow. Undeniably. Remember. See you soon. Enjoy the Easter holiday with our son. I'll be thinking about him and missing. I wish you would include me and let me see him. Life is beautiful no matter where you are, Brian.
To life in the Department of Corrections.
Tell son why I don't get to see him today so he knows.
Why is it happening?
Because George is dead.
Do better, quote, Dad. He sees and knows what you are actively deciding to do with, to, and for his mother. Remember that. Let's get one thing straight, bitch. If you ever talked about my mother like that, I would be going to jail with you, okay?
That is just a nasty spirit to be able to say all that on the holiday, which means that if you did let him see her on that day, let's say you read this and then said, oh, I totally forgot, let's make sure this happened. She's enraged already. All of that happy, good, God love my son out the window.
She's not a Christian! No!
She is enraged and is going to let everyone have it because you made her feel bad. How do we know? Because she let her son have it.
John 20:24-29. Do you believe? See him everywhere. He died for your lies, bad attitude, backbiting, selfish ways. Overcome like he did and like I am. You're supposed to be better from his selfless act. Happy Easter. Wish I was included. Hope you like your package I made for you. I love you no matter how uncaring and nonchalant you are towards me. I wish you wouldn't be. Mother.
And that boy did nothing but exist minding his own business, trying to enjoy the holiday with his family. And she is making it her child's responsibility to emotionally regulate her and make her feel special and valued. Hope you enjoy your gift. Yeah, parents are supposed to get gifts for their kids. Kids owe parents very little growing up. And I've said this before, but she holds him to adult standards while also demanding his childlike love. Like, I don't get it. How dare you talk to your child like this? I could never imagine. Over what? Feeling left out? Grow up. To buy him a record. And isn't that make me an amazing mom? And he's like, yeah, but your husband has to pay for all of the gifts. I've said this multiple times. Brian's money goes in a circle. She wants him to give her his money and then order him to use his money, that is her money, to buy gifts for their son as though it came from her to begin with. Or the dad can just buy him stuff and we don't have to go through this merry-go-round just so she feels included. But then Martell got her and she slipped up in the actual answer, and he's like, do you think it's fair that you are having your husband pay for gifts on your behalf? And of course, she's not going to answer that because she doesn't actually care about anything that she does incorrect. It turns back into, well, it's not fair to me because I could have been paid and I wasn't getting paid. And that's not fair to me. And if I wanted to get my son something, yes, that's part of my lawful alimony. And I can use my alimony however I see fit. And if I want to get him gifts just because I love him, then I'm going to do that.
You want your ex-husband to continue to give you alimony so that you can then turn around and purchase gifts for your son on your behalf because you cannot purchase those gifts because you're incarcerated. Is that correct?
My alimony payment can be spent however I make or decide how to do so. And yes, I would like to include my son for gifts on holidays or just because I love him. Yes, that would be a part of my disbursement of my alimony.
Do you think it's fair for Mr. Boone to give you money to purchase gifts for your son that you can't afford to purchase because you're in jail? You think that's fair to him?
Alimony is court order, which is unfair that I have to not be paid when I could have been paid.
Okay.
So what originally was primary, so the primary expenses that she needs, $100 to $200 for child gifts that she listed as children's expenses, as though she pays for literally anything in that child's life. She supports him in 0 ways. That's exactly right, Paulina. Harassing him daily over the phone and telling him I love you like a psychotic maniac. Oh no. Oh no. 3/9/24, 10:21 p.m. to son. So much. I love you, 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 I love you. Yeah, I'm not gonna say this many times. Are you kidding me? Oh my gosh. Wow. Wow, it keeps going. I love you, I love you, I love you, I love you, I love you. This is so overwhelming. If I were her son, I would probably panic seeing this. This is the definition of love bombing. Quite literally. Like, what is this supposed to do for him? Does you think he actually believes this because you say it a million times? It feels so fake, hollow, abusive, overwhelming, overstimulating, and self-serving. Like, how does she think he is supposed to respond or react to this? It's one of those things when you say things so many times, it means nothing. I wonder, what does I love you mean to Sarah Catherine Boone Paulsen?
Where is he? Where is my son? Where the fuck is he? He's escaping! My son is escaping! Help me!
Because overwhelming someone like this is not showing that you actually love them. It's showing that you need them to acknowledge that they know that you love them, but not actually expressing the act of love itself, which is giving him the space he is begging you for and clearly communicating to you. Every time he does clearly communicate, you go absolutely apeshit about, you don't treat me right. Why are you so mean? You're this terrible this. Oh, and then the next one is, I love you, I love you. Just wow. So now she gets to use this in the future to say, look how supportive I am. Look how much I'm trying. I'm trying to actively be in your life, to be in every single aspect of your life.
I love you, I love you, I love you forever.
Inhale, 2, 3, 4. Hold, 2, 3, 4, 5, 6, 7. And exhale, 2, 3, 4, 5, 6, 7, 8.
Doesn't mean you actually support your child. Meanwhile, she has the audacity to ask for hundreds of dollars monthly from Brian as though she'd had anything to do with her son. And then to push back a little bit on Judge Jackson when she says that she denied paying the Department of Corrections $50. She didn't really deny it, she just didn't answer it. Because Martell asked, are you saying that you owe the department money? And she said, well, you have to put a lien on your account this, and after every single period, they pull money from your account this and that.
Okay. And you have here a $50 charge for creditor Department of Corrections. Are you indicating that you owe the Department of Corrections money?
These are all estimates. And you need to please remember that I am new to DOC and don't understand, but I do know that weekly draws from everyone's account every week. So depending on how much money you have in your account is how much they deduct from your account. This was just an estimate. I'm not even sure how they go by what they do, but this was what I was told to do from one of the classifications officers. And a lot of these, if you see at the bottom, it states estimates for all. The clothing is charged quarterly. It's not every month. And there's limited quantities, and also the prices fluctuate, which is why I included those as my exhibit so you all would understand the most current pricing.
But to be technical, she never affirmed, yes, I pay $50 to the Department of Corrections monthly. She says, and you know I am new to DOC, so I don't know. And these are just all estimates because you said I can estimate this and estimate that. So I'm going to overshoot and try to get absolutely everything I possibly can from you. And that's why she said, at best, your monthly expenses are $145. 13. As such, substantial competent evidence support petitioner's claim of a substantial change in circumstances. See Hembry v. Thomas, finding that, quote, incarceration clearly constituted a substantial change in circumstances. Nangle v. Nangle, quote, a key factor in determining whether a modification is warranted is determining whether, after the final judgment is entered, the parties, quote, financial abilities have changed. Which is so blah and obvious. It took all of this just to set up going to jail means your financial situations as a family has changed. Shocker. And now moving on to the parenting plan. I know we took a lot of detours in the past. Hopefully we'll just keep going forward and until the next detour. B. Parenting plan modification. 14. Petitioner seeks to modify the final judgment by awarding him sole parental responsibility, decision-making authority, and 100% time sharing. See Modification Petition at page 4. 15. At the final hearing, father proposed mother have one monthly visit and one weekly phone call with the child. Mother objected to father's request for sole parental responsibility, and she requested an unspecified number of, quote, phone calls and personal space without interference, as well as one or two in-person visits for the, quote, maximum time allowed, holiday visits, and, quote, perpetual cooperation from father. She sure did ask for perpetual cooperation, and it sounds absolutely as ridiculous in this written final judgment as it did when she first said it. And I hope when she reads these words, she realizes they're making fun of her, because they have to take her words seriously when she actually just means to just try to jab at someone. She means, I want you to tell him to be more cooperative, not that I want you to put in the final judgment, quote, perpetual cooperation, because it sounds like a little toddler tattling. And it's just funny because, yes, everything was so unspecified for her. Brian said, I want her to have one singular 30-minute phone call per week. I want her to have one monthly visit. Paulina remembers, and she was also wondering, Sarah didn't write any of that. She wanted to be able to call anytime she wanted to, and she uses the guise of her son, or anytime my son wants me to call. And we know from the messages that she will blow up in his face if he doesn't want to talk to her, and then she'll guilt him, saying he's a terrible son. How could he treat his mother that way? Man up and just tell me if you don't want to talk to me. All the while saying he wants to talk to me every day. I should be able to call him 1,000,000 times a day. And so now she is stuck. Well, we're going to get there. Paulina the Plane had a lot to say on that one. She said if Sarah had specified any number, said I want 2 to 3 phone calls a week or daily phone calls. I want 5 phone calls during the weekday or 7 calls a week. If she had put out any number, they could have negotiated with that. But she put an unspecified whenever I want number. So the only number they had to contend with was Brian's. 16. The court has heard the testimony of the parties, examined the demeanor, body language, and overall credibility and ability to show self-insight and awareness of the issues pertaining to shared parenting and time-sharing issues, and examined evidence related to the issue of the contested time-sharing for the minor child. In determining the best interest of the child, the court makes these findings as to the factors affecting the welfare and interests of the minor child and the circumstances of the family as follows. Which this paragraph is basically saying, buckle up, Sarah, this is about to be a mess for you, and this is the exact reason why you will lose everything. Judge Jackson says, I have examined all the demeanor, the body language, and overall credibility, which you know Sarah would throw a fit over. How did you judge my body language when you couldn't even see me? I was over the telephone.
Sometimes I'll start a sentence, and I don't even know where it's going. I just hope I find it along the way.
She can get a good sense just through your vocals, how loud you were, abrasive, just insulting overall, and just aggressive. She didn't really need to see it. But the important part is she's saying that shows self-insight and awareness of the issues pertaining to this shared parenting and time-sharing issues. She wanted to go off for 1,000,000 years about every other issue than what they were there to discuss. That's why I don't know how many times Judge Jackson had to interrupt and tell you again and again, we are talking about X, Y, and Z.
On the issues regarding the parenting plan proposed for the relocation, and the modification of alimony and child support, the relocation proposed parenting plan, and the modification of child support, the modification of alimony, and the request for sole parental responsibility. The relocation proposed parenting plan and the request to modify either child support's not an issue, but to modify alimony. I will say them one final time. The issues are the petitioner's proposed parenting plan, and then the request to stop alimony. And there's also a request for attorney fees. So the only issue with regard to relocation is the proposed parenting plan. Regarding the proposed parenting plan, the request that the alimony be discontinued, or the request that the child support be discontinued, or the request for attorney fees. Regarding the proposed parenting plan, the request to stop the child support, the request to stop the alimony, and the request for attorney fees is the proposed parenting plan, as well as the request to have the alimony of $1,000 per month discontinued, and the issue of child support and the request for attorney fees. The request to discontinue alimony and the request to discontinue child support. In regards to any of the issues that we're here on today that I have recited over and over, I think I might be on time number 7 now.
Yeah, double homicide, double homicide, double homicide, double homicide, homicide. Bitch! No, I'm sorry.
So Sarah will say everything is unfair and that no one listened to her. Unfortunately, they listened to you too well. And you are the one who refused to talk about the actual issues at hand in a concise and clear way. So that's why your side is rarely considered in this, and it's pretty much anything Brian says go because he said it in the right and proper way. She is used to living her world through exaggerated, flowery language, big, bold claims. I'm smarter than everyone in the room. I have a dictionary.
I don't think you all understand who I am, where...
Okay. Well, tell me.
I mean, I've always been a straight-A student. I am an outstanding mother to my son.
Okay.
I excel at everything.
Okay.
So I'm the one that's being portrayed as the aggressor. Because I have never dealt with anything like this before. I don't know what to do, how to do it, and I always know what to do and how to do it. I don't know. So I don't know, like, what's going on or, like...
Also add a dictionary as my other torn in half. If she doesn't have her dictionary, what is she going to do? How is she going to use inveterate? Also add a dictionary as my other tore in half, and the officer threw it away. I know that's right. She was tired of you abusing that dictionary too.
But when it actually counts, you don't know how or what words to use. It's very simple. In its essence, this whole case is extremely simple. She makes it as complicated as it can possibly be, and that shows zero self-awareness or insight on the actual issue. And Mr. Martell called her out directly, saying she refuses to accept responsibility, accountability, show any remorse, or accept the reality of this family's situation.
Is that the court take into consideration in its equitable powers the amount of attorney's fees that Mr. Boone has incurred to fix basically all the chaos that occurred due to Miss Boone's voluntary act, criminal act, and also her ongoing defiance and unwillingness to acknowledge the reality of her situation and the reality of this family's situation, which has had a direct result in Mr. Boone having to incur tens of thousands of dollars of attorney's fees.
She wants to always throw out there that no one has a crystal ball.
What do you think you would settle for?
I don't know. I don't have a crystal ball. I know he's a piece of shit.
As said in my previous letter, no one has a crystal ball. P.S. Thank you for seeing that crystal balls don't work at all, ever. Dust catchers.
Because I can tell you one thing, if we continue on the direction that we're going right now, you will not achieve your goal.
How so? Where's your crystal ball? So
Because-
you want me to conform?
Because, okay.
No one can tell the future or assume to. I was unaware former husband had a crystal ball. I have faith and will always. This being something no one can take from me ever.
She's not a Christian!
No one has a crystal ball. There is an imagined future where as long as I believe in God, God will say it is okay that you viciously murdered someone. Please, thank you for harassing everyone until I decided to set you free.
She's tampering in dark-sided stuff! Yes, yes, she did!
Honestly, that's what she thinks is going to happen. She thinks if I can still throw as many Bible verses at everyone and to show how amazing and wonderful I am, then of course God will set me free. That's how this works, right? Well, let's see what Miss Jackson thinks. A. Demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. Due to her incarceration and life sentence, Mother has been and continues to be unable to honor the time-sharing schedule implemented by the parties' parenting plan and the final judgment. The child was able to have virtual visitation with Mother when she was incarcerated at the Orange County Jail, but she has since been relocated to a prison in Marin County. Father testified that he has paid for all telephone calls between Mother and the child. According to Father, there are times when the child is visibly upset after speaking with Mother on the telephone because of the way Mother talks to the child. And straight out the gate, this paragraph A is quietly devastating to Sarah's whole case. And I like how it's composed because it's very subtle but impactful, and I like the way the logic builds upon each other. So, A is questioning whether each parent has the ability to demonstrate the capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship. Sarah would like to frame that as Brian could go out of his way to facilitate a relationship between me and my child, but that is not what the question is asking. It's saying independently, can both sides facilitate and encourage a parent-child relationship? She can't do that. And I like the wording she says of ever since her incarceration, she has not been unable to, Mother has been and continues to be unable to honor the time-sharing schedule. And I like that framing of honoring it. This isn't just a, oh, well, I'm in jail so I can't do it. It's
All right, Miss Boone, you have to agree that there's a lot that's not being followed with regard to that parenting plan, which includes even the time sharing that you're not able to do at this time.
Right.
You would agree with that, correct?
I understand that, but that is my only stipulation. That's my only part that
All right, you would also agree.
No, you are still breaking your obligations. Obligations you agreed to when you agreed to take this money. And so not only do they establish that because of her incarceration, she can't do that, the husband has been facilitating visits with her. Beforehand, he facilitated virtual visits, not as many as she would like, but he still did it. And then also, he has paid for every phone call. That is the most devastating part to every claim that she brings up about parental alienation specifically. He's alienating me, he's excluding me, he's making me feel bad.
It doesn't include me in any way, shape, or form in regards to anything that has to do with my son's life. I know a lot about my son. I know what his favorite color is. I don't believe that petitioner even knows that much. The name of his girlfriend, the things that they're going through. I am part of his daily life. And for him to take that away from me is just out of bitterness and spite. I want to be a part of my son's life. And people forget that I have a pending appeal. So, to prove my innocence.
When the jury find the defendant guilty of murder in the second
Electric chair.
Holy shit. God damn it.
Also, he pays for 100% of every phone call between me and my child for the past 5 years. Right. And I like how she said, father testified this. She didn't say the court did not find credible the father's testimony that he pays for all of the phone calls, because that was uncontested. Both sides agreed to it. That exchange will never not make me laugh at trial. How she tried to get Brian saying, didn't you agree to the 13 cents per minute? Well, yeah, it's the only way. Well, most of my questions are just a simple yes or no. And then Martell got on there and asked her the same question in reverse of, Brian has paid for every single phone call, right? Well, it's my only form. It's a simple yes or no. The answer is just a simple yes or no.
When you originally signed up for this account in order to utilize the phone option, were you aware of the 13 cents per minute?
Yes. I have to pay for all the phone calls.
So you accepted the fact that it was 13 cents per minute?
You don't have a choice. That's the only way to have phone calls in the jail.
Yes, no. For most of my questions, it's just a simple yes or no.
All right, ma'am, what's the point of this questioning?
Because he's making it seem that it's a very expensive phone call for me to speak to my son, and it's just 13 cents a minute, and we don't utilize the full 30 minutes each time. So by him setting up this phone account for the 13 cents per minute and free phone calls.
All right, the court has taken notes that it costs 13 cents a minute based on exhibit number 1. Your next question.
Okay.
Okay. I want to be clear, though. Every expense related to you communicating with your son since you've been incarcerated, Mr. Boone has paid for that. Is that correct?
It's my only form of ability.
Ma'am,
right
answer
now.
the question.
Yeah, double.
Has what your communications with the child been paid for by Mr. Boone since you've been incarcerated?
Yes.
Other than receiving contributions from third parties and receiving money from Mr. Boone, since you've been incarcerated, have you had to pay any money out of your own pocket to meet your day-to-day needs while you have been incarcerated?
Sir, I have no money.
Insufficient funds. You ain't got no money.
I'm sorry, I didn't understand your answer. What did you say?
Sir, I have no money.
You ain't got no money. Woo.
Okay. So the answer would be no, correct?
I have no way of doing so. No, I do not have any way of paying.
I have no further questions.
With your broke ass.
It's funny because it's cringe. If she had any valid argument against that, which she didn't, she could have gone a million other directions. But it is a fact that Brian is the sole reason you have been connected to your child this entire time. You have zero ability to facilitate that relationship on your own because of your own voluntary actions. And I said that last sentence was the most devastating part, but just twisting the knife and the real mic drop is, according to the father, there are times when the child is visibly upset after speaking with the mother on the telephone because of the way mother talks to the child. This is going to be a haunting argument that will follow her continuously, because she likes to say, oh, my parental rights are being violated. He's only punishing me because I'm incarcerated and there's no reason he's doing this. No, the reason is you upset the child and you agree with it. Gary the garbage truck heard you too. You point blank agreed in trial. Okay, are you done, sir? Okay. You point blank agreed in trial that yes, he is upset after speaking to you, but it's only because you allow him to curse on the phone.
Why was your statement made that our son is upset after speaking to me on the phone? Do you know specifically why? Because you asked me or him?
Because he tells me. I can see him.
I'm asking you if he explained to you why he was upset.
Yes.
And why is that?
Can I? I mean, any number of different reasons. The way you talked to him, what you said to him, how you made him feel. I mean, the plethora of emotions that you corrupted.
Is it because you allowed him to curse on the phone?
That I allowed him to what?
The majority of the time, I will tell you this, which you are unaware of because
You're
you
not
do not
telling anybody anything, ma'am.
Yeah, double homicide.
Bitch.
No, I'm sorry.
How is that harmful?
Once again, I see him very upset at the way you talk to him all the time after phone calls.
When was the last time he was upset?
Probably about a week ago because you didn't call all last week.
Do you know my schedule of work while I'm located at DOC?
No, of course I don't.
What?
Why haven't you asked about it? To know that.
Because I don't care.
What?
Regardless of your reasoning, you still admitted that talking with you upsets the child. You have no proof to the contrary that says talking to Brian upsets him, but Brian made that claim and you agreed with it. And if Sarah had actually been able to submit those jail text messages like she wanted to, that would have proven above and beyond how abusive she actually is to that boy. We've played these texts plenty of times, but let's just do a highlight reel of her best insults to her child that she says she loves more than anything, yet talks to him like this. Thanks for setting up your account finally. I guess better late than never, huh? I tried calling you 2 to 3 times so far today, but no answer. What are you doing? I hope your day is nice. Like you, sometimes. Happy New Year. Or just New Year. I'm praying you will help make it a happy New Year. I keep trying to call you on your phone, and still it goes directly to voice message. I really do not want to call Brian, as I have said in the past many times. I was hoping you would actually listen and care and make an effort just simply to have your phone on and charged so I can talk to you. Why? It's not like I'm asking you to grow a third arm or lasso the sun. Just answer your phone. I hope one of your resolutions, if you have any, is to be nicer and respectful to your mom. And to understand my feelings. Yes, I have feelings. And how much you crush them by not caring enough to simply plug in your phone. Would you make sure it were on if Addison called? Or Mary? Or anyone other than me? If you are choosing not to talk to me, I wish you'd just man up, Jesus Christ, and tell me so I can stop looking like the fool you are making me out to be by calling just to be yelled at, called names, or hung up on. If you have nothing to say to me or care enough to include me and share your life, just be honest and say so. You are my son. I am your mom. Forever. No matter what, where, when, why. No matter anything. You can't delete, erase, blot out, omit, change, or remove. Stop being mean to me and not caring. I'm already going through so much, then to be disregarded and spat on by you is unspeakable, and for no reason. Do you delight in making me feel worse? Does it make your day knowing you make me cry and feel worthless to you? Who am I to you? Really ask yourself that. Punching bag? Daily joke? Unwanted friend? That's how you make me feel. Know that, son. I can't make you care. I can't make you love. It's your choice, yours only. New year, new start, new everything. Your choice. Don't forget about me. Love always. Who am I? You can't go back and change what you said or did or didn't do. Every day you have one chance to shine bright for him, yourself, and others, including your mom. Plug in your phone. I've been trying to call you on your phone the last couple of days, and it just rang and rang, then voicemail. Now it just goes directly to voicemail. Please make the effort to plug in and charge your phone and make sure you have with you. It's not nice to me to not be able to talk to you because it's not on. Remember, if your decision is for me to not be a part of your life and keep trying to talk to you, just say. Just say. Your response last time I asked was that you wanted me to be. I wouldn't know from the lack of effort and intention to make possible from you. What else can I do? Honesty and effort. Not asking much, but missing out on talking to you. My one and only son. Love, your one and only mother. Trying to call you. Your phone goes directly to voicemail. Still trying to call. Why can't you make sure it's charged and on and with? Please know it is not me not trying to talk to you. Effort and love? To son. Trying to call again. I just tried calling yet again. Why can't you? Rather, why won't you make sure your phone is charged and with you to talk to me? For how many times I have asked you and Brian, I keep using my credits that cost 50 cents each to remind you. Please plug in, charge, have with. Love and effort? You have so many things that are praiseworthy and positive to think of joyfully. Most of all, him, and also including me. Love and effort. I'll keep trying to call. Miss talking to you and knowing how your life is going. Please don't ever think I'm not a part of it. I am, no matter what or where. I'm never going to give up being in it. And for you, no matter what or where. I love you for everlasting to everlasting. Always know that. Talk to you later. Heart, heart, heart. To son, I try calling you every night with no answer. Don't you know by now the evening time is when I am able to call you so you have your phone with you? I call every night. Every night. Tonight it rang and rang, then went to voicemail. Then voicemail directly when I called back. You don't want to talk to me? It makes no difference when it is, as it's the same thing on the weekends. Anytime I call you. Please don't think I'm not trying. It's you who are not. I hope you answer sometime. I love you. Make sure others remember how good you make them feel with all the softness, understanding, love, and positivity you can give to everyone, including me. I want to remember good things from you, which there is an overabundance of, now and future. Make a difference. Be the difference. Take the extra minute or extra effort to remember that I remember too how you make me feel, your mom, along with everyone you come in contact with. Remember, I love you. Thank you for your goodness. I have a trivia question, blank, the answers to, and you can give to me on the phone when we talk. Blank, I catch you. I try to call you every night, so make sure your phone is blank. I called 8 times. Did Dad tell you I tried earlier today? John 20:24-29. Do you believe? See him everywhere. He died for your lies. Bad attitude, backbiting, selfish ways. Overcome like he did and like I am. You're supposed to be better from his selfless act. Happy Easter. Wish I was included. Hope you like your package I made for you. I love you no matter how uncaring and nonchalant you are towards me. I wish you wouldn't be. Mother. But even without those messages, it is completely understandable that Your Honor came to that conclusion based purely off of the way Sarah behaved at trial. She hears how she spoke to Brian, and that's why Judge Jackson was completely over Sarah the entire hearing.
Being truthful and ethical and providing the proper paperwork in a proper amount of time so I can actually review and correspond timely with the correct
All right, Ms.
information.
Boone, you're way off base here. I need to know, an opening statement is kind of a outline of what you intend to present at trial. And what's the relevance to the issues that we're here on today?
This is where I'm unclear, Your Honor. I'm not sure what exactly I'm supposed to be doing. Is this in regards to the parenting plan for the relocation?
I've explained to you more than one time the issues that the court is considering today. You need to be asking questions regarding those issues. I will say them one final time.
I had no idea that the relocation parenting plan was even an issue, considering the fact it's been agreed upon.
I'm not sure why you have no idea when I've said it. I think this is the 5th time.
Yeah, double homicide, homicide.
Bitch.
No, I'm sorry.
5th time that I've said it.
Forgive me, Your Honor.
Sorry, Miss Jackson.
That it will dramatically improve the economic circumstances of the petitioner and the minor child.
So I'm going to object because as the relevance, because.
All right, I'm going to sustain the objection. Again, ask questions regarding the issues that I just gave you.
I'm not sure what I'm supposed to do. Am I supposed to object to it? Because I object to it.
Right,
It
we're
doesn't
here
make
for a
sense.
final hearing. Whether or not you object to it is not relevant at this time.
Communicating with you about our son.
Yes.
Have you responded?
You've already been over this. Next question.
When the
I'm gonna object
parents
as
do not
relevance.
plan remains in effect until further order of the court. Has
All right,
this
ma'am.
been
Ma'am, you're beyond the issues we're here on today, okay? Next question. On those issues that I've gone over with you over and over again.
Forgive me, I'm trying to do my best without knowing what I'm doing. How soon before the actual relocation did you tell me?
All right, again, that's not relevant to the issues we're here on today. The relocation to has already been determined, okay?
I don't know if you can answer this or not. I just don't know without asking you. Are my questions after this? Is that the end of it? I mean, I don't know how much further this goes for me to be able to utilize my pretrial statement information.
All right, as I explained to you at the beginning of this process, I will do it again. The petitioner has the burden in this case. They get to call the witnesses, they get to introduce evidence, okay? Once they are done, then I turn it over to you so that you can call any witnesses or you can provide any documents that you want the court to consider. I also want to say to you, it is now 3:06 p.m. We will not be going past 5 o'clock. So the more you continue to ask questions that are not on the issue that we've talked about today, the less time you will have to present your case. Okay?
Yes, Your Honor. Okay. So parenting plan attorney fees and alimony.
Correct.
Okay. 2018, I believe, I wanted to bring to the court's attention that it's been violated by the petitioner. Again, from previously, now I believe it's a time where it says the parenting plan may be modified or verified on a temporary basis when both parents agree in writing.
All right, Ms. Boone, Ms. Boone, you have to agree that there's a lot that's not being followed with regard to that parenting plan, which includes even the time sharing that you're not able to do.
I understand that, but that is my only stipulation. That's my only part that
All right, you would also agree that that parenting plan was entered into back in 2018 prior to there being any criminal charges in your incarceration. Do you agree with that?
I do, Your Honor.
Yeah, Double homicide.
But it
Okay,
was
and you
still
have
an
to also agree that when the parenting plan was entered into, if I remember correctly, you all agreed to the parenting plan as part of your mediated settlement agreement back in 2018. And at that time, neither one of you were contemplating any type of criminal charges.
Double homicide.
Or incarceration. Is that correct?
Yes, Your Honor.
Yeah.
Okay. All right, you may continue. Any additional evidence you want the court to consider?
In regard to the parenting plan,
In regards to any of the issues that we're here on today that I have recited over and over, I think I might be on time number 7 now.
Double homicide.
in regard to the alimony, I would like please to
All right, that is not a citation for a case named Lamb.
Lamb versus Lamb.
All right, and I need you, how many more of these you have? We were down to 15 minutes and I gotta give counsel an opportunity to question you and then save time for closing arguments.
I'm not sure. That's why being on the phone is very difficult. I'm sorry. I'm doing everything that I possibly can to properly represent myself.
Yes, I did. I had some other exhibits that I would like to have put into my evidence, and then I also was supposed to speak about the attorney's fees.
Then why didn't you do that?
I've given you lots of time to speak about all the issues. The fact that you didn't take that opportunity instead of going into other issues is not what the court is going to address now. What specific exhibits do you would like to move into evidence?
Your Honor, forgive me, but I'm here on the phone
Forgive
trying to
me
do all
when
of
I
this.
ask you what other exhibits that you want to put into evidence.
Yeah. Double homicide.
Oh, Miss Jackson
Jackson.
has had it.
Next.
That's all I have for right now, Your Honor. I'm being rushed out.
All right, I'm going to give you all until next Monday at 5. I'm going to say by 5 p.m. That includes, Ms. Boone, you need to put it in the mail by next Monday, a written closing argument on the issues we're here on today, okay? So I'm going to give you all until 1 week to provide written closing arguments, no more than 5 pages.
No more than 5 pages?
That is correct.
Parenting plan, alimony, attorney's fees. Please, if I may, before we hang up, the closing arguments are for parenting plan, alimony, attorney's fees, and...
I am not repeating myself, ma'am. You need to make a closing statement. You need to put it in the mail to me no later than next Monday, which I believe, actually, that's a holiday. So I'm going to give you all till Tuesday, which is September 2nd. I will not accept anything that is postmarked beyond September 2nd. Again, this is closing arguments on the issues we're here on in trial today. No more than 5 pages. Thank you and have a great day.
And she can tell that if this is how she talks in a court of law, when she knows everyone is watching and every word she says is being scrutinized, how does she talk to that boy when she's alone, angry, and feels abused or abandoned or any negative feeling whatsoever? She's going to rip into him. That pattern of behavior is clear as day. So straight out the gate, this paragraph A destroys all of her major claims of, well, I can be a parent too. No, you can't. If you are solely dependent on Brian to make you a fit and included parent, then you are not a fit and included parent. B, the anticipated division of parental responsibilities after the litigation, including the extent to which parental responsibilities will be delegated to third parties. Since mother's arrest in February 2020, father has undertaken 100% of the parental responsibilities for the minor child. C, The demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of the child as opposed to the needs or desires of the parent. The court notes that mother continued to contest the relocation petition and subsequent motion for temporary relocation despite the intense local media coverage of her murder trial, despite the child being bullied in school in Orange County. See Order on Motion for Temporary Relocation filed on March 6, 2023, quote, temporary relocation order entered on April 5th, 2023, see also finding mother did not have, quote, an articulable reason as to why she opposed the relocation. Not one single articulable reason, because there wasn't one. The only reason she initially objected is because it made her feel bad. Them leaving made it seem like, oh, I'm going to be locked in prison forever. How dare you do this? You don't know the future. You don't have a crystal ball. You have to wait and see what's going to happen. It started even from her motion for contempt, where she pretty much comes out the gate being like, how dare you side with them for the relocation? This is nothing set in stone. Everyone has a crystal ball and can see the future. I too am still in shock of the outcome for the petition to relocate. And blank, my minor son being advantageously taken 4 times the lawful amount, 50 miles, to move away from me, the other parent. As far as I'm aware, which is rare in this case as no one includes me on anything, I still have my rights, custody of my son, and am owed alimony. Nothing has been made permanent or signed to state otherwise legally. I am already being told and profusely laughed at repeatedly by him. They're never coming back. It's all going to be made permanent, and I can't do anything ever about any of it. You see, Judge Dean, Henrietta, how even more terrible will I be made out by wanting to have my son closer to me, and is lawful, after he's established friends, school, activities, favorite places to eat, then all of this brought to you again to conclude and them be made to move away, closer as included in the temporary location paperwork. Or will it automatically be awarded to them, like everything else, and all their wishes come true permanently? Because I will have nothing and no one to help me figure any of it out when the time comes. If I even do it right in my hopeful attempts like I have been already. Please tell me now so I know what to plan on, considering everyone seems to have a crystal ball but me. It's only fair and I should be included. From everything I have experienced so far with judges, courts, lawyers, etc., it seems true already everything will not be in my favor from the truly unjust way I have been treated and am still in this case. Is this how the, quote, justice system really works? Judge Dean, you stated in the relocation hearing also it's a, quote, fresh start for son and former, quote, husband to move beyond the 50-mile radius away from me. Why would you allow them to, quote, start before knowing anything of my outcome? Why? I guess I'll never get my, quote, fresh start from everything being made so impossible and arduous before anything has been happened and after when and if it does. Jesus Christ. And she said the same type of thing in other letters where she just kept asserting, this is temporary. Why is everyone acting like I'm going to be in here forever? Where I'm only on trial for one of the most brutal murders of the 21st century. I should be home by the end of the week, but no one is listening, which is still crazy because she doesn't see it as a violent murder. You can tell even from the bond hearing clip, not the bond hearing, but when she was originally denied bond the day after she was arrested, and the judge is literally reading the autopsy findings show significant trauma to both sides of his body, and she's shaking her head no.
The autopsy findings, which include significant evidence of trauma to multiple sites on the victim's body.
The state asked for no bond. The judge agreed.
As though it's an opinion, but it's what she's had to do to emotionally distance herself from her terrible actions and she expects everyone else to do the same. No, it is insane for you to fight this hard to keep your child and former husband from moving, especially since he told you he was being bullied. And that's one thing that wasn't brought up in trial that was brought into this final judgment of the original temporary relocation order mentions school bullying and media coverage of her murder trial. I'm glad Judge Jackson will not let that go. It keeps contextualizing everything. You're not just incarcerated, you are incarcerated for a murder charge. And your former husband and child had to endure intense scrutiny because your actions make no sense, meaning everyone else who was connected to you has to suffer. And the angrier people get with you, the more aggressive they are to anyone who's connected to you. Which is why you see with the parasocial relationships with the Julian, the Nicole, the New York.
Mine? Beyonce, sweetie, I'm so sorry. I'm so sorry that an ugly ass bitch like this would even say that. Oh my God, are you insane? Beyonce? You know who you really look like? You look like Luther Vandross. I would advise you to pack your up because you're going to prison.
Girl, prison, honey.
They're all getting harassed as well because they're seen as siding with her, meaning they're the more tangible targets because no one can really reach her behind bars, even though she's always afraid for her life for some reason.
I wrote his family and his daughters apologizing for asking for their forgiveness, but due to fear that my life or sons would be jeopardized, I did not send. I am sorry.
I am sorry. They're gonna come and kill me. They're gonna come and kill me. I want you to know that. Look. Are you talking about family? Yes. Okay. I want you to know I am full blown. They're gonna come and kill me. They're going to come and kill me.
It's gonna be I'm afraid for my life. I want you to know that. I am afraid for my life. His family, they're going to kill me. Okay, well. Do they live local? Yes, they're down the road. They're going to kill me. His kids are going to kill me in Philadelphia. They're going to kill me. This was not intentional.
But yeah, they're gonna know what we're here, what we're investigating, and that they're gonna think I killed him.
Why would they? They always have said that. They've always have said that.
What have they
I
said?
told you it's because I'm the blue-eyed white dragon. That's what they call me.
Now my blue eyes. Finish him off with
white woman. And nonetheless, if you really want to know, and I hope it doesn't get them in trouble, but he is over here illegally. So he's trying to work on getting his green card.
What does that got to do with you using the restroom?
I cannot begin to fathom any of their grief and sadness. Please forgive me.
And yet you are absolutely okay with forcing your son to stay here in an environment where you fear for your life. Even by your own fake conceptions of reality demonstrates you have no capacity or disposition to put the child's needs above yours. If you feel like you are literally being hunted, why wouldn't you want your child to leave here? Is that fair? No. Should that happen? No. But does it happen? Yes. And she knows that. If you are actually trying to put your child first, you would believe the allegations that he is suffering because of you. A good parent would say, yes, please relocate, move. However, when I get out of here, I am coming for my child, so don't forget me. You get out of here and you protect our child right now, but I have something, whatever, my joy on the horizon, yada, 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 crusade forever. I don't know. You can do all that if you ever got released. But she was so offended at the notion that they would drive away from her as though she had any control beforehand. She was not driving to them. They were not driving to see her every day. There was no difference besides the fact that it hurt her feelings. So what is she going to do? She is going to prolong this for years and years, making her child stay in a hostile environment as long as she possibly can, because if they leave, then that's acknowledging that she is behind bars for murder.
Will the jury find the defendant guilty of electric chair?
And will not be coming out.
Court sentences you to life in the Department of
Electric chair. Holy shit. God damn it.
And she has to show you she still has mom rights. She has custody. It's another control tactic. She has control over nothing in her life, not when she sleeps, when she eats, when she does this or that. But if someone tells her that they're going to do something that she doesn't like and she has any form of power or influence over it, she is going to seize as much as possible. You're not going to leave here because I have some kind of power to make you stay, and so I'm going to do it. And because she's having a hard time, she can't see anyone else as having a hard time. Oh, you're being bullied? Well, imagine what it's like being me behind bars. Maybe that means that you should come talk to me more. That kind of logic that leads to this. Years and years on end of not just being in a hostile environment, but building resentment every single day, knowing this woman who calls me every single day, 1,000,000 times a day.
Hello?
Why don't you want to talk to me?
You don't want to talk to me?
Don't hang up on me.
Is chaining us here, which is why he said in that letter, we don't owe you anything, responding to what she says, because I imagine she tells him often, you owe me this, you owe me that. He says, we don't owe you anything, are waiting for you to be found guilty so we can finally be set free from you. We don't owe you anything and are waiting for you to be guilty so we can get out of here and away from you. I don't want to deal with you anymore. I'm going now. Click. Yelling at me so loud, the phone is distorting. So loud, former husband, his father, came in and told him to stop being mean to me before hanging up. Honorable Dean, this is what was told to me by my 11-year-old son when I asked about his best friend and how she was doing since I hadn't mentioned her in a while. He told me she started acting strange after he told her he was moving and wouldn't see her anymore. She's upset with him. The conversation continued with me asking why he's telling his friend this, as nothing is set in stone and will be discussed when the time comes. Oh, we're leaving, and it doesn't matter what you say. We have an attorney. Eventually, it turned into the aforementioned statement, and I was laughed at, disrespected, shut down, and hung up on.
Hello?
It's me again.
Take it easy. Hello?
Hi, calling you back.
See ya.
By my son, over asking about his friend. And because that hurts her feelings, she will not let her victims go. Insanity. So I love that this is brought up in the final judgment, because then we get to trial. After all this and all that, get to trial. Do you oppose the relocation? No, not at all. I absolutely agree with it.
I'm going to start with the petition for relocation. Ms. Boone, do you oppose the petition for Mr. Boone to relocate with the minor child to?
I do not oppose.
Right. Hearing that there is no opposition, I'm going to adopt the findings from the, I believe it was February 2023 order, finding that there was a substantial change in circumstances that necessitated Mr. Boone moving the minor child to, and hearing no opposition to the motion, the petition for relocation, I'm going to grant that petition.
Your Honor, am I allowed to say anything in regards to the contents of?
If you're not contesting it, I don't need to hear anything about it.
I am contesting some of the points that they have in regards to some of their other motions and modifications. Just things that I would like to apply to it from this motion.
All right, the petition for modification is solely for Mr. Boone to move to with the minor child. Are you opposing him moving to with the minor child?
Your Honor, you said the petition for modification, the petition for relocation.
Excuse me, the petition for relocation. We're not dealing with the petition for modification just yet.
Okay, no, I do not oppose the modification for relocation.
Why? Because it was all a BS stunt. So when she said, I told him wait and everything will be discussed when the time is right. The conversation continued with me asking why he's telling his friend this, as nothing is set in stone and will be discussed when the time comes. This was the time. You said nothing. You immediately gave in and said, absolutely, take my son away. I don't contest that at all. She fights just to fight, which goes against this whole point of the capacity and disposition to consider and act upon the needs of the child as opposed to the needs or desires of the parent. It has only been about her this entire time. Regardless of how many times she wants to throw his name around, how many times she wants to throw the label of mother around, it has always been for what she wants. And she made it clear in both of those letters. It's because at the time, he was not giving her commissary because they had to deal with the whole move, which cost money. And that's an easy, great excuse. And it's not really an excuse, it's a reality. That because we have to move away from you because of what you've done to our lives here, I don't have extra money just to be throwing at you.
Broke ass.
Moving misconceptions, assumptions. I am told on a daily basis about all the hustle and bustle, repairs, contractors, etc. for the house to be sold as soon as possible so former husband can take my son and move away from me. Another reason I am withheld monetary funds to make my necessary purchases. When trying to rationally discuss the topic of moving, I am either yelled or laughed at or just told it's happening. I want to make sure former husband abides by the 50-mile radius and all other moving rules included. He assumes he and my son are going to ride off into the sunset and leave me in the dust, knowing I have no attorney, money, or family, which he seldom reminds me of, telling me there's nothing I can do. I don't want to hear him talking about it all the time anymore, and get it right when you do. Please, Judge Dean, clarify so he knows for definite what to plan on and can make the necessary changes, including saving money in order to bring my currently negative jail account in the positive to make my necessary purchases. I am requesting to be kept informed with any updates regarding moving plans, especially since it includes taking my minor son. So your response is, I'm going to force you to stay here. And now that I've forced you to stay here, there should be no issue in why you can't give me money. Another reason I am withheld monetary funds to make my necessary purchases, including saving money in order to bring my currently negative jail account in the positive to make my necessary purchases. You don't have an excuse to use, I gotta move away from you and you're taking my son away from me. Not you're taking my son to safety. It's away from me. I don't care how he feels as long as he calls me and picks up this phone 7,000,008 times I call and then tells me he loves me unconditionally forever and always. I don't care what happens in his life. Linda, you are spot on. She don't give a damn about that boy and what happens in his real life as long as he picks up that phone and says, Mommy, I love you. And here's $20. D, the length of time the child has lived in a stable, satisfactory environment, and the desirability of maintaining continuity. Since mother's arrest in February 2020, the minor child has lived with the father 100% of the time. E. The geographic viability of the parenting plan with special attention paid to the needs of school-aged children and the amount of time to be spent traveling to effectuate the parenting plan. The parties disagree as to how many phone calls and prison visits the child should have with mother. Father contends that it is 1 hour and 20-minute drive from Gainesville to the facility where mother is currently incarcerated. Mother estimates that it is a 50-minute drive.
Did you have a conversation for a split moment with our son the other day? So you had the understanding when he was asking about the application that you do not live an hour and 20 or 30 minutes away. You came to the understanding correct that it's only 50 minutes away, 50.
I think it's further than that when I did it on Google Map.
Your Honor, I'm not sure what else I'm supposed to do, so I guess I'm ending whatever part I'm supposed to be doing.
However, the court finds father's testimony on the travel time more credible, as mother has never driven from father's home to the jail, and mother's 50-minute estimate appears to be a generalization of travel between and without taking into a consideration of traffic and the actual distances between destinations. F. The moral fitness of the parents. Father has raised concerns regarding mother's inability to show genuine and accountability or remorse for her actions that led to her conviction for second-degree murder and subsequent sentence of life in prison without the possibility of parole.
Thank you, Judge Jackson, for clarifying. I don't know how tuned in she is to what's happening or not, but we know from one of the released jail calls that she had this whole debacle, tirade, thought process, spin-off idea that because Cranick never said natural life, that didn't mean she got life without parole. It would it was just crazy. I'm like, yeah, you need to grapple onto some kind of hope, but this is not it.
Apparently somebody was telling me, because I've been asking you about this also, please, and help me, Father. Like, I love, but it's like sometimes it's very difficult to work with her. But Cranick never gave me natural life. He just said you have life in prison.
Court sentences you to life in the Department of Corrections.
So I'm trying to figure out what specific, in quotes, life I have in prison.
To life in the Department of Corrections.
Because apparently parole has been approved for Florida.
It was all a lie. Guys, it was all a lie. She lied.
Parole has been approved in Florida?
I'm talking about it on the docket, that yes, it was approved.
It was all a lie. Guys, it was all a lie.
Parole for Florida. So unless it's natural life,
to life.
All I have to do is go to court and get a number, and then it's cut it by a third, and that includes my county time. So if I get 10 years, I've already done almost 6.
Come on, math.
And then for good behavior and state time?
Yeah.
Don't that. See, that is the sign of a fake friend. Yeah, right? Life sentences equal 10-year sentences. What? New York is wrong for that.
I wanted to see her anger level. I wanted to see if I was powerful enough to twist her mind. It was a mind thing. She got mind screwed by me, and it worked.
But she truly believes that she could somehow go to the court, just grab a number like the DMV, just stand and wait in line, and then when they call her number, she goes up and she says, "Hi, I was sentenced to life for killing my boyfriend in the most horrific way imaginable. Can I go?" And they'll say, "Okay, great, we will give you your ticket. Oh, great, you get to get out in 4 years." That's her thought process. Her thought process is it'll get cut down to a third. What will get cut down to a third? Life? What's that number? but whatever number she has in her head would get cut down to a third, and that would mean she would only have to do 10 years. However, she's already done 6, and with good behavior, she only will have 4 years to go. And that's what she's wanted from the beginning. That's why she turned down the 15-year plea deal, because from the beginning, she wanted to nickel and dime them, and she wanted 10 years. That is what most conversations pull together, that she would have been willing to take a plea deal if it were 10 years. But have it be 15 years? She says no. And now she's here. And now she thinks a life sentence is just a veiled way of saying 10 years, but only if you ask for it? I don't know.
Can you please can you research it, please? I don't have anybody else to ask in Australia, which is not the United States of America.
What?
I have no idea what to look up or any kind of anything. But can you look up to see if it was actually passed or like what?
I'll look it up right now. Hang tight.
And I don't understand how nobody, including effing Josh Adams, who I've asked 4 times, what, in quotes, life
To life.
in prison do I have? Because all it was he said, I sentenced you to life in prison.
Ms. Boone, court sentences you to life in the Department of Corrections.
Collected his belongings, fixed his robe, and left the courtroom. So I'm trying to figure out what life
To life.
do I have, and nobody can tell me.
Okay, hang on. I'm going to look that up right now.
But the word natural never came out of his mouth. And this is what I've been trying to find also out for peace of mind.
Okay, so Sarah Boone was sentenced to life in prison.
Court sentences you to life in the Department of Corrections with credit time served.
On December 2nd.
Where are you reading this?
Through the internet.
So there's got to be some kind of like official, lawful court document that states if it's just life,
To life.
or it says natural. But I was clearly competent when I was sentenced, and he did not say natural life.
To life.
And if you recall, that was one of the biggest things on social media afterwards. The shitstorm was wondering if it was natural life.
To life.
And everybody was upset with the judge.
What? Who said that?
That he did not clarify to me what type of life it was.
To life in the Department of Corrections.
You're saying so Florida does not have parole for second degree or for...
Correct, right.
And that was just passed.
You have 1 minute remaining.
Right.
I'll do this research and then I'll shoot you an email with what I find.
Please.
Okay.
And I'll call you tomorrow. I mean, am I able to call you tomorrow? I mean, I know not right after it happens, but in the afternoon?
Yes.
God bless. Please look this up. I'm grateful for this, and it would just help me big time with it would just help me make me okay? If I knew that I had an eligibility other than, having to go back to court and all that.
Get used to disappointment.
100%.
And I wonder if it's just the girls, like, pranking you now? Because how are there 64, 81 girls back there and you don't know? That makes no lick of sense. Natural life is a legal term. However, in, 1995, wrote that down somewhere. Yes, in 1995, Florida abolished parole, meaning life is inherently natural life. And I either said it earlier in this video or in a previous video, but Florida does a gain time system and not a parole system. So some sentences in a parole system, you can get a life sentence and within 20 to 25 years, you can be put up for parole to see if you've had good behavior, have you shown remorse, changed, yada, yada, yada. People hold out hope for that, but not many people actually get it based off of these type of offenses. However, what we heard from her plea deal explains gain time, which was you were given 15-year plea deal, you would have had to serve at least 85% of that, plus good behavior would allow you to shave time off your sentence.
Do you understand that if we were to proceed to trial in this matter, and if you were found guilty, the lowest permissible sentence that the court could levy in this case would be 22.5 years in the Department of Corrections? Do you understand that? Do you understand the state's offer to resolve this case?
15 years to a lesser included charge of manslaughter, with the understanding that she would serve 85% of that sentence.
That's up to the department and her behavior, but that is my understanding of the section.
Ma'am, Understanding the state's offer, do you wish to accept or reject the state's offer to resolve this case?
That is a very, very simplified version with some issues, so this is just to give you the essence of the differences. And the thing is, she couldn't get that anyway because she has terrible behavior. Which also, I do have this whole DR saga that I was going to get into at some point. When am I going to get into it though? I don't really know. And this video is already taken forever, and it's going to take forever more because we got a lot left to cover. Should we do it? Yeah, okay, fine, calm down. We're going to do it. Why not? Detour number 3, 4? Detour number, I don't know.
Sometimes I'll start a sentence, and I don't even know where it's going. I just hope I find it along the way.
Anyway, let's talk about Sarah's DR Saga report. It was just a mess. And it didn't really have to be, but because it's Sarah, it turns into a whole shitstorm. What had happened was, she was supposed to have a hearing for family court where she was going to be on the telephone again, and she wanted to bring her tablet in. She wasn't allowed to do that. She should have known that by now. You have to check out these tablets, and there's check-in, check-out stations, kind of like a library book. You think you can just take it out and just take it out? That's right, Paulina. There's protocols and levels to this. You can't just take a tablet willy-nilly that has access to, I don't know, whatever kind of apps or the internet or whatever. So, because Sarah is a genius, she not only takes this tablet in, she immediately goes up to the front desk and says, hey, how do I get onto the Wi-Fi so I can use my tablet illegally? And then that caused a whole stir, and then she got called out for it, and it turned into a whole big mess. So let's dive in.
So, can you bring your tablet?
I'm hoping so. I'm going to bring it with me anyway.
Inmate Boone Sarah is being charged with 910 lying to staff member or others in official capacity or falsifying records. On May 29, 2025, at approximately 10:29 hours, while assigned as classification officer at Lowell Correctional Institution Annex, while present in classification, I was approached by correctional sentence technician A. Sims, who informed me that inmate Boone Sarah was attempting to bring her tablet with her into her telephonic legal hearing, and had informed Miss Sims that I had given her permission to do so. At no time did I give the inmate permission to bring her tablet to classification. Inmate Boone, Sarah remains in general population pending the disposition of this report. The imposition of additional suspension of privileges and penalties was made to reinforce positive principles that could impact the inmate's overt behavior and thinking. In this particular case, the inmate stated she was given permission by classification officer Bowen Walker to bring her tablet to a legal call when she, in fact, did not have permission. Inmate was sentenced to 30 days canteen suspension from 6/5/25 to 7/4/25. It was my complete misunderstanding I could bring my tablet to my legal call.
I'm hoping so. I'm going to bring it with me anyway.
Which had most of my documents I needed for after speaking to Miss Santiago about everything regarding my family law case. Miss Foss and trying to speak to the warden and trying to receive physical documents to not use my tablet. In all the emails, phone calls, and messages in Rex, I misunderstood I could use after meeting with Miss Santiago and discussing my options to be successful in my cause and case. We talked about many things where she was extremely helpful, and I did not understand about this. I would never disobey any rules of DOC
I'm going to bring it with me anyway.
or take advantage of the classifications department with ongoing, very needed help. I would never.
I didn't mean for this to happen. Please wholeheartedly know that, and always, I would never.
Please allow me to speak at, I'm guessing, her hearing, because of course she's going to try to appeal this. I didn't lie. I just didn't know I was lying.
Well, I need for you to please send 2 emails to the warden and to the head of security, please, for my hearing.
Okay.
But I need for you, please, to do that because I haven't had my hearing yet, and apparently it's more serious than what I'm thinking it is. So, like, a lot of the people that have been here for like 30 years are telling me that I need to do whatever it is I can to help save my ass. I got to try and do whatever it is that I can in the meantime. Like, this is serious, and just, like, this is serious, and on top of everything else, and this pretrial statement is driving me crazy, and just this parenting plan, so it's a lot, please.
Yeah.
Peter.
The stakes are still the same, though, right? Like, it's that they'll take away your privileges and send you back to the other building, right? Which is not a good thing.
Right, they'll remove me from the incentivized program, which I worked so hard for to get here by being a role model inmate and abiding by all the rules, and I would never do anything differently.
So, can you bring your tablet?
I'm hoping so. I'm going to bring it with me anyway. Like, I didn't lie. I'm going to bring it with me anyway. I mean, everybody was like, how else were you supposed to utilize your pretrial conference without your tablet? And after she's done everything with me and you and everybody else with the correspondence, you know, one way or another, I read between the lines that I could take my tablet.
Oh, so now we're reading between the lines. Okay, I see. That's not what you told everyone. You said you were given permission after talking to Miss Santiago and all these other people that you could take your tablet in there. You got confronted, you blamed it on someone else, and then you were punished for it. Now it's, well, I read between the lines. That's not getting permission. And this all happens because it's just the way that she operates. She can't take responsibility for anything she does, so she immediately points the finger to someone else and then gets floored when it comes right back at her.
And nonetheless, they should know, too, by me not taking my tablet, that I have no other access to the court.
Right.
It's crazy to me.
Yeah.
Like, this is such a big deal. And, Peter, you have to understand, I left. She kept telling me it was okay. It was okay. It was okay. I left with my tablet thinking that it was okay. And then 4 hours later, she wrote me this DR, and I was served the next day with it.
Who did, Santiago?
Yes.
When she said it's okay, what, when you were in that room, she saw that you had the tablet and said, why do you have your tablet?
I came in the front door with all of my paper in my my tablet, and I went to the front desk and I said, how do I log on to Wi-Fi or whatever it is in order to utilize my court documents? And then from there, the front desk lady went back and got the security person, and she came out and asked me, who gave you permission? And I said, Miss Santiago. So then they went back and got Miss Santiago, and Miss Santiago came out yelling at me that she never gave me permission to bring my tablet. And I said, I never would have brought it if you didn't. Never would have brought it if you didn't. I'm going to bring it with me anyway. And so then another sergeant came in and told me to stop talking and yelling at me in front of everybody. So I have like 4 people yelling at me, and then Miss Foss came out there behind. And I'm in my head, I'm like, Peter, what is going on?
What's going on is you are a liar.
It was all a lie. Guys, it was all a lie. She lied.
That is why all of this is happening. She doesn't get, she really thinks the issue was her having her tablet is why she got the disciplinary report. No, it's because once you were caught, you lied and said you got permission from another officer. She doesn't get it because it's no big deal to her, but let's reframe it. She said, another security classification officer gave me special permission to have an unauthorized tablet that has access to Wi-Fi and internet in an unauthorized space. That's right, Marty, you tell him, without letting anyone else know. You're saying that you're having 4 people yelling at you to stop talking. You're being all nice about it now, but that's like you're yelling in there. If 4 people have to tell you to stop talking, and what does Sarah Catherine Boone Paulsen do?
Stop talking! You are insane! My God! I am an absolute failure!
She keeps talking. She's always going to have the last word. And she just said, I never would have brought it if you didn't.
permission to bring my tablet, and I said I never would have brought it if you didn't.
Never would have brought it if you didn't. I'm gonna bring it with me anyway.
That is a lie. Just like she thinks she's being punished for calling the police.
I lied to the police. Basically everyone, because I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought they were going to help me, but instead I was arrested for calling 911.
And not for murdering George. She thinks she's being punished for needing access to her documents and not for lying and blaming a correctional officer who could lose their job if they're found giving preferential treatment that is illegal.
And so then they all went back there, and then Ms. Santiago came back out, and she goes, we all know that you need this, so you can use it this time. So I went back there, and I kept profusely apologizing to her that I had my tablet, but I thought I understood that I could have it. After talking to her 100 times, you talking to her, and everybody else talking to her and the entire classifications department, knowing I had to have my court documents, and knowing that I've been trying everything and then some to get them, but I can't because I can't receive anything from third parties. So she kept telling me it was okay over and over and over again and told me to focus on my call. She knows how hard I've worked for it. And then I left and still was trying to profusely apologize to her. And then she kept telling me it was okay, it was okay. And the next time to send the inmate request form, and she would give me instructions on how to do it properly. I left with my tablet and everything was fine. And then again, 4 hours later, she wrote this DR, and then the next day I was served by a sergeant with it. It's a total WTF moment. Like, I'm confused. Is it okay or it isn't okay? Because obviously it's not okay.
Can you bring your tablet?
I'm hoping so. I'm gonna bring it with me anyway.
Yeah, that's weird. So you had this thing happen, and then you had your call, and you took your tablet in.
Yes, I walked in the door with it, showing it to them, asking how I'm supposed to log on so I can utilize my court documents. And then from there, everybody freaked out, where it's like, what is the big deal?
The irony there is that she did the exact same thing, or those were the exact same circumstances when she went to originally go get her phone before getting interrogated. Sarah, the woman who knowingly knows that she killed this man the day prior, and for some reason they did not arrest her on the spot, is away from the police and decides on her own to go back to the police station. And not only that, then go to the front office or whatever and say, where can I get my phone? Do you have like a little closet for killer phones that you hand back to the killers? And that's when Scott came out, took you away, and made history. And so what do you do when you take an illegal tablet that you know you did not get permission to have with you? You go straight to the front desk and say, how do I do this thing illegally? Because to be honest, if she did her schemes the right way and just avoided the police originally, she could have actually talked herself away from this. And if she didn't go to the front desk and ask for the Wi-Fi password, she probably would have been able to have her tablet. Figure that out later. I don't know. But that's wild to me.
And it's just, there's a whole lot of, it's just stupid, and it's convoluted, and it's unnecessary. So I have a feeling, because of how fantastic Miss Santiago really is as a human being, that she was okay with it, and she understands all the BS that I'm going through. Then, like, somebody came back up in her office and said, you can't let her get away with that. That's when she wrote the PR.
Probably Miss Foss.
Right.
Right. Just got to make sure to point the finger at someone else, because it can't be your fault. Like you said, this was just, what's the big deal? This is unnecessary and convoluted. Absolutely. It could have been as easy as, oh, I brought my tablet. Sorry. And then accept whatever punishment they have, which honestly, they probably would have just yelled at you and then moved right along. But you said, no, I am allowed to have it because it has all of my court documents, and I got permission from Miss Santiago in the back, and she said that I'm allowed to have it. And then you just made a whole storm. She comes back and says, I didn't allow you to have that. Why are you telling someone else that I gave you permission? And I said, of course you told me that. I never would have brought it if you didn't.
Permission to bring my tablet. I said I never would have brought it if you didn't. Never would have brought it if you didn't.
That is insane, because that's what she's recounting, meaning it was even more elaborate in the moment, or even more committed than how she said it then. So she was trying to actually argue, I didn't break the rules that I knew I was going to break, even if it were a rule. Regardless, I said I was going to bring it with me anyway. Now you all are mad, and I'm going to say it's you're mad because I need my documents. No, it's because you think you can lie your way into any kind of special treatment imaginable. And if you're questioned, well, you always have an excuse. Well, I'm poor. I don't have this. I don't have that. Everyone in jail has issues. That's just a fact. Odds are you wouldn't be there if you had zero issues whatsoever. And by issues, I mean obstacles and circumstances. However, she thinks her obstacles and circumstances are above everyone else's, so it should be fine. And the way she's collapsing time here makes zero sense. New York is trying to ask,
When I think of Muslim, I don't Muslimanity.
No.
When I think
Islam.
When I think of the Nation of Islam.
No, not the nation. Just Islam.
Islam. Okay, I could just say that.
oh, so they told you could have your tablet? Yeah, I go in there and they said it's okay, telling you it's okay. If they have to repeatedly tell you it's okay, it's because you are incessantly trying to fake apologize and going again and again. She said this often. People tell me to stop saying thank you. And she thinks that's a compliment of people think I'm so complimentary that they're telling me to stop because I'm doing it too much. That makes me an amazing person. No, it's hollow and it gets faker the more you do it.
I think he likes me just in a weird way. You know what I'm saying? Like, I don't know if interaction is a thing with him. I don't know. But I told you yesterday, he thought it was weird that I kept thanking him for my job.
So she's going back there and profusely apologizing, and they're saying it's okay, get out, do it the right way next time, because she thinks, just like she did with the interrogation, as long as I go back there, I can say the right words to get me out of trouble, and you'll just forget the actions that I did. No. You still did the actions, so you still got written up.
So I'm just massively confused. I'm sick to my stomach. I can't freaking concentrate on anything because of the sheer terror of me being removed from this program for a misunderstanding.
I'm gonna bring it with me anyway.
Okay.
It's just mind-blowing to me. It's just mind-blowing. Out of all of the effed up things that go on in this compound, they're worried about me being successful in my pretrial conference with my tablet. It's just wild to me.
It's nuts.
And then strip me of everything else that I've worked for, and like I said, led up to me being an in quotes role model inmate, which is why I'm here in the first place, because they chose me to be in here.
Wow.
And so every day I don't sleep, every night I don't sleep, because I'm terrified they're going to wake me up in the middle of the night, tell me, you know, I have to pack all of my stuff, I have to drag it all the way over there, I have to stand there handcuffed holding all of my stuff, and you don't understand, 90% of my belongings, because I don't have anything else, are my court documents that I have from my criminal case that I might be doing something with at some point in my life when Josh Adams contacts me.
Which is hilarious, especially since now John Adams isn't even her appellate attorney anymore. But she kept all of her criminal trial paperwork in case John Adams contacted her. One, of course, she doesn't have real friends to explain to her that's not how any of this works. Two, she's just dumb if she thinks she has files on the inside that he would not have access to on the outside. He has the whole court docket. He has absolutely everything he needs. He has access to your discovery. He can request your discovery if he needs more copies. There is nothing he can get from you that could help him. Plus, he would have to schedule a meeting to sit with you and actually receive stuff from you. And I don't even know what the protocols are between inmates handing over things to their lawyers unless they are in a meeting, like mailing them to them. And that would be a whole mess because she would want to talk with him and game plan and strategize. That's why she still thinks this appeal is to prove her innocence, because she has no concept of what appellate work is. And she complains ad infinitum about James Owens not giving her back her family court documents. I don't even know what those documents could be. It's probably like 4 packets that mean absolutely nothing because she has everything else. James never took over her family court case, so I don't know why he would have all of her documents. It's just something she's saying because she said this with literally every attorney ever. They all stole from her and are hoarding her discovery for some reason because she is that important. And then we find out in other calls or something, and I'm probably not going to look for this one, but she asked for the information on the jurors. She wanted to know the jurors' names and contact information. And I'm like, that's exactly why your lawyer cannot give you these things. She is not supposed to have a lot of her discovery, especially any files that contain sensitive private information of witnesses, of jurors, of judges, of lawyers, of anyone who can be involved in this case that she can harass. She's not supposed to have it. But if she wanted the depositions and the blood work and the DNA test and the crime scene photos and all that, they can probably give that to her. That just means she has that under her bed every night. She has piles and piles of paperwork proving that she's a murderer, that she's holding on to just in case her appellate attorney one day might potentially reach out to her and ask her for something. Yikes. And if that's most of your property is 90% paperwork, why are you so freaking out over having to pack up your stuff and hold it there? If it's just a box of papers, it shouldn't be that big a deal. And he asked like, oh, then they're definitely going to move you if they do that. No, they make you pack up as part of the whole ritual of it. It's partly shaming, partly punishment as well. You need to feel like no matter what, even if you are allowed to go back, you could have gone away. So next time, act right. But it's so serendipitous because in the criminal trial, all she did for years was beg for that paperwork, beg for the hard, physical copies of all of her discovery. And after begging for years and years and years, she finally got it, couldn't fit it all in her area, and now that consists of 90% of her property. Because they also had to throw away some of her other property because they have like property storages outside of the jail or wherever they had them. And to make room for all of her discovery she wasn't allowed to have but bullied people into getting, she had to get rid of some of that. So now all she has are those files.
We could not send all of those boxes with you to the jail, and the jail advised me that they cannot take all those boxes. A process had to be created to make sure, and this is the process.
The process that I was explained after speaking to a couple of sergeants, and I've been waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed to anything that's on a laptop.
I understand that's your preference, but I can't do anything more than what I've done right now.
I understand. And I have had other information given to me, which is why I've been waiting for the boxes for them. I guess I will figure that out because if I'm up at 2 o'clock in the morning, I can't utilize the laptop, which is another reason why I was looking forward to the hard copies.
Mr. Lane also took possession of the hard copies. Have those been provided to you?
They have. They were waiting at the dorm for me upon my return of the last hearing.
Okay, and where are they currently?
They're located at my bunk area.
Okay, and what are they stored, or how are they stored?
The hard copies you're referring to?
Yes, ma'am.
The 2 boxes are at my bunk on the side in between other bunks.
Wait, she has the literal boxes? What happened to this property bag, miss? I know all the protocols and solutions. You have the literal boxes. This should be your happiest day ever. You have been searching for those boxes for almost 5 years. You have been begging for every single file to see in its entirety, every single page. And you have the literal holy grail mythic boxes right next to your bed. How dumb can you be? Oh my gosh. You could lose all of that. And then that's your discovery. And it's gone. You have the digital one that you don't like, but that is, wow. Whew.
Okay, all right. Are they in some type of bag, or is it just the 2 boxes that are right there?
It's just the 2 boxes.
Okay, all right. You understand by keeping those boxes there may be a risk as to other persons looking at them.
I don't have any other choice.
Are you serious? They created a whole process for you to have another choice so you wouldn't be stuck with boxes where they're not supposed. Oh my.
Do you understand that it's your request and choice to keep those documents in your possession?
I do, and I'm also requesting in my letter to the captain and to the major to also be able to store all of the USB drives and the hard drive in my locked drawer, also for an extra security measure.
What are you talking about? Oh my gosh, I fear she might actually just be not intelligent. Are you kidding me? You can't even store the paper copies, and you said, now give me the digital, completely all of my discovery, everything, no other safeguard. Give me all of it so I can unsecurely have it by my bunk.
Number 2, USB drives. It's a matter of security. The metal tips, the drive itself can be fashioned into something other than what it's originally intended for. These items are secured in a secure control room.
I understand the process. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why, other than the fact that the assumption could be made that it could be made into something other than a USB drive. And I'm trying to avoid any further leaks of information that could possibly be suppressed or utilized in my case. So I didn't know if I could have my hard copies. I'm unclear, other than those reasons, why I cannot have those as well.
And Judge, if you recall my request, I had asked for all of this to be placed on a USB drive so that we would not have the paper in the jail.
And I understand that. And Ms. Boone has continued to request the paper copies. And that's why everything was digitized, so that she would have that access to it. Everything has been digitized, but she has continued to request for those, and we're trying to make that accommodation for her as well.
Scott, if everything's digitized, why do we have to get the paper?
Great question.
That's up to her if she wants paper or not. That's fine.
All right.
It was never my decision to have anything digitized in the first place, and nonetheless it's being put on a laptop that is not even fully accessible because some of the programs do not work, which I have not had the time yet to continue to go through everything that are on the USB drive.
Wow, it's almost like we told you you wouldn't have space, but I have a property bag where I can put all my pages in there. You get the property bags. Well, the property bags, they're not stiff enough, so the paper, it's just a lot of paper. And because she's in jail and she can't have metal or elastic or anything, all of the staples were taken out of those thousands of pages that she begged for. So it was all just loose paper everywhere in these cardboard boxes.
Property bags that you all do supply, there's no rigidity to them whatsoever. It's just a floppy bag. So when you pick that up, everything goes in the middle. So there's no type of there's no way of actually being able to make sure that one pile stays in the one pile and so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to keep those together?
Oh my gosh, why are we still in court over this? She had it on a nice, neat jump drive, didn't want the jump drive, hated it, complained about it nonstop, even though they were trying to help her. Then she gets what she asks for. Isis, the ice maker, knows where this is going. So let's get there. She gets the property bags. It doesn't fit. The papers everywhere. She complains again. She says, I gave back the second property bag because they gave me 2. And then the solution at the end of the day for all of this, after she complained about not having room for the boxes are encroaching on other people's spaces, the papers are loose and they're everywhere, and she doesn't even know if everything's there. Of course, she's going to say that everything's still not there. The solution was a third property bag.
Boxes are not authorized by the fire marshal. The fire retardant bags are. So the documents are going to have to come out of the cardboard box and into the fire retardant bags.
Ms. Boone?
I would have to figure that out for the voluminous amount of paperwork that are contained in those 2 boxes.
Yes, the 2 boxes that you beg and pleaded for, that you made everyone's issue. Don't act like it's an inconvenience now. I told you, I didn't want to hear about it.
There is no way to organize or separate, so it would just be a large mass amount of papers. So if I may, in the meantime, try to come up with some type of organizational structure of those 2 fire retardant bags with my hard copy discovery enclosed in those. If I could please do so.
So now you want the second bag. So they gave you the second bag, you returned it, and now you want it again.
Mr. Chavanel,
Captain Giovanni, is there any way we can give her an additional bag or so and she can switch it in and out of property or whatever it may be? Can we provide her an additional bag that may help her to separate her documents?
Oh, another bag. A third bag. 1 bag she takes, it didn't work. 2 bags she gets, returns 1, and so the solution is a third bag. Whew. During that hearing, I lost my mind a little bit. Like, this is the dumbest shit I've ever heard. And it's only because she wants what she wants, how she wants it, but she doesn't know what getting what she wants actually means or looks like. So then when it happens, look at her, egg on her face, doesn't know what to do with it, and still is going to blame you for it. So when she says, I have nothing in my drawer but lint and old newspaper from the last girl, I could be living comfortably, this and that.
It's like I'm in this fabulous dorm and everything, but I just have nothing in my drawer but rust and the old newspapers that the previous girl left. And if would be paying me something, or at least, just something, I would have something in my drawer. And it's just like out of $61,000, I'm supposed to settle for what he's trying to throw at me or nothing. Like, I could have been living comfortably, not being like shaky and, dysfunctional and just.
Have you thought about sending him a letter and him and his attorney and saying, hey,
I'm not doing that. I'm not surrendering ever.
Well, no, you traded in your comfort for all of those files to try to slander George and say he killed himself the day I murdered him. And you fought so hard for those papers that specifically detailed every which way you were guilty.
We, the jury, find the defendant guilty. Electric chair.
Oh, shit. God damn it.
Electrocute that bitch. And I want you to pour some water on her first. Jury seat number 3, is this your true verdict?
And now you get to hold on to them forever. I wonder if she's actually ever going to throw them away. What would be funny is if all the files are annotated with her handwritten notes like she wrote on her medical records.
When I tried to review some things with regard to discovery as to things I wanted to make sure she was aware of, she walked out. She has asked me repeatedly for a copy of some medical records. Based on the discovery I got from the previous attorneys, one of the copies of those medical records had her handwritten notes. So she had a copy given to her previously. She'd reviewed them with previous attorneys. I sent her a new copy. Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to, and you try to explain that to a client.
How are you going to write handwritten notes on your medical records to tell your attorneys either X, Y, or Z? Probably saying, don't listen to that, I actually told them this. I don't know, that's just real funny to me. Half her belongings, or 90% of her belongings, are just the papers that she begged for. Personally, those papers would haunt me.
And I've got to just stand there for hours and hours and hours until I go in front of the board, who know nothing about the situation, who don't know me, who weren't there as a witness, to judge me and then take everything away from me.
Well,
it's ludicrous.
Ludicrous going in on the verse because I've never been defeated and I won't stop now.
Yeah. Who are the emails going to? One going to Santiago and one going to Foss?
No, it's going to the warden of the entire FDC compound.
Okay.
And then it's going to Frank Gatto, who is the head of security.
Okay, cool.
These are the two people that three of these ladies that have been here forever and a day, decades, and said, this is how you're supposed to go about doing it. Please. And you are involved with this, too, on my side because you've contacted everybody. They all know you, too, because you've been like a pain in the ass, like I've been a pain in the ass trying to figure out how to get my damn court documents that they just reprimanded me for having them on my tablet.
Inmate Boone Sarah is being charged with 910 lying to staff member or others in official capacity or falsifying records. That's a wild statement to say. This involves you too. You're a part of my lies as well because I have made you pester them as much as I have. That's insane. She's literally like wrapping you in because she hounds you to check incessantly, nonstop, while she's also doing the exact same thing from her side. Now you're equally as involved in her lying about another correctional officer giving her permission that she did not have. So it's almost like you're in trouble too. So you better send this email to these people. Does she not? Just how dumb that sounds. I got written up for something I did inside the prison, so I'm having a friend on the outside write a few emails saying, hey, she didn't mean it, it's okay, that's not what happened. And then she says, and a judge who doesn't know me, wasn't there, didn't see anything, is going to pass judgment on me. Hey, fun fact, that's how every case works. That's why you have a neutral judge. Someone who was not there, does not know you, is not going to give you the preferential treatment you beg for, and is going to hold you accountable for your actions, not you as a person. She can't see past that.
After she, in between the lines, told me that I could take when she went over my inmate request forms, and the tablet in my pretrial conference preparation was one of them.
Yep, 100%.
Thank you. I'm not wrong.
No, but I think the way you want to approach this is just, at the end of the day, like, I think you just want to say, look, just keep with the whole, it was miscommunication. You don't want to say, like,
I did.
You know what I mean?
And I am.
Yeah.
I'm meek and mild, and yes, I take full responsibility. But please understand this, I did not lie. Wholeheartedly, I did not lie.
Yeah.
It was a misunderstanding.
Can you bring your tablet?
I'm hoping so. I'm gonna bring it with me anyway.
So this is very serious, and like I don't know.
What if I just sent her a personal note and just said, hey, listen, I spoke with Sarah. I'm not trying to get in the middle of anything, but I just want you to know that truly, she was just confused, I think, about what happened. She was not trying to be sneaky, or do you think that might piss her off?
I don't know.
Yeah, I think that might piss her off.
It is.
So what happens? They make their decision and whether or not you stay where you are,
Or if I get put into an awful, wretched, no air conditioning dorm. This is very serious, and it goes on my record, which is terrible because they're accusing me of lying to staff, which is really awful. I don't do that.
Can you bring your tablet?
I'm hoping so. I'm gonna bring it with me anyway.
I lied to the police. Basically everyone. Because I was extremely fearful of being arrested.
I don't want to get arrested. I don't, because I fought for myself, and I have my 8-year-old, and I just want to go home and sleep in my own bed right now. But I did fight back. I'm not going to lie. So.
How come when he contacts you after you know he has a no contact order, why don't you call the police?
I don't want to get in trouble.
Why are you getting in trouble if he contacts you?
I got in trouble last time.
One last time.
I gotta take my son to school tomorrow.
Look, can I tell you something before you call and whatever? I've been arrested before because I fought back. I didn't fight back. I didn't fight back. So whatever he has or whatever it is, it's not me. I'm not getting arrested.
No, I'm getting a statement from you. You're not being arrested. So,
Okay, look, I'll come over and see you on my side.
come on.
Thanks, ladies. They know.
Let's get this done.
They know. They know.
Okay. Now, would you come in here so we can do your statement, please? And stop this. Sit down at the table and let's get your statement filled out.
He didn't believe I would ever do it. I'm not getting arrested.
No, you're not getting arrested. I've already told you that.
I'm not getting arrested.
Nope, you're not. Did you do something you should be arrested for?
No.
Okay.
For the last time I fought back.
And so Tuesday morning at 6 o'clock in the morning, I have to pack all of my belongings, all of my casework, all of my criminal casework, my bedding and everything, and take it with me to this board hearing and stand in front of everybody and justify my case.
Oh, so chances are they're gonna move you, and they're making you bring all your stuff, right?
They do that just in case.
So have you thought about what you're gonna say?
Yes.
What are you?
Same thing I've said 2, 3, 4 times already, and written it to her twice in 2 inmate request forms.
Yeah. Wow, that's.
After all is said and done, and that happens to me. Over that, nonetheless, that she is fully aware of that I've been desperate for my casework. It's crazy.
Wow.
But
Okay.
that's going to be what it's going to be. So it's very serious, and I want you to know that. So if you don't hear from me, something has happened. But trying to do that, and then remember, I have this pending DR on Tuesday, so I don't know what that's going to do to me. Everything else?
What are the people, like all the other inmates? What do they say about that? Do they think that you're gonna get booted?
They don't know. They say to me, which numerous ones have told me, even the hardcore ones that have been here forever and dealt with things like this, is that they will do what they want to do. It doesn't really matter what I say. It just, a lot of them say it depends on what mood they're in that day.
Wow.
So not only do I have this and the pretrial statement, and then also the parenting plan, it's a lot right now. And I definitely cannot do this by myself.
Since you got your degree and you know every fucking thing.
Yeah, it's a lot. It's definitely a lot.
Well, after I found out about this DR, I came back and I threw up. I was so upset about it. I haven't slept. I toss and I turn, and all I do is worry about all of this. And this is a lot. This is a lot.
I didn't lie. I just didn't know I was lying. Just a mess. And I'm going to stop it right there because I do have more to that saga, but I think I'm going to make a full video out of that. So I try to hold back my commentary on the last little bit, and we'll explore it more there. But all of that to say, she thought she had other options than life without parole. So I am so glad that Judge Jackson finally told her, you have life without parole. You didn't hear it clearly enough. Not enough people told you. I'm going to write it to you point blank period in this family court order. Hilarious. But it's true. Eons ago, when we were actually talking about the final judgment, they were bringing up the moral fitness of the parents and how she has no moral fitness. She has no remorse. She doesn't feel bad about literally anything that she has done. She feels bad because of the consequences, not because she actually feels bad for the other people. Because if she did, she would never have been able to do what she's done. And that's why Mr. Cacciatore laid out the facts. And he did this for the cameras. He didn't actually have to do it for the trial's sake. But when he gave the explanation of our plea deal of 15 years was contingent on the plan and the agreement that she would come in here and accept full responsibility and show remorse for what she's done.
My plea offer is put forward, and there's something very critical to that. It's 15 years in the Department of Corrections, but it's predicated on something. And the consideration that it's predicated on is the defendant coming to court and accepting responsibility for her actions. For her coming to court and saying, I am responsible for George Torres's death, and I accept the punishment that comes with it. And because that consideration was never given in this case, the offer of 15 years in no way represents what this case is worth, or what George Torres's life is worth. That is an offer predicated a circumstance of a first-time defendant accepting responsibility and giving every benefit of the doubt in coming to court and saying that they are ready to be punished. Those conditions were never met. She has never shown remorse for that. She didn't show remorse for that here today. She again painted herself as the victim. She's the victim of George Torres. She recounted the litany of deeds and mistreatments that he perpetrated upon her. She's the victim of George Torres' family. She's the victim of the police. She's the victim of social media. All about Sarah Boone. Everything's about Sarah Boone, about how she is the victim. And Sarah Boone sentenced every one of George Torres' loved ones to a life sentence. Just like she sentenced George Torres when he was in that suitcase. There is no valid basis for a downward departure in this case. She deserves a life sentence. Thank you.
Those are unacceptable terms that she rather sit behind bars for the rest of her life than admit she is a despicable, deplorable, depraved heart murderer. G. The mental and physical health of the parents. There is no evidence presented as to this factor. H. The home, school, and community record of the child. The child currently attends and is enrolled in a biotech magnet program. The school is located miles from father's home, and father is responsible for 100% of the child's transportation to and from school. I. The reasonable preference of the child if the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference. Not applicable. It's not applicable because there is no preference to be had. He can only live with his father. Even if he could have a preference towards the mother, there's nowhere he can live. So, not applicable. J. The demonstrated knowledge, capacity, and disposition of each parent to be informed of the circumstances of the minor child, including but not limited to the child's friends, teachers, medical care providers, daily activities, and favorite things. There was no evidence presented as to this factor. See, and there's a nuance here because Sarah went on and on at the trial being like, oh, I know all this stuff. I know about his favorite color. I know about his girlfriends. I know about this. I know about that.
I wanted to find out if you understood that I know about his girlfriends, about his laughing and joking.
Ma'am, we're going to stay on topic with regard to the issues here.
It doesn't include me in any way, shape, or form in regards to anything that has to do with my son's life. I know a lot about my son. I know what his favorite color is. I don't believe that petitioner even knows that much. The name of his girlfriend, the things they're going through. I am part of his daily life. And for him to take that away from me is just out of bitterness and spite. I want to be a part of my son's life. And people forget that I have a pending appeal. So to prove my innocence.
So she never presented evidence that she could demonstrate the capacity to be informed about these things. Moreover, having the knowledge does not mean you have the capacity to be informed. She would have to call to be updated, not that someone can call her and update her or inform her directly. Which, if you're looking at a more standard case where both parents are in the real world and not incarcerated, if there's location differences, if you're still able to be contacted and informed, then you have the reasonable capacity to be informed. She cannot do that. K. The demonstrated capacity and disposition of each parent to provide a consistent routine for the child, such as discipline and daily schedules for homework, meals, and bedtime. There was no evidence presented as to this factor. L. The demonstrated capacity of each parent to communicate with and keep the other parent informed of issues and activities regarding the minor child, and the willingness of each parent to adopt a unified front on all major issues when dealing with the child.
And when she's talking to your son, does she support your decisions, or is she a contrarian? Can you tell me exactly how she interacts with your son?
Mainly contrarian, from what I understand from. I can't hear too much of them because she forces him to make sure he is nowhere near me when he talks on the phone with her.
Okay.
There exists a vexing communications problem between the parties due to mother's incarceration. Father is unable to pick up the phone and call mother, and call mother to discuss day-to-day parenting and decision-making issues.
Practically speaking, if there was a major decision that needed to be decided upon, how would you go about having, if Miss Boone did have shared parental responsibility and was had equal power to make decisions related to your son, practically speaking, how would you even do that if she's in federal or in prison?
No idea. I have no way of contacting her. It'd be sitting around and waiting for her to call or something at some point.
Okay.
This makes it difficult for the parties to confer with each other so that major decisions affecting the welfare of the child will be determined jointly and expeditiously. According to father, he sometimes receives calls from mother asking him to buy things for the child or yelling at him. And we definitely know that to be true from all of the text messages. We know she abused him in the text messages, but she also decided she was going to send messages, wasting 50 cents each time, as phone confirmations so that she could write down her own narrative of what they talked about over the phone. And even her own recountings show how abusive she is. It's insane. All the money she wastes for nothing, all the annoyances, all the begging, all the pleading, all the demanding. And then she documents it like he is the abuser.
How would you know if it was legitimate or not? You don't answer. I have nothing ever to speak to you about in regards to anything other than our son. I have nothing ever to speak to you about in regards to anything other than our son.
If there is a conversation you want to have about, you're welcome to have it with me. That's not what you call for.
What else is it that I call for?
To yell at me about some random thing, or tell me I need to buy things for.
You do realize, Brian Calloway Boone, that you are under oath.
I do.
Phone call confirmation, possible appendix bursting. Quote, I can't tell the future. My appendix could burst and I couldn't order blank. This morning when I was made to call you for order confirmation numbers, blank any of my almost 100 tablet messages I've sent to you attempting to blank. Judge has ordered you to provide me in the form of coffee and food. Blank reasonably want. You seem to be able to tell the future of a guilty verdict.
We, the jury, find the defendant guilty of murder in the second degree.
Blank think you know so much about and unnecessarily tell my son. How blank coffee and food package I'm still asking you about 6 months for blank food.
What else is it that I call for?
The surety of your futuristic prediction was, quote, it's close to blank, 150 miles away with my son. How about this? But not ordering my blank, asking you about 6 months for coffee and well over a year for the blank, about your appendix bursting, the reason you stated you, quote, should be blank and food hopefully today. You stated, quote, you can try. When I said I'd call blank confirmation numbers for my orders you could place while outside, blank could have just ordered a year ago or the 6 months when I started blank it. I wouldn't be calling you today or sending you an almost 100th message blank wasting money and with still no response from you. So I know, and blank sending a message wasting money. If you would just
Send me money, send me money, send me money.
cooperate, blank appendix bursting. It's because you're bitter and sad and unhappy. Blank your fat quote power of your little raisin of a heart to try and make everything blank. Such a boring child.
Was that a read?
Yes.
Remember, it's a big inconvenience for you living blank here to be told the same thing from the judge. To cooperate. Blank, you keep bothering everyone. The judge, your attorney, even our son. Blank will not cooperate. I'll send another message tomorrow and call blank you. Please just cooperate and order and stop being so immature. Blank contacting you in any form. Please cooperate. In the meantime, blank burst and you are able to finally safely order my coffee and food.
What else is it that I call for?
Coffee and food. To Brian. Phone call confirmation. Per our phone call this morning after you not responding to any of blank, anything you stated the following. You have not scheduled a video visit blank other for a regular or Christmas visit. See prior messages requesting blank. Not use that as an excuse you have many times previously. You blank presents still to date and quote, should this week. You've been telling me blank turned into months. I gave you his list from me December 6th last year. Blank ordered yours from him. It's ongoing March. You have not ordered. Blank, quote, you've been busy. But you kept telling me you did, and I kept asking blank for me after you repeatedly kept telling me you did. Nothing has been blank. Nothing came today. Another week. You are going to send a message blank. Numbers for the following you are going to finally order today.
What else is it that I call for?
Hot blank wings meal 2, coffee packages, jumping Java food packages. Previously, you were going to order, and I would like also, especially blank, received, Valentine's Day most recent, and my son wants to send me blank. Keep telling you've ordered this or are going to since December 6th of blank. The time to look up for me on the internet while we were on the phone. Blank, please order. Just the hymnal is all I'm asking for. You blank a video visit with my son for the upcoming weekend, hoping Christmas blank, schedule one anyway. 12:30, whatever day, 12:30. Please don't wait, blank. Many times previously, and we've been unable to see each other from blank times 5 minutes you can do from your phone while outside smoking and blank. Not, quote, forget, which is usually your go-to excuse for not scheduling. Blank his phone with so I can speak to him after trying 8 times over the weekend. Blank enable our phone call. I await your highly anticipated promised message, blank, promised orders. You stated you are going to send this message for blank arrival of his Christmas presents and confirmation of our highly anticipated blank or without. We want to see each other. Thank you for your cooperation, blank. Just another, quote, week of waiting for everything still. And I hope you wait years more.
What else is it that I call for?
To Brian, respond Christmas, coffee, food, car, commissary. Have you ordered Christmas presents and promises?
Nothing ever to speak
Once
to
again,
you about and start anything other than our son.
Amazon, drink mix, 2, football, 3, hymnal, $6, confirmation number from Amazon, suitorfriends.com, 1 item, 1 clearly fun fish soap, $9, confirmation item, eye care, 2 items, jumping Java coffee, delicious delights, number of eyecare.com, 2 items, what his Jim's phone number, blank, not going to contact after telling me you are and did. Give me so I can, blank, commissary.
Send me money, send me money, send me money.
Add funds, respond. Before PM to Brian from Sarah. Phone call confirmation. From having to call you on the phone this morning after no response, blank, trying to communicate with you about everything you will not communicate, blank, threatened to hang up on me. You stated the following. Son's Christmas, blank, receiving by Saturday, and will be scheduling a Christmas video visit, blank, Christmas presents from me next Saturday, March 30th at 1:30 p.m. Blank, Saturday, March 30th at 1:30 p.m. Find his Christmas card, blank, I mailed in December. Commissary, you did not
Send me money.
supply the blank. Even after my 2 written tablet messages that day and my attempted blank to confirm you received my messages from no response to either, or blank, forget after doing for over 4 years now, you stated because, quote, you blank. Delicious delights, my solution to not having commissary. Blank, purchase this food package I've been asking about for well over a year. Blank, asking for, which costs the same amount of the minute amount of blank. Don't forget. And you stated, okay. When I asked you when you were going blank, I asked for a confirmation number to ensure order, and I will call back blank. Unfortunately, I have to do without commissary and also the small blank for a half a year now. I should have all. You stated you blank will not come until next Friday. Already, do not forget, blank, son, important. I'll call on Sunday for the confirmation numbers, blank, and also the scheduled date for his dental appointment. You stated blank, hymnal. You stated, quote, will order today, the same time you ordered blank, delight. I'll call for this order number also on Sunday. You stated blank, not have Jim's phone number. Will you under oath please provide... Fuck off. To Brian, phone call confirmation. From being made to call from no response to any of my over 100 messages trying to move forward in anything, I am unable from your continued intentional obstacles and withholding. You stated you have not scheduled son's dental appointment. You will, quote, today. You have not ordered my $6 hymnal. You will, quote, today. You have not ordered Delicious Delights food package. You will, quote, today. You stated I do not need confirmation numbers. How else am I to know you ordered? Because you tell me you did? You are an inveterate liar.
I lied to the police. Basically everyone.
Ever since I've known you. You've even made up confirmation numbers before, so I won't know the difference anyway. Just do. Please, so I don't have to deal with your boring, sad ass anymore. Oh. Ugh, you. Talk to you later. TTYL. Talk to you tomorrow. Ugh. So you're creating new things. Not TTYL, talk to you tomorrow. I'm going to bug you tomorrow because I'm your stalker abuser.
What else is it that I call for?
To Brian. Phone call confirmation. Goody. Today, when I followed up via phone for confirmation numbers from blank, receive coffee and food, especially since you did not
Send me money.
provide commissary blank, you have still not ordered my $6 hymnal. You will, quote, later today. You blank package, Delicious Delights. You will, quote, later today. You still have not blank. You should, quote, later this week. So you can finally schedule our Christmas visit. Blank Jim's phone number to call or provide for me so I can locate my car. Blank messages and you stated, quote, no. Why? How else am I supposed to blank phone when I am forced to call or on the tablet sending messages? Blank response. Why are you like that? You. Please respond or provide the blank over a year for some so I can get on with my life in jail and not have blank to get a $6 hymnal and food from you, not
Send me money.
supplying commissary.
What else is it that I call for?
Brian, phone call confirmation. When having to call you today from no response to any of my messages, blank, received coffee or food as you said you were going to order last blank, and the weekend before, 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 blank stated. Son's Christmas presents we are still waiting to receive for blank video visit are ordered and should be here next week. You would blank after explaining it's for proof of order. You simply said no. You order blank today but did not order my $6 hymnal from the same website, Amazon blank, asked why. You stated, quote, because I didn't. When I asked you if you could blank, don't know if I don't ask. And you keep telling me the same lies over blank over. You stated, quote, I don't have to. You refuse to give me a definite answer blank on me. You never give me a definite answer. Therefore, I have to keep blank, calling, doing the same. Does that make sense? Do you think that's blank able to truthfully answer the judge when he asks why you are not blank orders? When I ask why you actively choose to not cooperate, you blank means do what you say. What else would that mean? What else blank? You about other than our son, you so desperately try to blank, cooperate in anything and go the extra mile to not for our son. When blank still waiting on his Christmas presents from me, you actively have blank knows it's you, not me. Do you want me to message you blank over and over and over and over for months and now years? Blank want me to call you asking the same questions over and blank months and now years? Why am I, Brian? Think about it. Hymnal still and could have when you ordered sons for blank order when I gave you the list with sons in December for blank, asking you when are you? Think about it. By you not ordering blank could have the ongoing 6 months ago you keep telling blank going to, or this weekend, or today. I have to keep asking blank about it. By you not ordering the limited food package blank for my birthday, but never did and kept telling me you blank to, or this weekend, or today, I have to keep asking you blank. All I'm asking for is a $6 hymnal, coffee, food package, blank ordered these one-time requests. I would not blank asking, when are you? Would I? 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 I'm crashing out. Would I? 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 You not cooperating blank, doing what the court and judge have told you to do blank, do differently until my supposed unknown predicted trial blank been ordered. It means you have actively been recorded blank, stating you know and understand you have been ordered blank was your recorded statement, which I'm going to get when blank requests and you enabling a loving relationship with my son blank you have been ordered to do. Are you? Please cooperate blank. Way to go to be told the same thing again by the judge, and in which blank supposed to not lie. Think about it. I'll call Sunday for confirmation numbers. I'm going to say something I don't mean, but it's in my head, and I shouldn't say it, but I'm going to say it, and I don't mean it, but there's like 2% of me that I get why George hit you.
What else is it that I called for?
She has no concept of how actually horrible she is as a person, and it is just mind-blowing. Or maybe she does, and she just doesn't care. Father also testified that he has not received any letters from mother in 4 years. Which is shocking but true, because she confronted him on this on cross-examination, and she said, didn't you just receive something from me last week? But it wasn't a letter from her. It was the visiting application because she wanted him to fill this out for her son to go see her.
When have you ever responded to any of my letters that I have written to you from no response or answer of a phone call?
Like In the mail letters?
A handwritten letter, yes, that I have mailed to you.
I don't think you've done that in like 4 years.
You just told me 2 weeks ago that you received mine in regards to the visitation applications that I sent to you.
Well, yes, that wasn't a letter to me. That was an envelope with some applications in it.
In the parenting plan.
And then Sarah was trying to be sly in trial and being like, what are you supposed to do if an emergency? How are you supposed to contact me in case of an emergency? He's like, I don't know, maybe you just call the jail or something. And then she goes, oh, so you do have a way to contact me. No, that's not how that works at all.
Have you ever made an attempt to find out contact information for me while I am located here?
Say that again?
Have you ever attempted to find out contact information from me while I am located at VOC?
What contact information?
Should there be an emergency, have you ever tried to find out how to contact me?
I would call the jail and ask them. Or the prison.
So you do
whichever
have
one.
an option of contacting me.
What's that?
So you do have a way of contacting me.
I have no idea. I don't know what the rules are. I don't know if I could get in contact with you. Maybe they could let you know. I don't know.
Have you ever made an attempt? Have you ever asked me? Have you ever
And what's
responded?
the relevance to the issues that we're here on today?
So just because people aren't going above and beyond to make sure that you could possibly be included doesn't mean that you have the capacity to make this happen. Nor is it his responsibility to make that happen. Unless you went up there and say, hello, judge, I actually had this illegal phone that I got. Don't ask me how I got it in there, but I have it now, so he can call me anytime he wants. So now I do have access and the capacity to be informed. Nah. Honestly, it wouldn't surprise me if she did that. She would argue that. M. Evidence of domestic violence, sexual violence, child abuse, child abandonment, or child neglect, or evidence that a parent has or has had reasonable cause to believe that he or she or his or her minor child or children are in imminent danger of becoming victims of an act of domestic violence, regardless of whether a prior or pending action relating to those issues has been brought. Whew. There was no evidence presented as to this factor. And that's true. All the evidence in the world is there. She zipped her child in a suitcase. CPS was called on them.
I was investigated 4 years ago, and both our investigators and Department of Children and Families realized that it was consensual. The kid wanted to get in there. The kid wanted the picture of being in the suitcase.
Documented history. She killed her boyfriend years later the exact same way. She was arrested for a domestic abuse, third-degree strangulation felony.
Hands behind your back. For what? For battery domestic? Me? Both of you. You two hitting each other. This is for real? This is for real. Why am I in trouble though? Because of the marks he has all on his neck and the inconsistencies of the story. Back.
George was also arrested that night, but he was arrested for a first-degree misdemeanor versus a third-degree felony. She is the domestic abuser in that situation. Violent abuser, which she still, I don't know how she has distanced this. I mean, I guess she has to block it out in her mind, but the fact that she doesn't understand how important it is that this was a violent crime to all of this is wild. And it's more wild that Brian's side didn't lean into that more. They put judicial notice for her whole criminal case and trial, but they never brought up that it was incarcerated due to a violent act and that it would be detrimental to have the child have sustained communication with a violent murderer. They just said she's incarcerated. She's a bad parent. She makes him feel bad. But if they had leaned into that violence aspect, that would have opened the floodgates to this section. But because they didn't harp on that, evidence that either parent has knowingly provided false information to the court regarding any prior or pending action regarding domestic violence, sexual violence, child abuse, child abandonment, or child neglect. There was no evidence presented as to this factor, which I'm glad they specified the domestic violence, sexual violence, child abuse aspect, because Sarah's been alleging up and down that he has been lying about absolutely everything. Hasn't presented any evidence to any of that. She's just saying he has. But no one is making these accusations against each other either way, although he definitely could argue child neglect and abandonment, as in she's currently abandoning him and she neglected him when she did have him. The particular parenting tasks customarily performed by each parent and the division of parental responsibilities before the institution of litigation and during the pending litigation, including the extent to which parenting responsibilities were undertaken by third parties. While the final judgment provided the parents were to have 50-50 time sharing, father estimates that mother exercised 30% of time sharing. He testified that mother's time sharing was, quote, sporadic, and she saw the child, quote, whenever she felt like it. According to the father, there were nights where he got calls to come pick up the child because mother had started drinking.
And when she was not incarcerated, prior to incarceration, what was the time sharing schedule on paper that you two had?
It was a 50-50. One of us was Monday, Tuesday. The other one was supposed to be Wednesday, Thursday, and then we alternated Friday through Sunday.
Okay. And prior to her incarceration, was she exercising all of the overnights that she
No, it was about 30%, and it was sporadic as to kind of when she felt like it. Not even on days she was supposed to. She wouldn't have him for like a week and a half. And then she'd be like, I want to have him tonight and tomorrow night. And I'd be like, well, those are my days. And she's like, well, I haven't seen him in over a week. And that's kind of how things would go. So it'd just be like that. And then occasionally I'd be called over to pick him up at night because she had started drinking or wanted to drink and didn't want to take him to school in the morning or what have you. So, yeah, it was a lot of that.
It's her day to pick up the kid, but it doesn't always happen. 1 or 2 days a week, maybe she gets him.
Out of the 5?
Yeah.
Okay.
Yeah. So.
And what do you like every other day you're supposed to?
Well, we're supposed to. She's Monday, Tuesday. I'm Wednesday, Thursday, and then we alternate Friday through Sunday. Is how it's supposed to. I was actually my lawyer back a couple weeks ago because I was looking to get it changed because she can never stick to it. There's always some reason why. So it's general that I start calling her around to find out if she's actually going to get him, even though yesterday she told me she would.
Okay. And during that time period before her incarceration, was she actively involved in the decision-making process with your son? Was she?
Not really. She was kind of in her own little world at that time.
And she didn't contest any of this. That's what was wild to me at the trial, is she's saying she tried to shift the blame on George, the murder victim. She tried to say, well, didn't I tell you why I couldn't have my child for, in quotes, even 30%? And that's because of the danger of George.
Okay. This is in regard to the exercising of overnight, where he stated that it was 30% about for my average. Can you please explain to the court my conversations on more than one occasion of why I could not have 100% or 50% of my time?
So I'm going to object. That's self-serving hearsay, what she said to him.
All right. I am going to sustain the objection. Next question.
Did I ever explain to you the safety risk and danger of having my son come over on particular days that it was mine?
Not really. I mean, kind of, yeah, I guess. I don't know, most of the time when you had me come over there and pick him up and we was supposed to stay over at like 10, 11 o'clock at night, there was nothing going wrong. It was just the two of you drinking and having fun, and I guess didn't want him there anymore.
Brian.
Next question, ma'am.
Well then, okay, so you technically have him more than she does. Is that where you're getting?
Yeah, that's why I said I was going
So
to the
even
lawyer. I
though
was
that's
trying
how
to get
it's
things
supposed to be, you still have him.
Yeah,
the majority?
there's it's a not a good day. George is in a bad mood, or whatever else reason. I think sometimes just she wants to stay up and drink and can't really do that if she's got to wake up and take him to school the next day.
Right.
Any number of different reasons. So.
Okay. How long have you known Sarah?
Did ever tell you that he liked being more at your house because of everything that you had and everything that I didn't have?
Yes, because that was the reason. He actually wanted to go home. That's why I called you to pick him up every single time I wanted to get drunk, because he actually wanted to go home. There's always some excuse. You needed to prioritize your child and raising your child over prioritizing you having a good night, which is the pattern we saw reflected again and again. She wanted her toys when she wanted to play with them, and when she didn't want them, they had to go away. When she didn't want her son pawn around, Brian had to come pick her up. When she didn't want her son boyfriend pawn around, police had to come pick him up, or his parents. The more you just read these facts out, the worse it just looks, and the more absurd all of this arguing just looks. Like, when you have all of this stacked against you, how dare you have the audacity to have any other opinion besides, please, I'll take anything you can give me. P, the demonstrated capacity and disposition of each parent to participate and be involved in the child's school and extracurricular activities. Due to her incarceration, mother has been unable to participate in the child's school and extracurricular activities. And she thinks she should be absolved of that. Anything with the time sharing and this and that, I still can't get over how she just so casually talked it off when the judge said, you can't even fulfill your time sharing obligations. Well, that's my only thing that I'm not doing right.
2018, I believe, I wanted to bring to the court's attention that it's been violated by the petitioner. Again, from previously, now I believe it's a kind order. It says the parenting plan may be modified or verified on a temporary basis when both parents agree in writing.
All right, Ms. Boone, you have to agree that there's a lot that's not being followed with regard to that parenting plan, which includes even the time sharing that you're not able to do at this time.
Right.
You would agree with that, correct?
I understand that, but that is my only stipulation. That's my only part that
All right, you would also agree.
I understand that, but that is my only stipulation. That's my only part that I'm
would
also
agree. As if that's not the most important thing in the entire parenting plan. Your time sharing, the time in which you actually take care of your child, is the most important factor of all of this. And you just say, well, that's the only thing I can't do. Wild. Which means you can't do stuff like this either. Q, the demonstrated capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. There was no evidence presented as to this factor. And again, that's because Brian didn't try to push the issue. If they really needed to push the issue, they could have just said literally the day that she was arrested, there were 3 magnum-sized bottles of wine that were just tossed around. Vodka bottles, Dr. Pepper cans scattered everywhere. She has no evidence nor way to demonstrate that she could ever provide an environment free of substance abuse, even if she were free. R, The capacity and disposition of each parent to protect the child from the ongoing litigation as demonstrated by not discussing the litigation with the child, not sharing documents or electronic media related to the litigation with the child, and refraining from disparaging comments about the other parent to the child. There was no evidence presented as to the parties discussing the current modification proceeding with the minor child, but mother testifies that father has called her a, quote, killer and, quote, murderer in front of the child.
Number 6, where it says not to hear parents speak ill of each other, nor to hear about the difficulties of the other parent. Have you ever called me murderer?
No.
In front of our son?
No.
Have you ever called me killer in front of our son?
No.
You do realize you are under oath.
Yes, there is a difference between calling me a murderer and saying you're being tried for murdering someone. Those are not the same thing.
Have you ever called me a murderer in front of our son?
Asked and answered. Move on. Next question.
Which honestly, her not submitting her text messages is what saved her in this section, because she absolutely admits to using the child in order to communicate with Brian when he won't answer her phone calls or whatever. However, in the trial, she only mentioned, how else am I supposed to get in contact with you if not through our child, through a letter, or through what other things? You are putting our child in that position. That is what she said. But in the text messages, she says, please don't make me have to go through my son when I ask status of everything. And there's text messages upon text messages of her admitting to using her son as a go-between when talking with them. Please respond. Please do not have to make me go through my son when I call to have him ask status of everything. Judge Dean, after coming back from an outside medical appointment for my cancer and surgery, I really wanted to call my son to hear his voice and brighten my long, arduous day. In doing so, he was checking the mail, telling me I had a letter from you and wanted to be helpful and read it for me. The document was an order to dispense mediation. When my 11-year-old was finished reading, his response was, I'm sorry, I don't know what Dad's trying to do now.
Dad says you're annoying and beg all the time. Son told me after asking him to ask former husband if he finally ordered a book and hot meal after being made to call daily to check for 13 weeks.
The conversation continued with me asking why he's telling his friend this, as nothing is set in stone and will be discussed when the time comes. Oh, we're leaving, and it doesn't matter what you say. We have an attorney. Eventually, it turned into the aforementioned statement, and I was laughed at, disrespected, shut down, and hung up on by my son over asking about his friend.
In the parenting plan, it says that you are not to use the child as a ploy or a mode of communication. How else am I supposed to communicate with you if not through our son?
If not through our son?
Through the letter, a tablet, or a telephone call. You just said that you do not answer phone calls because you do not want to. You just said you do not have a text message because you do not want to. You do not respond to letters. Therefore, I have to ask you regarding our son. You are putting our son in that predicament. Is that correct?
You are putting our son in that predicament. Is that correct?
Now, if you have something legitimate you want to talk to me about, then you let me know, and I will talk to you about it.
How would you know if it was legitimate or not? You don't answer. I have nothing ever to speak to you about in regards to anything other than our son. I have nothing ever to speak to you about in regards to anything other than our son.
Wait to the question zone. All right, now you may answer.
Once again, you can write me a tablet message explaining the question, and then I can answer. Or two, just when you're on the phone with Luke, have them say, hey, mom's going to call you out, blah, blah, and then you can call me about it. That's not making him communicate between us.
Why you can't just communicate as an adult and a parent do not have to include our son
All right,
in
next
this.
ask a question, Ms. Boone.
But that wasn't evidence in this case, and that was kept out because it wasn't relevant, nor did Brian ever respond to any of them, so it would have just been hearsay. S. The developmental stages and needs of the child and the demonstrated capacity and disposition of each parent to meet the child's developmental needs. The child is blank enrolled in a magnet program and involved in extracurricular activities. T. Any other factor that is relevant to the determination of a specific parenting plan, including the time-sharing schedule. Father testified that mother has not been involved in any major decisions regarding the minor child. Also, he has no idea how to contact mother to get her input on such issues involving the child. He testified that over the past six years, mother's calls have been off and on. He describes there being weeks of tons of calls. I tried calling 9 times today, 8 yesterday. Just for you to yell and not care as usual. I am floored. You nor he answered the phone after calling 3 times on blink his phone with so I can speak to him after trying 8 times over the weekend. Blink enable our phone call. I try calling you every night with no answer. Don't you know by now the evening time is when I am able to call you so you have your phone with you? I call every night. Every night.
So then my stupid self called back in 30 minutes and nobody answered. So I called and then I called and I called and I called for like 6 hours afterwards and nobody answered.
But other weeks with, quote, none.
When was the last time he was upset?
Probably about a week ago because you didn't call all last week.
Do you know my schedule of work while I'm located at DOC?
No, of course I don't.
What?
Why haven't you asked about it? To know that.
Because I don't care. Oh.
What?
He also expressed concerns about mother's decision-making, including the circumstances leading to her arrest and conviction for second-degree murder.
Given the decisions that she made that led to her arrest and eventual conviction for second-degree murder, do you have any concerns about her decision-making ability?
Oh, of course.
Okay. What are some of those decisions, or some of those issues the specific issues you have with her decision-making ability?
I don't think she makes good decisions. Even without the alcohol, I think she has some problems that need to be worked on.
Okay.
According to him, he, quote, doesn't think she makes good decisions. Notwithstanding his concerns, Father testified he does not mind mother giving her input on decisions regarding the child's education, health, and other major decisions, but he believes sole parental responsibility is in the child's best interest given mother's current circumstances.
And do you see any problems with the fact that if there was a joint decision that needed to be made regarding a major decision of your son, do you see any problems with Ms. Boone having input on that decision if she is not going to be financially responsible for it?
I mean, I don't mind her giving some input on it.
Okay.
No. I just don't want her to have any kind of legal availability to make a decision.
Okay.
17. Upon evaluating the factors above, it is in the best interest of the child that father shall have sole authority to make major decisions for the child.
Bon appetit!
And there it is. Brian receives 100% full custody, full responsibility of their son. No duh. Wasted all this money and time for the most blah, no duh answer because there's no actual alternative. She can't have any responsibility over him. She just fought from the beginning because she said, if I don't have any power, then none of my things get discussed. It was always a power tool, not in the best interest of the child. It was how she can use the child's best interest for her own interest, her own personal gain. It is detrimental to the child to have shared parental responsibility for the following reasons. Mother's current incarceration with a sentence of life in prison
sentences you to life in the Department of Corrections
without possibility of parole.
with credit time.
Electric chair.
Holy shit.
Mother's sporadic calls and father's inability to call mother to discuss parenting issues. 18. It is in the child's best interest for the father to have 100% time sharing with the minor child. 19. The court further finds that a flexible visitation schedule for mother is in the child's best interest of the child due to his age, current school schedule, extracurricular activity commitments, and the distance between the child's home and the prison where mother is currently incarcerated. C. Alimony termination modification. Okay, we are finally done with that opening portion section 5.5 hours later. But so far what we covered was just covering the parenting modification and parental responsibility, the thing that should have taken maybe 10 minutes in court the whole trial. Not even just the whole trial, I mean these whole 6 years. It should have been as easy as she's in prison, he's not. Obviously, he has 100% parental responsibility of the child. It's almost a talent for someone to be able to stretch such basic issues and make them the biggest obstacles in the world. And she used that talent for evil, yet again, to make everyone's life as difficult as possible. I am no longer going to willingly make it easy for former husband to advantageously rob me of my last and only minute life resources out of bitterness, greed, and spiteful opportunity. And then she will be shocked, befuddled, and upset when it all backfires on her, as it always does.
See, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
You done.
It's awful, I know.
Okay.
It's awful. And I will tell you both this right now, too.
The majority of the time, I will tell you this, which you are unaware of because
You're
you
not
do not
telling anybody anything, man.
All right, moving on. 20. Petitioner also seeks the, quote, termination of durational alimony or, quote, that the alimony be reduced or at least suspended during respondent's incarceration. See Modification Petition at page 5. 21. At the final hearing, respondent argued she needs alimony to buy gifts for the party's child, and she is, quote, legally entitled to alimony. However, neither party waived their statutory right to seek modification or termination of the alimony awarded. See Final Judgment, page 8, quote, the alimony amount is modifiable upon a showing of a substantial change in circumstances. See Florida statute, quote, the amount of an award of durational alimony may be modified or terminated based upon a substantial change in circumstances. Emphasis added. And they'll sometimes do stuff like that, the emphasis added, when the original opinion that they're citing didn't emphasize those exact words in the way that this court wants to emphasize them for this opinion. But that is another no-duh moment that completely unravels one of Sarah's main talking points throughout all of this, which is the 2018 thing. It's still in effect. It's still in effect. He's still supposed to pay me because this court order told me he should. How dare he stop paying me? He should be doing this no matter what. He has this obligation.
Sometimes I'll start a sentence and I don't even know where it's going. I just hope I find it along the way.
And it's like, sure. However, you didn't in your original marriage dissolution, which I guess, like, if you wanted to go through it with a fine-tooth comb and you had your own lawyer at the time, you could have found that out. But you never stipulated or came up with an agreement of that you are not allowed to change these terms. These terms are always modifiable based on a substantial change in circumstance. It does not get more substantial and more of a change in circumstances than being removed from society, isolated in a prison, and have every single one of your actions planned, accounted for, and checked, recorded, observed, monitored, and critiqued. In contrast to when she was on the outside and she could do literally anything she wanted and seemingly no one cared enough to stop her or make her feel any kind of consequences for her actions. It could not be more of a 180 for her life and for everyone's life around them, which in some instances means their lives have gotten better. However, she likes to still chain herself to people, and that's why she said in the motion of Brian thinks he's going to take my son and they're just going to walk off into the sunset and leave you. Absolutely. You have trapped them there their entire life with you. And now that your behaviors and actions, dispositions, attitudes, and just the way you treat people have finally caught up with you. She is that parasitic family members that most people have to go no contact with. And just me personally, I am not a no contact advocator per se. Definitely setting boundaries, distancing, making sure that you are protected and safe. But I'm a huge proponent of communication, that all things can be solved through proper communication, understanding, compromises, etc. However, when you have encountered an individual who just cannot budge, cannot move, cannot respect you, cannot put you or anyone else above themselves, then you need to leave. It doesn't always have to be that way. I've always had this, idea, disbelief, thought, and I guess hope that she would humble herself even a little bit, that she would admit, maybe even once, maybe I was wrong. Maybe I've treated people poorly. Maybe I'm doing this to others instead of the world doing this to me.
I am afraid that I'm always stuck getting the damn short end of the stick on everything.
Sarah, how long have I been talking with you?
It has to be over a year.
I'm not going anywhere. And if you don't know that yet, you're out of your gourd. That prison's doing something to you.
I'm not to me. Because anybody I've ever loved, you have to understand, they either leave me or they die. Think about it. My entire family, and it's just or I'm treated really awful and just
She could not control her family members dying. Got it. That is something that she just had to encounter in life. Which, future me here, I don't want to sound insensitive, but we learned at trial that all of these deaths that she repeatedly brings up again and again, they all happened in her 20s. And, that's a hard thing to go through. However, this woman is 47 plus years old now. The length of time where it is reasonable for those deaths to be debilitating is far in the past by now, especially given the amount of resources and support systems she did have around her in order to allow her to move on. At that point, it becomes a choice. You couldn't control your family members dying. Got it. You could control how you treated everyone else after that. You could control how you treated Brian. That could have led to y'all not getting a divorce. You can control how you treat your son. That can lead to him not wanting to not talk to you as much as you want to talk to him. You can control George not dying. Why? Because you had his life in your hands that night. You made choice after choice after choice. The world didn't do that to you. The world didn't make you scream at him while he's talking to his brother at 7:30 at night and you saying, I need the phone so I can talk to my brother.
And we're talking, and then he's talking to me about when we was kids. And then, a couple minutes after that, that's when I hear in the back start arguing with him. No, I have to call my brother. I have to talk to him. And he's like, no, I'm talking to my brother. It was her phone, so. And then she starts arguing and telling him that, no, tell him what you've been doing to me. You choked me, this and that. But he was calm. And he was like, okay, I gotta let you go. And then He said, I love you. And then I told him I love you. And basically, that was it.
And then that devolves into another argument that your neighbors say that they overhear. The world didn't do that to you. You kept picking those fights. You told the police. You controlled every single aspect of that night. We did this. We did that. We did this. We did that. Oops, he's dead.
We've been doing art, trying to take the stuff off the wall to make new art put up there, like having a good time with one another. But we're drinking. We had a bottle of wine last night. Okay. So then it's like we decided to play hide and seek, right? Okay. So he gets in the suitcase. Okay. Who is this guy? That's my ex-husband, my former husband. How did he lives here with you guys? No, I called him over here. Okay. Okay. I didn't know what to do. Okay. I didn't know what to do. Okay.
She didn't even say oops, though. She just said, he's dead. I have no idea. The one woman who was in the most control of everything that entire evening has no clue how he didn't get out of the suitcase she zipped him in.
I have no idea, and I don't want to seem out of sorts, but I have no idea. We had a good day. Mm-hmm. It was a good day. We've had good days lately. Mm-hmm. Even considering everything that's going on with our jobs and life in general and ex-wives and everything. It's been good. Like, I don't even know where this is coming from. It's kind of, I thought it was the boy crying wolf kind of thing. Okay. And again, my plan, my plan was not to go upstairs and go to sleep. My plan was not to, he'll be up here any minute. And my plan wasn't also to leave him in the suitcase. Well, I thought by not zipping it up all the way, it would be okay. My plan was not to leave him in the suitcase.
And what was your plan?
Waiting for him to come upstairs.
And then when he did it?
I fell asleep.
And then has the nerve to say that he is the reason she's going to prison. He is the reason that she ever went to jail.
For me, experiencing ever being arrested and after today, prison.
Not because she killed him, not because she strangled him. It's because the world does this to her. You have had complete control over your life. You could have controlled how long you spent behind bars, and you did control it. They begged you, hey, we only want to send you to prison, your murdering ass to prison for 15 years. And all you have to do is say, I'm sorry. And you said, no, I want all the control possible. I'm going to burn through 9, 10, 11 attorneys in order for an hour-and-a-half verdict that was ultimately reached after I pressed record. You could control your attitude, how you treated your attorneys. You went through attorney after attorney after attorney.
This attorney, number one, is untrustworthy, unreliable, unprofessional with poor leadership skills, and is extremely unorganized. He was unable to perform ethically, and as an adult, ignoring his client, misleading and deceiving. He didn't even respect me enough to speak before his withdrawal to try and remedy or figure anything out to stop. I was totally blindsided because of the magnitude of his ineptness and dereliction of duty as a result, withdrawing from my case at the 11th hour after taking over 2 years with nothing I knew of but disappointment. I could have reported him to the Florida bar for legal malpractice. Exhaustion 1. He is still not helping. Him no longer being my attorney was not my choice. Like Lois Lane looking in the skies for Superman, I'm hoping, praying for an attorney to step up and truly represent me with honesty, intensity, understanding, respect, and perspective. From my perspective, am I surprised my attorney is trying yet again to give up completely? No. Is it a blessing? Yes. Let's be honest. Frank J. Bankowitz is a dud of an attorney. He is unprofessional, hides, lies, and is disrespectful. I had a feeling when other attorneys spoke about him, winced, sighed, rolled eyes, saying they have some of his clients. And after finding his 3 public reprimands, I announced to the court, and which he said pissed him off, being the reason for his first attempted withdrawal. This was going to be an adventure, but nonetheless, hoped for the best. Unfortunately, I seem to have gotten the worst. Thankfully, there are many other professional and scrupulous, valiant attorneys still available, and hopefully after all my previous letters and 6 withdrawals to date, not by my choice, Judge Wooten, you will remove the blindfold this time when throwing your darts of justice at the remember everyone has constitutional rights and should be treated fairly dartboard, and you wear glasses. So let's go for the bullseye. Please. Thank you in advance for hopefully caring this time. After repeating to her over and over and over while she's beginning to speak louder and over me still to please schedule an in-person meeting where all can be discussed further privately with no success of being heard, I disconnected the visit telephonically. She uncooperatively. She is impossible. See previous letter or ask her for a copy of the 2 I sent her. I was trying to remedy or lessen before sending this to you. Your honor. And not having to include. Now it's a race to the pulpit. My question, please, who acts like that and still be able to call themselves professional? She, like other former attorneys who always blame their dysfunctions on me, said, you don't like the answers I give you. What answers? See pages 1, 2, and 3.
And people want to say not all of them are her fault. I beg to differ still. Because the first ones that were conflicted out because they represented George during the times she got him arrested. All the times we've seen her talk her way out of getting arrested by being the one who calls the police first, by lying, saying, I did touch him, I didn't touch him, he did it, I didn't do it, this is what happens, you should have arrested him for this, that, and this, you can't arrest me for literally anything.
You said a month ago he hit you with a curtain rod. Yeah, with a curtain rod. That's why I can't believe you guys didn't take that either. Well.
So because of that, Public Defender's Office, all these other offices were automatically conflicted out because of her actions. We now know that more times than not, she called the police when she was in absolutely zero danger and purely wanted to use the police as a punishment system because she got mad at what he was doing.
I don't want him to be taken. Please put the fear of the police. Please put the fear of the police.
So you don't want to press charges? Okay.
I don't think we ever saw her call the police when she was actively in danger. Every time she calls the cops and they come over there, just like Brian said when he came over there to go pick up his son, everything just seems fine. He's asleep. He's docile. He's not fighting against anyone. She's belligerent. She's all over the place. She can't tell a coherent story to save her life. However, the world bent to her control and bent to her influence and allowed her to get away with it time and time again. 22. The court finds the respondent has $0 income.
Insufficient funds. You ain't got no money. Woo.
Due to her involuntary incarceration and that her reasonable monthly expenses or reasonable need has been reduced to $145.
Hide the money, y'all. There's poor people around. With your broke ass.
23. By stipulation, the court finds that petitioner's gross monthly income is $5,000 and he has the ability to pay alimony.
And a large popcorn.
A large? You got money. He got money. Get it all for him.
24. Because respondent still has a need for economic assistance, petitioner's request for termination or suspension of his alimony obligation is denied.
Yeah.
Let's see footnote number 3. Respondent is currently sentenced to life in prison without the possibility of parole.
Ms. Boone?
Electric chair.
Holy shit. God damn it.
As such, petitioner's request to suspend his alimony obligation while petitioner is incarcerated is effectively requesting a termination of the alimony.
See Florida statute, blah, 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 expressly stating that the purpose of durational alimony is, quote, to provide a party with economic assistance for a set period of time following a marriage. 25. However, petitioner's request for a downward modification of his alimony obligation effective May 1st, 2022 is granted. 26. For the remaining 36 months of the 84-month period for durational alimony, the alimony obligation shall be modified downward to $145 per month for a total of $5,220. Wow, she went from $67,000 to $5,220. I bet she wished she took that $6,000 now.
You could go through this trial and you could walk away with nothing.
What do I have now? Hey, what do I have now?
That trial is going to cost him a lot of time and a lot of money. So.
And they're trying to throw me out of $61,000, $6,000. $6,000 out of $61,000.
How do you know that number?
Because it's in the amended supplicated whatever it is.
What do you think you would settle for?
I don't know. I don't have a crystal ball. I know he's a piece of shit and he's bitter and he's angry and he's sad that he has to live an adult male life now. But I don't know. I don't even know. He never even would try to explain to me the $6,000 and the number that came up from that.
I mean, I don't see how it could hurt by just sending him a note, and I could also send it to his attorney saying, hey, look, we're asking,
It's still the same thing. It's still the same thing. What you're trying to do is you're trying to get me to surrender. And it's
Again, she hates to say it. She says, I hate I told you so moments.
I just don't get it when I tell you this, and I'm so tired, and God bless you. I'm so fucking tired of I told you so moments.
This was another I told you so moment. New York told you.
My gosh! Oh!
If you go to trial, you can end up with nothing. And your response was, what do I have now? Look, what do I have now?
What do I have now? Hey, what do I have now?
Now, you have less than $6,000. 27. Respondent is entitled to total alimony arrears of $20,220. Footnote 4. Petitioner admits that he did not make any alimony payments for the 15 months before filing the modification for a total of $15,000 in missed payments.
In my understanding that petitioner concedes there is 15 months of alimony that should have been paid. And so there is a amount that's owed, I believe it's $1,000 per month. So that would be $15,000.
Well, we're going to be arguing that he did make other payments if Mr. Boone's going to testify that he made payments to an average of $600 a month during that period of time. So
we're agreeing that he did not make $15,000 worth of direct alimony payments that were ordered pursuant to the final judgment.
That is correct.
Okay.
D. Child support modification. 28. Father also seeks the, quote, termination of child support retroactive to the date of mother's arrest because his child support obligation was based on the, quote, equal time sharing schedule outlined in the parenting plan and on the financial abilities of the parties at the time. See Modification Petition at page 6. 29. It is undisputed that mother stopped exercising time sharing with the minor child upon her arrest on February 25th, 2020. 30. After over three years of litigation, mother finally conceded during the final hearing that father's child support obligation should be terminated given her incarceration and exercise of zero overnights.
All right. They made a statement that there is approximately $4,000 that is sitting in the clerk of courts with regard to child support. They're asking that be returned to Mr. Boone so that he can use it to care for the child. Do you agree with that?
I do, only if he decides to include me, please, on some of the things that I would like to have my son to have also, and things that he had made mention to me that he would like to have in order to become more of an adult and his growth in his teenage years.
31. During the final hearing, father testified that the clerk was holding approximately $4,000 in child support payments because the clerk did not have information and/or an address to where the child support payments could be made to mother. Mother agreed that all such funds being held by the clerk of court should be returned to the father. Only if you decide to include me, please.
Only if he decides to include me, please.
32. Petitioner's request to terminate his child support obligation effective February 25th, 2020 is hereby granted. See Florida statute, quote, a modification pursuant to a parent's failure to regularly exercise the time-sharing schedule met so forth in the parenting plan is retroactive to the date of non-custodial parent first failed to regularly exercise the court-ordered or agreed time-sharing schedule. Emphasis added. 33. The new child support arrears balance to $0 effective April 7th, 2026. 2. Relocation Petition. 34. In his relocation petition, petitioner seeks to permanently relocate from because of respondent's incarceration for second-degree murder, the child being bullied at school, and respondent having 0 overnights over the past 3 years. See Relocation Petition, page 3. 35. On February 23, 2023, respondent filed a handwritten response, quote, relocation answer to the relocation petition, wherein she objected to the relocation. See relocation answer at page 1. 36. Notwithstanding her objection, on February 5th, 2023, the court entered its temporary relocation order wherein the court permitted petitioner to temporarily relocate to Gainesville. See temporary relocation order at page 2. 37. Respondent continued to contest the permanent relocation and did not stipulate to the permanent relocation until the final hearing. Which we talked about it a little bit before, but was extremely devastating to her whole point and position of thinking she's coming from a good faith basis. There was absolutely 0 reason why she should have objected to that relocation aside from the fact that it emotionally made her feel bad, evidenced by the fact that after she's sentenced to life without possibility of parole,
Ms. Boone,
Electric chair.
sentences you to life in the Department of Corrections.
Holy shit. God damn it.
she changes her mind.
Electrocute that bitch. And I want you to pour some water on her first.
That means it was never about the best interest of the child and purely about the emotional interest of the parent. It would be one thing if she were an active parent in the real world and he decided, I'm going to move hours away and you just figure it out. You have to come drive to come get him or this and that. That's when you have those objections. His school is here. He has friends here. He does this here. And you're trying to take him there away from me out of bitterness and spite. That's how she wanted us to see it. And it's honestly how she sees it. However, that child has not spent one night with you in over 6 years. Yet you want to flaunt the little power you have of, I still have custody of my child. I too am still in shock of the outcome for the petition to relocate. And blank, my minor son being advantageously taken 4 times the lawful amount, 50 miles, to move away from me. The other parent,
As far as I'm aware, which is rare in this case as no one includes me on anything, I still have my rights, custody of my son, and am owed alimony. Yes, technically, but not physically or actually, and it should be embarrassing to write that down. But she does it with such confidence and says there's no reason, completely ignores the alleged bullying that he went through. She doesn't care. She doesn't believe it's real. However, what do we see in these messages? I can't believe I was laughed at and called names. Don't call me names when I'm doing this. I was made to cry. Oh my goodness.
No one listens to me. I have made the active decision to not call for an undetermined length of time so I can take a break from the beratement. I can only take the terrors inflicted by former husband in doses. Right now, I've gotten my fill from both of them. When trying to rationally discuss the topic of moving, I am either yelled or laughed at. We can't wait to get out of Orlando and away from you. Laughing. I do not have to speak to you or waste money on messages. I do not have to be ridiculed and abused or laughed at or called names.
Fuck Brian, excuse me, like I knew it. The way that he talks to me on the phone and shit and laughs at me where I'm like, what are you laughing at?
Yeah, that's what happens when you get bullied, right? You don't want to feel like someone's laughing at you, but you're okay with your son being taunted, harassed, bullied, because child bullying is way worse than adult bullying. Because adult bullying, you can catch these hands. Child bullying, they just throw everything they can possibly think of at each other and don't care at all how that lands or hits with the individual. I'm sure it definitely hurt him originally to hear his mom being talked about in the way she's been talked about. But then in combination with the way she's treated him and the treatment he has to deal with in reverse, because there's no way that he has not received negative backlash purely from association with you. And that's exactly right. You let him know, Linda. If she actually cared about that boy, she would know that any association with her puts a target on his back, and either A, you start acting right so people will treat him differently, or B, you allow him to leave and get to safety. And then her insistence on being insulted at the notion that them moving allows them to have a fresh start. She could not believe the judge said that. That's her ultimate insult. Why on earth do you need a fresh start from me? Just because I killed one person who was in your life for 3 years does not mean anything has changed. And you saw it in the interrogation when she's like, I'm not going back to my place until whatever to blow over.
Well, we did tell you yesterday that we don't want to do anything around your son, hence why you came to us. So I don't know why you think that's going to change.
That and or me not just show up back home.
I'm sorry, what? That or what?
Me just not show up back home. That's what, he's so happy that I'm staying over at the house with Brian. Like, so happy. And I'm not going back to the house, to my house, for however long I can stay over here because of whatever to blow over. Mm-hmm. And again, if you don't mind me asking, so for whatever it is you all are claiming from the videos, is that what you're going to tell them? Like his parents? It's like, oh yeah, and by the way, she did.
Because that's how her position has been from then until now. This will all blow over. Everyone will forget about him and it'll be okay. Because I've painted him as this malicious abuser who I barely survived. So everyone's going to say, oh, thank God that terrible man is gone and you survived and we're so happy you're back. It's okay. Move back into your apartment and we'll be just okay and we'll pretend nothing happened. And that's what Brian means when he says she lived in her own little world.
And during that time period before her incarceration, was she actively involved in the decision-making process with your son? Was she
Not really. She was kind of in her own little world at that time.
So I'm guessing you called for a reason, right?
You told me 24 hours to get a check. Okay.
Yeah, but you do realize he's here, though, right?
322, 65.
Have you been drinking?
I had a drink.
Okay.
I had a drink. Tattoos all over him. No shirt, gray pants.
Yeah, I have to. He's here.
Other one, tattoos.
Yeah, you can stay right here. You can stay right here. He doesn't know that you call. He doesn't know how to know
Another black male, no prescription, car QA,
I have to.
3 white females, collecting an area check. What?
Why do you have to? So we left earlier. We respected your wish, yeah, we respected your wish.
Okay, but I'm literally begging you, don't.
Yeah. Something over here. I know. I'm trying to keep you away from there. You're not listening.
No, don't. Have Rachel come talk to me.
There you go.
George, I'll do whatever I can.
Okay.
George.
What's your name?
Babe, I had no idea.
Jesus Christ.
Babe.
Stop screaming at him. No. Go back inside.
George.
Go back inside. Go back inside. Jesus.
Do you need Jesus right now?
I don't. Just go inside and call Mom and Pop.
How's Henry over there talking to him? How's Henry over there talking to him?
Henry's the property manager. Why is this?
What do you want me to do?
Ma'am.
I got both. Hold up in a minute. Y'all gotta go. Okay, it's done what it's done.
Why are you screaming for?
You need anything with me?
I need you to go inside like the past 5 minutes. Goodness gracious. All right, go.
George!
Because to this day, she still lives in her own little world. And this logic makes sense in that fake reality, not this one. And you see that supported by Brandon, the roommate's, the neighbor's testimony of saying that at the end that George was a bad guy.
Okay. It's one of those things where like he was a bad guy. Mm-hmm.
And, I felt bad hearing that at first, but then he also admits he only spoke to Sarah. He never spoke to George.
Do you know either of them? Like, do you know?
I've had a few brief interactions with them.
Okay.
But I don't. I haven't interacted with him much. I've spoken to her a few times.
And any other interactions with her?
No. Honestly, from the few times I had spoken to her, like, anytime I saw her, I kind of just tried to go straight into my apartment.
Right. Okay. Any interactions with the Hispanic male?
No, not that I can recall.
No.
The other roommate did speak with George and had a very neutral opinion about him, did not think that he was a bad guy.
Did you ever hang out with them on the back porch?
Yeah.
You've hung out with them?
Yeah, I have, and it was like, not for like long periods of time, but like, I'm a musician, so like they heard me playing guitar the one day, so they asked me to come over and tune their son's guitar. So I tuned their son's guitar for them and everything, and I was playing on the back porch because, I write songs, so they were like asking me if they can hear it and everything. And I was like, yeah, sure. I had nothing going on, so I went back there and I was hanging out with them and I was playing some guitar, and I did it a few times, and then I was actually in their apartment a few times. Like, he was an artist, and he was showing me like a bunch of his paintings and like artist drawings and stuff like that. So I mean, like, they were cool people, but like there was something going on, especially with Sarah. You know what I mean? Like, there was something going on with her. Like, you couldn't tell, it was like she wasn't like all there, She wasn't like all there,
But the one individual who only spoke to Sarah thought he was an abuser. That was her goal. That's her MO. That's her abusive strategy. And when it all crumbled, when it all failed, she can't believe it. And this is just another one of those moments that...
I don't get it when I tell you this, and I'm so tired, and God bless you. I'm so fucking tired of I told you so moments. I know how vindictive and vicious is and can be, especially with money and parents and resources behind him. You don't understand how vindictive is.
Yeah.
The things that he had said to me on the phone. Fuck Brian, excuse me, like I knew it. The way that he talks to me on the phone and shit and laughs at me where I'm like, what are you laughing at? The things that he had said to me on the phone in front of how he used to make me feel when I was married to him. His entire family. And now I'm in prison, where they can all clap and do backflips and double high-five each other.
It's over! It's over! It's over! It's finished! It's all over! It's over! It's over! It's over! It's over!
And even now, she wants to know, where is my fresh start? When am I going to have a life of my own? Judge Dean, you stated in the relocation hearing also, it's a, quote, fresh start for son and former, quote, husband to move beyond the 50-mile radius away from me. Why would you allow them to, quote, start before knowing anything of my outcome? Why? I guess I'll never get my, quote, fresh start from everything being made so impossible and arduous before anything has been happened and after, when, and if it does. Jesus Christ. And she yells at Julie and Nicole in New York.
He said I don't look like a pumpkin. Give me a hug.
Bitch, you look like a man and you need that facelift and get rid of crow's feet with that.
I don't even pay no attention. I'm not. You're bigger. Okay? I'm not. Okay. I love you. I love you too.
Get her out of here.
About this same thing of, well, obviously I get it. You all are busy with your real lives, which I would like to have one too one day. Why is no one doing this and no one's doing that?
Like, we don't start something and then it can't be finished. And I understand you have a life on the outside just like Julian does and everyone else, which I myself would like to have at one point also. But at the same time, though, I can't do this without you. But you've had me have that reality check where it's like, well, he's on the outside with a computer, with access to the courts, with, you actually have pen and paper and stamps. I don't even have that in here. So I have nothing. So you have everything.
It's a choice. You blank gifts whenever your father decides to
Send me money, send me money, send me money.
order. It's the middle of February, blank, and I have no resources, family, or money.
Money, money, money.
You have all and do nothing.
So when you show me that you have something of your everything that I can have, I'm going to try and take it. I'm not trying to look a gift horse in the mouth. I'm just trying to take the whole mouth. I'm not trying to look a gift horse in the mouth. I'm just trying to take the whole mouth. That's what I'm trying to do.
Fair warning, you are not going to at all like this message. I am sorry, but not. Over it, and I honestly don't care. I'm used to nothing and no one. Just another day in prison with my illness. I guess I have to put on my fake-ass smiley face so everyone thinks I'm such a strong person and brave and smart and bold. So here, if you feel like it in between everyone's quote-end-quote breather, when is mine? What outlook is supposedly not promising? You say to just wait to see who calls back? You mean to say if the call back? What happens if no one does? In the meantime, let my ex-husband take my almost inedible, muddy crumbs to have a life in the real world if I ever make it, shaking my head. Here are my list of requests, my catalog order you both have been promising me, and to tell you anytime what I need. If so, I can't pick and choose what gets fulfilled.
I need something in my life or otherwise I'm going to go effing insane. I can't explain it to you and I'm really trying to keep it together, but after today and a taste of what real life is out there and to see everybody, you know, functioning normally and everything, it's very difficult for me, and I'm trying very hard to keep it together.
But what did you see? You saw, like, people walking around?
Everything.
Yeah.
Traffic, you know, people working. The office that I was in was like the office that I worked at. And I was thinking that I could do all of this that the one girl was doing and just... Listen, you guys listen. When words come out of your mouth, I trust you, what you say. I believe what you say, and I feel that I can use it to my life in whatever application and any way. So when you tell me that I can come live there, I'm coming to live there, and I'm taking care of all of the animals, especially after you guys sent me pictures. Some of the pictures are so ethereal. It looks like it's from a fantasy. It's just...
Yeah.
I get to go through all of this shit because I know that I get to go there. Because I know that I get to go there.
To prison.
We specialize in rescuing, so.
Well, I'm slowly but surely letting you guys pet me too, so it's perfect. So You'll have a leash on and I'll be walking and I'll just, tricks and everything. Thank you in advance.
Oh, you nasty. 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 You nasty. Little nasty. You nasty. You nasty. Ow.
And in one of the more recent release calls, Julian admits that he was imprisoned or went to jail, prison, wherever, for a little bit. I think it was jail. Because of a parole violation in his ex-wife and whatever issues he has to do with that. Fun fact, he ain't kill nobody. So, that's why he's free. And honestly, I think he rubbed a little salt in the wound with his response, because he said that he was in jail, he was freaking out because she's complaining, oh my life, woe is me. And he said that when talking with New York got up there, stood up there and
slap me, bitch.
acted like his lawyer, and then he was back hanging out with New York.
You put your hands on me. Did you see that bitch spit in my face? Bitch, I would take you out.
Later that evening or the next day or whatever. And she said, you need to help me with that.
Any etiquette whatsoever in here, it's just like, fuck everybody and I'm going to be a mess.
I was in federal in Rhode Island. I was in a cells there, but then I had my ex-wife got me arrested again on a probation violation. They sent me to Hartford Correctional, and it was during COVID, so it was 24 hours in a cell, and then they moved me in a dorm, and I was like, I'm going to lose my fucking head. I'm going to pop off in this place with these people, and then I literally got out like hours later.
Lucky you.
PD got me out. PD got in front of the judge and basically acted like my attorney, and next thing you know, I'm in the car with him, and we're heading home. And then I was on house arrest for a year.
You better help me with that. You hear me? I have a fucking life sentence.
What sentences you to life. And the
Electric chair.
Like sometimes I try not to fucking either scream or start to fucking turn into a puddle from sobbing. They expect me to spend the rest of my life here? Like this is what I'm 47 years old.
Damn.
I'm sorry. Because it was a thought. No, seriously. It was a thought. It was a thought, and I blurted it out. I did not mean it that way.
I'm fine.
Okay, but just understand I didn't mean it the way it came out.
We'll take a poll on how you meant it.
Like, they want me to spend the rest of my
life in the Department of Corrections.
Life doing this? You're crazy.
The best thing to do is keep fucking busy. Get books, get whatever you can. Get some friends if you can make some friends. Play cards. Do whatever you fucking can to keep your head focused on something, on anything other than where you're currently sitting, you know?
Get a real job.
Yeah, but it takes time. But the best thing to do is to get into the kitchen.
I can't because there's knives, Julian.
Oh,
My
shit.
options, listen, are either to fucking cut grass and pull weeds or scrub toilets and wipe the walls down.
Oh, do garden, pull weeds. That's great. You can get outside. Are you kidding? That's beautiful.
In Florida?
She thinks she will have a fresh start. Her fresh start might be a new bunk. Her new fresh start might be a prison in another state. That's the only fresh start that she could possibly imagine or happen in her future. And she can't stand it. And while she still to this day has no reason to object, as soon as she's sentenced, as soon as her worst fear finally became realized, oh my gosh, why is all this beeping? Now she acquiesces and says, yes, please move my child. Why? Because he'll finally be closer to me. Still about me, me, me. If she had kept the same position of saying, no, he should stay in Orlando because of the reasons I stated already, because he has friends there, because this and because that, it doesn't matter where I'm at, still a stupid reasoning, but it would be consistent and sound like you're centering the child and not yourself. She tells on herself in a million different ways and then gets mad when we listen. 38. The court finds that the permanent relocation to is in the best interest of the minor child, especially in light of mother's current incarceration in Ocala. 39. As such, the relocation petition is granted
Bon appetit.
by agreement of the parties. 3. Motion for contempt. 40. Although most of her motion involved respondent writing about her displeasure with the court's ruling permitting temporary relocation over her objection, respondent does state she is seeking to obtain, quote, missed, delinquent, or diminished alimony payments. See motion for contempt at page 1. Well, if you insist, Your Honorable Judge Jackson, I guess we must oblige. We've covered part of this multiple times, so might as well cover the entire motion for contempt. This is what she filed a year and 1 day after Brian filed his motion for modification. And that's why she's been in this uproar of, why won't people see my motion for contempt? Why isn't it doing this? Why isn't it doing that? It's because the modification order of operations had to be seen first, and then the motion for contempt. Sarah thought that a motion for contempt is a motion where you yell at him and say you need to pay her all this money right now, and then we'll look at the modification. Nar. So she didn't realize that her extending this year after year is the reason she didn't get her money sooner. If she had gone along with the timeline that was set and didn't keep pushing back and pushing back, like the trial judge said, or like the previous family court said, you can opt for a final judgment on this at any moment in time. And she chose to elongate it time and time again, which has resulted in this outcome. So let's dive in. Motion for contempt. Your Honorable Dean, Miss Coffey, per your instructions in our last meeting, petition to relocate on 3/29/23, after stating to the court my still ongoing problem with former husband and him not paying alimony to me, and your order to continue in the status hearing on 9/19/22. I am including my motion for contempt to obtain these payments and all missed, delinquent, or diminished. And that's the line that Judge Jackson brought up of, even though most of this motion for contempt was complaining over this relocation, she did technically say she was looking for delinquent or diminished payments, so we had to consider it. But also, this just means that she wrote a letter along with the motion. Because the motion can't speak for itself, she has to contextualize what she's asking for, why she's asking for it, and then she asks for it incorrectly, and then we'll still get mad at you. I don't get how she says she doesn't have a voice and no one's listening when she never stops talking, even for a moment. But also, kind of same. I am in the process of trying to figure everything out as it comes to me, and remember, pro se, so please bear with me and know I am doing all that I can to still utilize my rights, which seem to be tested or tried to be taken regularly, since I do not have money, resources, family, or an attorney. Former husband has in abundance, which was bluntly announced to everyone in the court by his attorney for whatever reason it was made to be necessary. I guess those without do without. But I'm still trying and always will. Yeah, unfortunately, we know that by now. But that's funny. She's mad. They call her ass broke. With your broke ass. In court, and she said, well, why did you need to announce that? I mean, you do it for us. So do you want everyone to know you're poor, broke, don't have any family, except for your 2 living brothers, so both of your siblings, apparently a half-sister, apparently other people that you just don't get along with and don't like you?
What family members do I have help pay?
Excuse me?
I'm sorry?
What'd you say?
My family members. Who is it that I can have help pay?
Philip's the only person.
Why is that?
Because your other brother's not really capable of doing anything. Oh. And your mom and dad are dead, and you don't get along with any of your other relatives.
Are my grandmother and grandfather deceased?
Well, I mean, you're almost 50 years old.
Damn! I'm sorry.
Most people, their grandparents are deceased at that point.
All right.
Ms. Boone, what's the relevance of these questions?
Because they're trying to make me seem that myself and no one in my family is contributing to my son. And it's difficult when my family is deceased and my younger brother is in the military on his 9th deployment in Israel. So
all right, ask your
whatever
next question. Ask your next question.
No resources and are pro se? Or are we offended when someone says that you're poor, broke, familyless, jobless, hopeless, and in prison?
Girl, prison, honey.
Which, to be fair, I probably would be jaded too if I were that broke, which is insane to me. Of like, she went into prison with literally nothing in the bank. And that's only by choice.
And does she or George have a job?
No. She hasn't worked for over 2 years. I mean, my alimony and stuff basically pays for where they live. So, I mean, they didn't need a ton, but, I mean, she was always calling to borrow money. And
She said her account was in the negative, so I transferred her a little bit of money to get her out of the negative.
But, it's been like 2 years since she got a job. She keeps on telling me she's looking, and she's always finding good opportunities and everything, but...
As many times as she argues about not having money, about not having this or that, there's no evidence that she ever tried to support herself on her own. She has always leached off of someone else with the excuse of my family's dead, so I need Brian to take care of me. Well, now I'm getting a divorce, so I need George to take care of me.
I don't give a shit either. I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on them doesn't make them yours. Even paid for them. I needed you to be a man and take care of me.
Well, now George has died in an obscure, unfortunate accident that wasn't intentional but was an intentional defense. Now I need the state to take care of me and to provide me with endless amounts of lawyers and care and this and that. She does not get. She is still a violent offender, a violent murderer. This wasn't her working 3 jobs, spread thin, trying to support and still couldn't keep the lights on. People are in that situation every day. This is everyone's taking care of me. I use all my money to get drunk. I will call my ex to bail me out whenever I want to.
She said her account was in the negative, so I transferred her a little bit of money to get her out of the negative.
My ex-husband is notorious for bringing my son over in very inopportune times when George is possibly drunk or doing things not appropriate for my son to see. And I just didn't know what to do. It was just a quick knee-jerk reaction. Brian was kind of my go-to person because of my family being deceased, and I don't have anyone else that I can call. And I just wanted to ensure that he would not bring my son over in the process of all of this at some point.
So you called him?
I called him.
So up top, she is saying this is about to be a whole pity party. Feel bad for me. I'm pro se with no money. They're bullying me. That's why I should win. She doesn't get that she's in her situation because of her actions and choices, not because of her lack of resources. But she'll find out one day, maybe in a few decades. I, too, am still in shock of the outcome for the petition to relocate. And blank, my minor son being advantageously taken 4 times the lawful amount, 50 miles, to move away from me, the other parent. As far as I'm aware, which is rare in this case as no one includes me on anything, I still have my rights, custody of my son, and am owed alimony. Nothing has been made permanent or signed to state otherwise legally, or has been discussed again and needs to be, where in my previous numerous attempts I have tried but told by you I'm doing it wrong. Nonetheless, you make known you do not read my letters, your JA does. For the 919 hearing, you addressed all my concerns in the letter I wrote to initiate and schedule it. Otherwise, how would you know to, if not by reading my letters? What am I doing differently this time? I thought my very legitimate, ongoing concerns needing to be discussed and brought to your attention would be in the case management meeting that was then canceled. Why? Because I don't have an attorney? I have rights and am desperately wanting and trying to utilize them, but it seems only when I, quote, do it correctly, I'm able. How am I supposed to know what's correct or incorrect? It is only made correct, I guess, with money and an attorney. If so, mine will never be correct, but you must definitely still get my intentions for everything, especially to save my son and be treated fairly. And that picks up with what we've talked about and covered so far of the I'm so shocked that you sided with them for the relocation. How could you take my son away from me? I have all of these rights that are being trampled on and nothing happens for me because I'm not doing it right. Yeah, girl, you have to do things right in the legal system. You don't get to say, oh, boo, I'm poor. You should just let me get away with anything I want to get away with and give me anything I ask for when I don't ask for it properly. Can you imagine if every impoverished individual who goes through the legal system in America, which is a large majority of the people who do go through the legal system, got to use the excuse of, I don't have the resources, so I win. No. And that's why a lot of legal cases can seem unfair when one side has drastically more resources. That's normally how most legal cases are, where the state will always have more resources than normal individuals unless you pull out that Karen Reed money.
Was that a read?
Yes, it was.
And she sticks to her good old statement of, why won't anyone address my very legitimate and ongoing concerns? Why are they legitimate? Because she's telling you they are. What are these legitimate concerns? She won't tell you what they are. You're supposed to just assume in the moment. I need my money. These are the legitimate concerns. He's bullying me. These are the legitimate concerns. My son doesn't love me enough. These are the legitimate concerns. Then she gets real mad when his JA reads her letters, because that's what JAs do. They filter out all the stuff. Judges are extremely busy. If you file a motion that does not fit the standards, that JA will read it and either have you correct it or just flat out reject it. Each individual judge does not have time to read personal handwritten letters from the jail. And a lot of times it gets passed on depending on how it's written and who's writing about what. But if it's just a letter to complain to the judge has more important things to do than read those all day. So they have their assistants who read it and say, hey, these are the issues that were brought up in this letter. If you'd like to read it, here's the full thing, but it's a mess, and this is what she's actually asking for. And then he addresses that at the hearing. And it is funny, she's just so insulted because she thinks that she's going directly to the judge, and she's annoyed that other people are reading it besides the judge before the judge. But yeah, do it correctly. If that's the only way, then mine will never be correct, okay? You act like that's supposed to influence anyone into doing anything different. You pull your side together, or you mediate with Brian and we don't even go to trial and we don't have to do all this mess. As we've seen so far going through this, there is so much of this that could have been solved maybe a month after he originally submitted this modification. But no, 3 years later, and now it's finally being addressed. Also, would I have known prior to the petition to relocate hearing it was really a trial, as I found out during? I know for sure I would have been better prepared and could represent myself even harder. But as usual, I was not included in that very important detail. I thought I had a chance, but in my opinion, your mind was already made up no matter what I said. Again, rarely am I included or made to feel significant enough to ever have anything of mine even mentioned. Why? Because I'm in jail?
Why is this happening?
Because George is dead.
It's okay to take the abuse nonstop from former husband because I have nothing? This is unfair and wrong. I still matter and am important, especially to my son. Okay? Not a single soul said you weren't. You are just trying to pile on the pity of saying, I am not made to feel significant. Again, it always revolves around or is anchored to her feelings. I'm not feeling significant enough to have my issues addressed. Well, are your issues legal issues? No, they're literally just complaints about how someone else is treating you, not the legal obligations or the legal issues that everyone is here on. He is saying, hi court, my ex-wife became a lunatic murderer and is now incarcerated for the rest of her life. Can I stop paying her $1,000 a month as though she were living on the outside? And you said, well, another court said you should pay me. So yeah, I mean, that's her only talking point. Her only support is that the order was in 2018, meaning he should still be paying today. If she had any actual legal arguments, they would be addressed. But she wants to waste all of her time on these side quests, which ultimately wastes everyone's time, and that's how things get extended from a 1.5-hour verdict over the span of 5 years. And she's calling the relocation hearing the trial before the trial. It's not a trial before the trial. This is literally called a temporary relocation hearing, meaning you were having the hearing to decide the temporary relocation order. She's probably calling it a trial because she had to get up there and testify, and maybe he had to get up there and testify. So she's like, well, if I knew this was a trial and that I would actually be asked questions and that I would have to ask someone else questions, I would have been more prepared. No, you wouldn't have. You've said this so many times. How many times have you said, everyone knows that if I was well informed, I would be more prepared?
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to.
And if this and if that and if only all the stars aligned and everyone gave me absolutely everything I could possibly ever want or imagine, then I could properly defend myself. And since all of that didn't happen, my rights are being trampled on. That's right, Linda. It's not even worth the extra effort just for her to blow hot air, because she goes on all these side quests, such as, do you know what hasn't been mentioned in this final order whatsoever? And I don't think it gets mentioned in the rest. Her personal property. This is another one of her things. My legitimate concerns I need to address with the court. I gave him my stuff and he won't return it to me. Did not surrender her vehicle and storage unit to her brother who lives locally and was coordinated to receive and secure, knowing the importance to both of them, the contents from their family who is deceased and to be passed on to her son.
I don't know if he's trying to utilize him as the weapon against me, and had told me that he was going to have to go into the judge's chambers with his attorney and how he was going to turn him against me. So, my whole storage unit thing, you can't not know that I don't think about that every single day. I think that's something that was in my storage unit that I think the devil is really trying to get one over on me, because these seeds of terror are planted almost on a daily basis, and he makes me think of my grandmother's jewelry, my mother's emerald earrings, my mother's Bible, my great-grandmother's cookbooks, my baby albums of me and my brother and my father, and just I think about it every day, Pete. I think about it every single day. And it's just, I have to be honest with you, and it's not you guys, so don't ever think that it's you guys, it's me. But it's I'm sick of talking about all of this same shit every day.
Imagine how tired we are. Imagine how tired we are of it.
It's the same shit every day, where it's just I asked God today, I was please, please, please give me some type of breakthrough, with this family law thing.
Signed proposed document stating he willingly abandoned Respondent's property he personally placed himself as liaison over during her incarceration and was voluntarily responsible for. What? What does that even mean? What does that have to do with time-sharing custody or alimony? You're just going to tattle to some random judge saying, order other people to do things for me. It's the same thing she got mad at Judge Jackson because she wanted Judge Jackson to order Mr. Owens, her criminal court attorney, free attorney, to give her back her files, as though Judge Jackson has any control whatsoever over anything Mr. Owens does. Unless he actually was on record representing her in this family court case, Judge Jackson has no authority to say anything to him. And then she blames Judge Jackson, being like, really? She can't do anything? I don't get why she can't just tell him to give me back my things.
Your motion to compel James and the motion for an attorney were both denied.
Okay, so what was with her compelling James? Oh, I see. So we asked for an order to compel him to do it. Okay, and then of course appointment was denied as well.
And then the appointment of an attorney. So now I think you file. I guess it would be the one asking the court to.
I don't know, Peter. Like it's one fucking blow after another.
Yeah, it's frustrating as hell. I gotta tell you.
Like, what's the point of her giving me 60 days if I can't acquire or obtain anything?
Yeah.
So now James doesn't even have to give me my stuff back. Is that right?
Mm-hmm. So here.
Did she give a reason? Or it's just no?
Just no.
Wow, she gives no reason whatsoever? Not even like a hearing?
Nothing. Just denied. So I think what we got to do is I'm going to have to print off all of those files.
What files?
All your case files. But here's the thing.
No, but here's the actual thing, is she just told on herself again. She doesn't actually care about getting her files, especially not for family court. She wants whatever James has for whatever reason. Because within milliseconds, he says, okay, if James isn't going to return your files, then I'll just have to print off all your files. What files?
I'm going to have to print off all of those files.
What files? What files?
What files do you think? You put in a whole motion to have James return your alleged family court files, unless you were just trying to get all of your alleged quote-unquote discovery, whatever you conceptualize that to be. You want another judge to compel him to giving you all those things, which he legally can't do. There's a lot of sensitive information in that would be illegal for a convicted murderer to have. Especially, I don't know, information about the jurors, because apparently she wanted to contact the jurors because she can't let anything go. So if there's even a whiff of an offense, she already forgave the jury at her sentencing trial. My gold goes out to the jury. For not understanding my cracks, for being blinded from the injustice and malpractice in all the judicial and prosecutorial errors, the very apparent violations of my constitutional rights during my case and entire trial, which caused mass confusion and dysfunction. I hate the jury, truly, for being weary from the confusion and dysfunction, also from being hungry and tired and wanting to go home to their families after being away from in full capacity for 2 full weeks. I understand. From this and their brash, misguided, corrupted decision, I was wrongfully judged a murderer instead of a survivor. For this, all is hated. For this, I can still survive and stand tall, having an even greater, the greatest opportunity to finally be understood in the Supreme Court for my appeal. And I guess she just wanted to send a postcard to say, I forgive you again, you piece of shit. So whatever it truly is, whatever her real goal is, it is not to get files for her family court case from James, because she's not even interested in it. He's saying, okay, I just need to get this printed off for you. And that idea never even entered her mind, because she is so laser focused on, I guess, the 2 boxes that for some reason she believes James has, even though she still has the USB with all of her files on it. So again, I'm like, what are you talking about? Everything was digitized. That was for your criminal court case. I don't know what you're talking about in regards to family court cases unless you specifically handed him things. And if you got his opinion on it, and if he wrote any notes on it, those notes written on those documents now make it his workplace product, and he does not have to share that. And he's not supposed to share that, especially not with convicted killers. Y'all are not best friends. Y'all are not anything. You literally got this attorney off of a circus clown ad. Okay, is it here? Is it? Oh, it's here. No. Oh, no. Ooh. Inmate seeks attorney. Oh, shit. What is this? This is a flyer. She's looking for a new lawyer by flyer. I will give her the credit of the effort it takes to go through this. I mean, she colored in and made her own font. And now you're mad that he's not helping you for the rest of your life? Child, no.
The problem is that even if I print them off and send them, they said it has to come through an attorney, your attorney, or the court. So, but you can't get it through the court because it costs thousands of dollars.
What case documents are you trying to print?
Like all your files, all the stuff that James has, that,
I know.
right? All that stuff.
So my question is, I just don't understand what the point of her doing any of that is. Like, she couldn't even grant the order for him to give me my stuff back?
She doesn't give this reason, but she can't just tell people to do stuff. It has to be like within her purview. And the reality is that he was never on the record as your family law attorney.
Nobody was on record as my family law attorney.
I know.
No way. I want to see the receipts.
1. Both parties appeared for the case management conference, which included a motion to withdraw by the respondent's counsel, Frank Bankowitz. Frank Bankowitz. 2. There were no objections to the withdrawal of respondent's counsel. 3. Frank Bankowitz is hereby removed as counsel for the respondent.
Nobody was on record as my family law attorney.
I know. And he was on record as your criminal law attorney, and you gave him that stuff as a part of your criminal case. So maybe what you could do is you could file a motion to the criminal court.
That means I would have to ask Judge Kranick.
Yeah.
I don't think that's a wise decision, considering the fact that he is the main concern in regards to my appeal.
What do you mean by that?
Okay, so look, because he's prejudiced against me, he's biased against me, he has a bad taste of me in his mouth, there's no way he's going to do that. And plus the fact that he's a main component of my appeal in a negative way. We're using him coming out of the gate with all the judicial errors he did.
Right. That's a good point.
What? That's a terrible point. See, this is what I mean by fake friends. New York is a fake friend right now.
You sound ignorant. You look ignorant. Bitch, I will be ignorant all over your motherfucking ass.
He knows that is not a good point because that's not how appeals work. The reason now it makes sense that she's asking Your Honorable Judge Jackson, is because she doesn't want to ask Judge Kranick. the actual judge who has any power to compel any lawyer in your case to do something. Wow. I don't think it's a good job to get him included, seeing how he is the main component in my appeal. He's all of your appeal. The whole appeal is just purely Judge Cranick. It isn't even about you. Like I said, she thinks an appeal is a chance to relitigate the case. No, an appeal solely looks at Judge Cranick's decisions throughout the entire trial and the entire process leading up to the trial to see if he made the right decisions or at least provided remedies to any potential mistakes or obstacles that arose. Appellate courts are already partial and deferential to the trial court, understanding that the trial court has to deal with a myriad of different obstacles that can come up at any moment. No one can purely grasp what it's like to be Judge Cranick through the written record. And they're aware of that, especially when it comes to difficult clients and eventually convicted murderers.
We the jury. Electric chair.
If you want things done, you message him. He has a bad taste in his mouth about me and he's prejudiced. Everyone has a bad taste in their mouth after any interaction with you. So it's not special to Judge Cranick. Plus, judges deal with this with every trial they have. Every single trial they have, there's a possibility for an appeal. There's still the trial court over that case until it is fully resolved. The appeal is dismissed. You can lock the door and throw away the key. Judges know how to compartmentalize, especially since they don't want any of their decisions overturned either. If you went to Cranick first and said, because Cranick has given you everything you wanted, because he knew this exact outcome was always going to be the outcome. So he lets you have this, he lets you have that, knowing that it doesn't actually change the facts of the case, nor the facts of your behavior, which led to your situations to begin with. All right, future me here. A little more on that. Judge Cranick literally predicted this behavior from the start, and that was repeated throughout the trial because he knew that even though Mr. Owens parachuted in on this, it does not matter who she had helped her. She is going to complain about her lawyer. She's going to say they were ineffective. She's going to say that they, stole all this from her, that they didn't do this, that they didn't do that. So he asked her repeatedly, multiple times, are you satisfied with your lawyer? And every single time she said yes, she was reaffirming on the record that she is satisfied with her legal representation. And we're going to look at a little compilation I came up with from Emily D. Baker's video, her 50-hour video covering the full trial. Y'all want to get on me for having an 11-12-hour video? That is some otherworldly numbers and aspirational. Maybe I'll do that with every single letter that has ever been released that I have covered on this channel. I might just put into a hyper mega video once all of this is over. Who knows?
Ms. Boone, I just got a couple of inquiries of you, ma'am, before release. Are you satisfied with your attorneys so far throughout this trial?
Definitely.
And are you on board with the strategy that they've employed?
She said definitely. I am shook. Ma'am, are you satisfied with your attorney? I've never heard a judge ask a defendant this before, and she said definitely. What? I'm back. We're going to run that back again.
Defense. All right, Ms. Boone, I just got a couple of inquiries of you, ma'am.
Never seen a judge do this.
Satisfied with your attorneys so far throughout this trial?
Definitely.
And are you on board with the strategy that they've employed so far in this trial? All right, thank you very much. We'll be in recess till 2 o'clock. Court's off the record.
Shocked. I am shocked. I thought we were going to be just playing You'll Never Be Satisfied from Hamilton this entire trial.
He will never be satisfied. I will never be satisfied.
But no, they are inquiring, and she is happy with it. Maybe it's just the clothes. She's like, I have clothes. I feel good. I feel like I'm being heard.
Ms. Boone, are you still satisfied with your lawyer's representation of you in this matter?
Absolutely.
Are you still on board with the strategy that they have employed in the use of your defense?
Yes.
All right, let's go ahead and stand and bring in our panel.
Yo!
Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up and until this point?
Yes.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can make most of the decisions about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Has anyone forced you, threatened you to get you to testify or not testify in this case?
No.
Has anyone made any promises to you to get you to testify or not testify in this case?
No.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making this decision freely and voluntarily?
I am.
I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay, all right. Are you on board with that strategy?
I am.
Are you still on board with the strategy utilized in your defense?
All of it, yes.
Are you satisfied with your lawyer's representation of you in this matter?
Yes.
All right, thank you. State, anything else we need to address?
Yes.
And similar to what we discussed yesterday, do you understand that your attorneys make the trial strategy decisions, including what witnesses to call or not to call?
Yes.
Okay. Are you still satisfied with their representation of you in this matter?
Yes.
And are you still on board with the strategy that has been employed in your defense?
Yes.
It seems that the court is going well out of their way to limit Sarah Boone wilding out on appeal. And it seems that these attorneys, though I have had critiques for the defense, that the attorneys have done a good job of client managing Sarah Boone, which cannot be an easy task. It might be why there's 4 attorneys. Emily, have you ever seen anything like this? I've never seen a judge colloquy a defendant like this, ever. Just ever. He knows, and this is his strategy to make sure that she can't come back and say, I didn't want these attorneys. They've, I don't agree with what they're doing. I wanted to stay self-represented. But she said very much on the record she did not want to represent herself. So,
and representing myself is not an option, as both judges have now threatened me with, from being outspoken and intelligent in all my observations of the ongoing abuse I am and have experienced.
I've not seen a judge go this far in that, but I think it's a good strategy. It takes, what, two minutes? So 2 minutes to protect this down the road.
As it relates to the state's witnesses in their rebuttal case, are you satisfied with your attorney's representation of you in this matter?
Definitely.
I will never be satisfied.
And with all that, there is no argument she could win in her appeal about ineffective assistance of counsel, which is ironically the one thing that did not show up in her appeal. When we get to that appellate brief eventually, they didn't bring up anything about the lawyers. Not one thing. Honestly, I was shooketh when I saw that. But the reality is she had legal representation. She did not have to go pro se. She did not have to do this on her own. And she more than communicated that she was happy with her legal team. She had a whole defense team. She went from 8 individual lawyers that all had to be conflicted out to 5 free defense team, 3 attorneys, 2, I think actually 4 attorneys, and 1 paralegal or assistant, all helping her for free. And she's still this ungrateful. Someone please tell her she is going to have to be involved with Judge Cranick. Even if she won her appeal, they said, we agree with you. This was so unfair. Justice for Sarah? I don't know.
Invest in the invest in the oppressed. Believe. I want a shirt.
You're going to have a new trial. Congratulations. Go right back to Cranick. Cranick has not shown any prejudice in this case in terms of unfair treatment. He's actually shown precedent of being partial towards you in ways that he probably hasn't been towards other inmates in the past, which now can bite him because people are going to be like, well, you did this for her when she complained. Now you need to do all of this for me. I'm the one who wants to wear this whole wardrobe thing. I want hair and makeup done. I want my snacks.
You know, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart to allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch, but she's not diagnosed with any kind of blood sugar.
She's not diagnosed with any kind of blood sugar.
But she says she gets, like today, she's feeling tired and lethargic, and so she feels like those items during a break, that she could have something like that to keep her energy level. I'm asking for the court's permission that she be allowed to do that. Now, when it comes time to trial, she would like for us to have some makeup for her and somebody to fix her hair.
I'm sorry, come again? She wants makeup and hair done? Obviously, a lot of that stuff she got denied, but she technically got the hair and makeup approved or not disapproved. So now someone can come up to him and say, hi, can I have hair and makeup? It's just ridiculous. So if it were really that deep and James really did have all of your stuff, you can ask Cranick, and if anything, Cranick would just write off and say, yes, return the stuff to her. That you legally can. She also has this misconception about discovery, not realizing that the discovery she had from the state is like borrowed. It's not actually her discovery. It is quote unquote her discovery. Her discovery is anything her side dug up. So Billy Lane or anything Mr. Owens did or the Three Little Stooges did, all of that stuff would be their discovery. But anything dealing with the actual court documents, dealing with any of the lab results, test results, documents from the state, this and that, was not part of her discovery. So she believes she owns a lot of things that she does not, including this alimony.
I'm just.
Can we put that on hold for just 1 second? I feel sick to my stomach. You don't understand because of that. So I just don't understand. Does she want me to just go and you know, start waving a white flag? Or I'm not doing that. I'm not surrendering ever. It's still the same thing. It's still the same thing. What you're trying to do is you're trying to get me to surrender. You know, expedite everybody's troubles and just say, F this, here you can have everything. I don't understand the point if we're doing that way.
I don't know. I like I said, I think that she doesn't give an explanation.
Like, how simple is it for her to say yes, give her her stuff back? I mean, why else would I be trying to contact this person?
Yeah, especially after you specifically said I can't get access to any of my stuff.
Okay, well,
I mean, look,
are you available?
At the end of the day, whatever happened, you're going to go to a higher judge and say, I was not given due process. I didn't have an attorney. I didn't have access to my materials. You have the right to defend yourself and to make a case. At the very least, your case documents. So I think we got to problem solve and figure out how can we get you one
attorney.
Well, the attorney, that ship has, I don't know what to do about that.
There is nothing you can do about that, because any lawyer you put in front of her, she will find an issue with, she will tear down, and they will run away. That is a fact at this point. An indisputable fact. She cannot work with any attorney. So she has to suffer. She has to say, I know more than everyone and about everything, but also I know nothing about this, and why isn't anyone trying to help me? And then they try to help you. Why is she going down the only one route she thinks she can take? There's more than one ways to win, and in more than one way.
Let everyone know who I really am, as opposed to the malicious murderer that everyone thinks that I am. I don't feel that she can do that properly. I still always, the reason why I'm here is hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying and see the bigger picture other than what's the one avenue that she keeps going down. There's other ways to win and in more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me.
Forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me.
And have a welcoming attitude, and things will probably change, and I will not get up and I walk out.
There's other ways to win, and in more than one way.
Never really understood what she meant by that. She, in her mind, she literally thought we could all come to a compromise where I get to go home and you get to feel better about me killing someone. And since no one can come up with that mythic proposal, then no one is working hard enough for her, or they don't care, or they don't understand, or this or that. But they're already previewing that no matter what the outcome of this final order was, you're going to go up to a higher judge and say that you didn't have due process and that this wasn't fair and that wasn't fair. And that you at least needed your court documents. Fun fact, they never say what documents they're talking about. Just nebulous family court documents. Like, what are these records that could help prove your case? Are these past orders with important information that you need in order to fill out something? Just nebulous, he has things of mine and I need that back, knowing that none of those things would actually help her in this situation. It's not her job nor her abilities, but again, Sarah thinks law should just work however she thinks it should work. So any judge out there in the world can order any other lawyer out there in the world to do anything that Sarah wants, and that's law. A disaster. Remember also, my circumstances are temporary.
Electric chair.
Court sentences you to life
Holy shit.
in the Department of Corrections.
God damn it.
With credit time served.
And no one can tell the future, but apparently the trial before the trial happened already after being told by you it would not in the status hearing, unless there will be yet another trial before the trial before the trial. If so, please include me prior so I know what to expect and what I need to do to properly defend myself as best I can against former husband's ugliness, torture, and attorney. I am already being told and profusely laughed at repeatedly by him. They're never coming back. It's all going to be made permanent, and I can't do anything ever about any of it. You see, Judge Dean, Henrietta, how even more terrible will I be made out by wanting to have my son closer to me, and is lawful, after he's established friends, school, activities, favorite places to eat, then all of this brought to you again to conclude and them be made to move away, closer as included in the temporary location paperwork. This is an absolute mess. Again, just emotional language with no actual points. How terrible will I be made out to be for wanting my child closer? You are in jail. You are in prison.
Girl, prison, honey.
There is no closeness there. There are literally guards, fences, surveillance equipment, and weapons that place literal and metaphoric distance between you and your child. It's one thing if you could, they should make this rule. Okay, if you go and knock on his front door and say, I do not want you to leave here, then he can stay. If you can't do that, then you have no right to dictate where they can live. If you can't even go to the place you're trying to anchor them, why on earth do you think you have a point? And also, why are you just disrespectful always? Judge Dean, Henrietta, you used a surname or like a more professional greeting up top, but now it's just Henrietta because you're mad that she reads your letters and not the judge. Now you feel like, oh, you think I'm not important enough? Correct. Yes, absolutely. You are not important enough for me to stop every part of my day and read this useless garbage. Because then let's give it the importance she wants. The judge having to deal with actual custody issues with actual vicious, nasty details that make it very hard to decide what parent gets what's best for the child. All these different factors are in play. All that has to go on pause so that you can open this letter. I'm being laughed at. He's making me feel bad. And they're saying there's nothing I can do about it. Can you believe I am poor and in prison for murder? I'll never let it go. This isn't just a drug possession. This isn't just you stole something from a store and now you're locked behind bars for some non-violent random offense. This is the worst capital offense you can possibly do. Murdering someone is the highest level of danger, of importance, and of restrictions and limitations on your rights if convicted of such a horrific crime. No one can tell the future. Yeah, but we can literally watch the past because you recorded it, and that informs what the future will be. Those videos did not capture the moment when George died, but they informed that that future would happen. Those videos also informed that this life imprisonment would happen.
To life in the Department of Corrections with
electric chair.
To this day, she still can't talk around those videos in any kind of coherent way because there isn't one. Yet we're supposed to play dumb. A judge is supposed to pretend that they don't know any of this. And they may not know this, but odds are they do. And then another lack of awareness moment of why would you try to leave when he has school, friends, activities he has here? And it's been cited and documented that he is facing school bullying. The exact factors that you think he should stay here for are the reason that they are currently harmful for him. But you do not care about the best interest of the child. You have made that abundantly clear in a million different ways. You care about your interest. Or will it automatically be awarded to them like everything else, and all their wishes come true permanently? Because I will have nothing and no one to help me figure any of it out when the time comes. If I even do it right in my hopeful attempts like I have been already, please tell me now so I know what to plan on, considering everyone seems to have a crystal ball but me. It's only fair, and I should be included. From everything I have experienced so far with judges, courts, lawyers, etc., it seems true already everything will not be in my favor from the truly unjust way I have been treated and am still in this case. Is this how the quote justice system really works? Maybe it's just me that with nothing that it does, it only makes everything harder and more disappointing. If you're a no one with nothing like me, all you get is a hard time, innumerable hoops to figure out, with to jump through and laugh at, all for nothing. Yeah, damn right, all for nothing. And you've known this from the beginning. You've known that all of this has been for nothing. And that's how she reframes arguments. And you've seen this in past body cam and past interactions. Whenever she's confronted with any issue, as a way to sidestep and avoid the issue, she makes the conflict about addressing the conflict. So now it's unfair because you're yelling at me when I'm poor, not that I just tried to strangle you and you want to talk to me about it, saying, why did you do that? Well, why did you come down here and yell at me? And then we'll spend hours talking about the conflict within the conflict. And then that's how she squirms away from any trouble that she finds herself in. However, you can't do that during a murder trial, because it all anchors back to the fact that a man is dead because of you. And no matter how many times you want to sidestep and say, you're only treating me like this because I don't have any money.
I would like to say that my incarceration has nothing to do with me as being a human being and a mother to my son. It's not fair to me that just because I'm here, it doesn't justify how I've been treated and excluded.
Okay, well, it's not fair. It's not fair. It's not fair that you guys automatically blame it on me. It's not fair. See, that is just not fair.
I've been avidly striving to and will continue my pursuit to be even more meaningful to my son in my continued hard-fought efforts to see him in person while temporarily located at DOC and in the meantime of my appeal and my release and all other positive aspects that I have with my son on the horizon. And I'm trying to be my son's best advocate for myself. Each parent and everything they're supposed to abide by regarding being appropriate to the other parent, regardless of incarceration or not. That's what I was trying to say. I've been excluded this entire time, and everyone has blamed my incarceration on it, which it shouldn't be like that because I'm still the mother of my son regardless of where I am.
The assumption being, if she had taken those videos and if she were rich, then she would be out by now and everyone would treat her differently, even though she still killed a man. And you just see it echoed in this whole motion. This whole motion has been about, how dare you side with them for the relocation? I was unprepared for the final hearing. You know, if I were prepared, then I would have fought for myself harder. And this is so unfair. I have no family, no money, no resources. Everyone's against me. Why is everyone not listening? This is unfair, da-da-da-da. Never once addressing the actual issues that she wants dealt with, which is the unpaid alimony and why she should have been paid. This is all ancillary nonsense that doesn't have any real impact on how the decisions will fall either way. There are arguments she could make to help herself. She refuses to make them because she wants to bring up every petty offense imaginable to try to guilt you into forgiving her for killing someone. And not even to ask for forgiveness. She really just wants you to forget it. Literally do not acknowledge it whatsoever. His suffering, the pain that caused, that rippled throughout the people in his life, and even the people who have just connected with George from finding out and learning about this case. That pain is real for those people who feel sympathy and feel that it hurts within them to discover the things that he went through and the things that she refuses to accept, and the blame and pain that she still continues to inflict on others around her. And I think that's the difference between other cases and this case. Why people keep coming back to this case is because it really is still ongoing. She is still abusing people regardless of the domain she's in. A lot of these other viral true crime cases, a lot of them kind of die down after the person's been put behind bars for the rest of their life because they kind of just chill the F out. Not many of them are still contacting their victims, sending people to their houses, hounding them every single day for money, making personal attacks, demanding all of this emotional, financial, and physical support from individuals she has been and continues to harm. Judge Dean, you stated in the relocation hearing also, it's a, quote, fresh start for son and former, quote, husband to move beyond the 50-mile radius away from me. Why would you allow them to, quote, start before knowing anything of my outcome? Why? I guess I'll never get my, quote, fresh start from everything being made so impossible and arduous before anything has been happened and after, when, and if it does. Jesus Christ. How much does it cost, please, to look into someone's crystal ball? Anyone's?
Oh, wait, I have no money or attorney. Please include me. Think positive. Miss Henrietta, if when reading this, please take notes so it can be relayed properly and correctly, if at all. If it even matters, according to former, quote, husband, quote, none of what I do will make any difference in anything, and I shouldn't be worrying about any of it. I'm going away for a very long time.
To life in the Department of Corrections.
Will be an adult. I will probably never have to worry about it. Thank you both for your time and understanding. I matter. Sarah Boone, Sarah Boone.
Cool. No one said you didn't. Just more woe is me. How, it's just what we've covered before. How dare you allow them to move more than 50 miles away from me? There's that narcissism speaking, and it doesn't really work in the legal system because it just flashes red lights everywhere. Like everyone has said, there is no articulable reason aside from her saying this goes against the current agreement and parenting plan. So you can't do this because it's only lawful, even though we are doing a lawful court proceeding in order to modify said agreement since your incarceration. No new points. Only point is, look at this paper from 2018. Ignore everything now. I swear she must have some trauma with a crystal ball because it comes up everywhere. It is the most tired metaphor that does not land with anyone ever. But I will give a little credit. She was a little clever with the how much does it cost to look into someone's crystal ball? Oh, wait, I can't afford it. Yes, you better be broken proud.
Insufficient poor people around. You ain't got no money, y'all, with your broke ass. Woo.
It's like, how many more ways can you say I don't have money and that's why I'm failing? Because ultimately, at the end of the day, zooming all the way out, all of this is just a prolonging stall tactic. She has known to her core, and she knows today, that she murdered George. She is ashamed of that because that hurts her ego. People think that she is a murderer. She doesn't see that in her mind, even though she factually is. So to prolong that being official, she drew out every single court proceeding imaginable past 5 years. She was completely confrontational with every single lawyer she's ever come in contact with. She believes she's in the right because she deserves to be treated equally, and she's not wrong for having these standards.
I am not the problem, except I want to and should be treated fairly, with respect, acting more professional than the paid. I've been doing this for over 40 years, professional. After so long, and in all the experience, common courtesy, customer service, and listening skills should have been acquired. All attorneys. Do you remember why you even wanted to be one? Remind yourself. No one listens, and it works for everyone's favor but mine. That I am a murderer, stuck in jail so they can pin on me. They're uninterested, unmotivated, hopeless. They're going to believe me over her haughty attitude. I am not wrong for not thinking less of myself, because everyone else has and does.
Yes, you are when you have no money and you're paying for none of this.
Poor people around. You ain't got no money, y'all.
And she's not actually dumb. She knows this. But she also knows I get a free attorney, and if I just keep burning through them saying that none of them meet my impossible standards, then I can just keep prolonging this again and again, and he is supposed to be paying me $1,000 a month Every single month I'm behind bars until I get my $67,000. And then once I get my $67,000, then I'll be able to figure out my life. I'll be ready to finally go to trial, and then And that's where that plan cuts off every single time. Because no matter how many times, no matter how many directions you pull it, how much time you waste, how many red herrings you send out there, at the end of the day, when everything is quote unquote equalized, when you have gotten all of your little minor requests, when everything has been set perfectly, the whole table looks perfect for you, still going to prison for life.
To life in the Department of
Prison!
Electric chair.
It's just ridiculous. It's like saying we see a speeding car going towards the edge of a cliff, and she is saying, wait, because the car has not hit the water yet, that means it might not go barreling over the edge, even though it is millimeters away going 60 miles an hour. And she expects some Looney Tunes God figure to come out of nowhere and say, oh, I see this car is now over the ledge. Let me just place it back and we'll just pretend none of this happened. Did that metaphor work? Maybe I ate.
No.
Oh, I guess this is the official motion for contempt. I am losing my voice. Motion for contempt. Comes now, Sarah K. Boone, respondent, submits her motion for contempt for non-payment of alimony by Brian C. Boone, petitioner, and in which was court ordered by Judge Michael Dean to continue being paid to respondent in the last and only status hearing, 9/19/22. Which isn't even true. That's just the interpretation she took from it, but it wasn't what actually happened. And she wrote that whole kiss-ass letter after the status hearing of being like, oh my goodness, thank you so much for doing all this. You heard me, and I know that my pleas won't fall on deaf ears. Thank you, you angel, and just love bombing the judge for absolutely no reason, because he didn't actually side with her. He just made everything temporary. Dear Judge Dean, I wanted to take a moment to thank you for allowing me to be in attendance during the case management meeting last Monday, 9/19. It has been such a long time since something good and real has happened to me since being incarcerated for ongoing 3 years almost. I thank you profusely for helping me, listening to me, and having an open heart and mind to see me as a human being, a mother also. Your invaluable time, empathy, and understanding are beyond appreciated. Thank you for seeing me. I am so impressed, and my sincerest gratitude cannot be fully expressed for your kindness and goodness. I look forward to any future meetings there may be, and am confident my hard work, determination, and efforts will not return to me void or fall on deaf ears. A victory indeed in my battles in preparation for the war on the horizon. I will not creep away as I continue to be brave and fight on. Thank you for giving me hope more than you know. It was an honor to meet you. Your honor. As sorrowful, yet always rejoicing. As poor, yet making many rich. As having nothing and possessing all things. 2 Corinthians 6:10.
Oh, that she thinks she's high and mighty, and she reads her Bible, and then this, and then that, and then this, and this is why she's here, and all this other mess and everything, while she reads her Bible. Bible.
She's not a Christian!
She could be a Jew and
P.S. Thank you for seeing that crystal balls don't work at all, ever. Dust catchers. Sarah Boone.
And temporary just means we're going to put everything on a pause, and we will revisit this after your criminal trial, and we know exactly where you will be for the rest of your
life in the Department of Corrections.
We could do this now, and you have the option to do this now, but you don't want to.
8. The respondent expressed frustration at not having matters heard and not being adequately informed about her case. 9. The court explained that the family case is on hold pending the outcome of the respondent's criminal case. 10. The court finds that permanent decisions regarding relocation and alimony should be postponed until the adjudication of the respondent's criminal case, so that circumstances are clearer. 11. The respondent was informed that she may opt for a final hearing on the petitioner's petition for alimony reduction elimination and her own contempt motion, but that the court would have to consider her current status of incarceration when making determinations.
So we'll make things temporary. That means everything stays as it was. Yes, you should technically be getting paid money. He's not modifying and giving Brian what he wants at this moment. It's on a pause. But conversely, Brian doesn't have to change his actions because he already filed the petition. In normal cases, this just would have went straight to trial and they would have been way done before her actual criminal court trial. But she made a big fuss. She didn't have any leg to stand on, so she wanted to prolong it as long as possible. And now she's taking that prolongation as an order for Brian to keep paying me. Those words never came out of his mouth, nor were entered into any physical, documented court order. But she says, if I just keep saying it, that makes it true. Nah. Since during and prior to respondent's incarceration to 2020 present, petitioner has completely withheld and or diminished incredibly the promised $1,000 monthly payments, stating repeatedly the respondent is, quote, not important and, quote, not priority. This money owed to the respondent is overdue, ordered and needed to be by the only source of income to make any all necessary purchases. Also, petitioner agreed to, signed, and made responsible for all said payments in the active court-filed dissolution of marriage, 2017. Respondent is seeking all delinquent and arrears payments and all current payments of $1,000 going forward to be made to the designated account of her choice. Wherefore, Sarah K. Boone, respondent, respectfully requests this honorable court to please grant this motion for contempt, entering its order for alimony payments, delinquent funds, and arrears to begin immediately and without difficulty or confusion by Brian C. Boone, petitioner. Thank you, Sarah Boone, Sarah Boone. So that was her official motion, and that's all you really had to say. You didn't have to bring in the relocation. You didn't have to bring in he's treating me this or that. Still, this motion is still inappropriate in the way it's written, but at least it's more concise and actually anchored in what you're asking for, which is the unpaid alimony. But what's her support even in this motion for contempt? He hasn't paid. He says I'm not important, laughs at me. However, he signed this form in 2017, so he should still be paying. So make sure that he pays without zero confusion, Judge, so that Brian, this stupid idiot, knows exactly what to put in my account. And luckily for Sarah, it has been clarified for Brian. You do not have to put in $67,000. You have to put in less than $5,000. So I'm glad those things have been cleared up. All of this could have been avoided if she mediated, because for some reason Brian was more than willing to do so. Well, not for some reason. Trials cost so much money. He spent over almost $20,000 throughout the whole span of all of this. He could have given her a little money. They could have cut ways. They could have tried to work amicably and move on. But no, it has to be her way or no way. And every time she gets no way, she is shocked, because she never really ran into hurdles like this in her life. She has always been able to talk around it or to make you feel bad enough to just give in and give her what she wants. And she makes it your job to come up with the compromise. How much would you settle for? I don't know. I don't have a crystal ball. Okay, then you're not advocating for any part of your side at all. You're advocating for 100% everything you are allegedly quote unquote owed, despite the substantial change in circumstances.
Why is this happening?
Because George is dead.
You're not going to address that. You're just going to say, give me money, give me money, give me money.
Send me money, send me money, send me money.
If you went up there and you said, hi, I will leave you alone. I will not message you again. Give me $10,000. He would have absolutely said yes. If you had promised to cut back, be respectful, be amicable, take the $10,000, stop begging me for money, never ask me ever again, he would have done that. Now you get less than $6,000. Okay, let's get back to the actual final judgment order in the end of this detour 4.55. I don't know where we are. We're in hour 7. That's where we are. 41. Petitioner acknowledges that he did not pay $15,000 in alimony for 15 months between respondent's arrest, February 2020, and the filing of his modification petition.
I stated in my opening statement, but I'm going to ask you here while you're on the stand, is it true that when Ms. Boone was incarcerated in February of 2020, you stopped paying the exact $1,000 a month alimony amount that was in the final judgment?
Yes, I would, through Zillow, through my bank, I would send her the $1,000, and with her incarcerated, she couldn't even use her checking account, so there wasn't really a reason to do that. So, at the very beginning, her idea was.
Okay. And again, my plan was not to leave him in the
And what was
sick
your
case.
plan?
She kind of kept notes of everything I was buying for her to kind of tally up how much I was doing, and then we'd figure it out at the end, and then.
Pure blank to Walmart. He wants a bird feeder. He said there is a blank lands and tells me about the cardinals and other birds. He said blank. We're talking about springtime and Easter. Put it on my tab. Put it on my tab. Buy blank. Know what I owe you. Let me know about the tooth so I can put on blank.
I think she said put down in her notebook or something like that, but the texts are cut off.
Why do you keep doing this? Why did you allow blank much wasting $67.50? Wasting $67.50 because I communicated blank understanding. Also that I have it in writing to add to all blank the breakdown so you are aware. $100 minus $67.50. Negative blank renew $5 each equals $17.50.
Come on, math.
Minus $13.20. Stamps equals $4. You bought $13 worth of stamps? Damn. Equals $4.30. $4.30 is enough, I guess. Blank food and coffee, which you keep telling me you will, or blank order blank nothing to date, but you keep telling me you did or will order. Positive 422 order. If not, I will still have no food blank. You still make me wait and beg until you decide to
Send me money, send me money, send me money.
Did you waste $67.50? Add more funds.
Send me money, send me money, send me money.
I need envelopes, blank, etc., etc. How many more times do you want me to ask?
Send me money, send me money, send me money.
Blank, remember I have told you there are certain items that blank commissary only. Everything I still need. I cannot mail, blank. I need to receive on time. I cannot mail if my other 9 letters, blank. Figure it out.
Send me money, send me money, send me money.
Respond. Why did you waste $67.50? Oh my God, you hear that? She is such an abuser. Why did you, Brian Boone, waste $67.50, even though to this date, I guess, I don't know, but to the date of where we have read, you have not sent a single message.
1 year turned to 2 years and to 3 years. And
Okay. And eventually you stopped making any payments to her?
yes.
Okay.
42. While petitioner acknowledges that he stopped making alimony payments after the respondent's arrest, petitioner testified that he did not pay alimony because after respondent's incarceration, he had nowhere to send the alimony payments.
He helped move items from petitioner's apartment upon her incarceration. He paid for storage unit for her items, and he made $600 worth of direct and or in-kind payments to petitioner prior to the date of filing, including giving respondent commissary money.
Do you know approximately how much per month for that period of time that you were continuing to make her payments, how much money you were giving her that was not things you were paying for her for, but actually direct money to her?
Probably say about $600 a month.
Okay. And when did that stop? When did you stop doing that?
Probably close to 3 years into it, something like that. It was after like her first court-appointed lawyer quit on the case is kind of when I gave up, because I just felt she was kind of delaying things at the time and we were never going to get to a trial.
Okay. Were you still paying her some money after you filed your petition to modify in April of 2022?
Yes, I think I was still.
You're still paying her some money?
I believe so.
And in my opening statement, I mentioned...
I know I was still doing the storage container at the very least.
Okay, that's why I wanted to ask you
other stuff I was doing also.
Okay, so how much were you paying for that storage container?
Well, locker, sorry. I think it was like $240 a month, something like that.
And was that a mini storage facility?
Yeah, it was like a, what was it, probably 10 by 10, 12 by 12, something like that.
Okay. And when Ms. Boone was first arrested, did you help move those things into that mini storage facility?
Yeah, I did. There was nobody else in her life to help her, so it was me.
Okay, so you moved her stuff in there, and then you paid the monthly fee.
Yeah,
for
I had
the
to
storage.
rent a U-Haul and physically move everything, and yeah.
Okay. And when did you stop paying that? Do you remember?
I think it was a while after I moved.
Okay. And when you were buying things for her, what were the type of things you were buying for her?
Hot meals, gift baskets, just money in general on her account, whatever it is, thing in jail, phone calls, excuse me, stuff like that. There was probably other things. I mean, presents she'd want to get, she obviously couldn't buy them, so I would buy them, and yeah.
So you'd buy presents with your own money and then make them presents coming from her?
Yeah. Christmas and birthday and yeah. Okay. Yeah, she'd have a list of presents she would want me to buy him, and I would buy them and wrap them up for him from her, so.
43. While the court does not find that petitioner's post-incarceration gestures absolve him from his alimony obligation, the court cannot find an intentional and willful violation of the final judgment under these unique circumstances, including respondent's long-term incarceration, petitioner's inability to make Zelle payments, and respondent's lack of a bank account that she can access. 44. As such, petitioner's motion for contempt is denied.
Bon appetit!
As to contempt, but granted
Bon appetit!
as to enforcement of petitioner's $1,000 alimony obligation for the 15 months prior to the filing of the modification for a total of $15,000. Which still makes sense because even though she's enforcing the $1,000 alimony payment, it's also she has decreased that $1,000 to $145. So now that enforcement is that she is going to enforce the $145 payment over the yapataba.
Sometimes I'll start a sentence and I don't even know where it's going.
And that was the whole section for the motion for contempt in this final judgment. She, for years and years, have said, sanction him, punish him, hold him in contempt, punish. Everyone wants to hold me accountable for my alleged crimes of murdering someone. What about his crime of not giving me free money? And after all that, she even put in another motion for contempt at the trial, right before the trial, for him not submitting the visiting application, which was never put down in any order. So the judge said, I literally can't hold anyone in contempt if there is no lawful order that they are violating.
After the pre-trial conference, he also was under oath as well and told the court that he made an attempt, and he has not made an attempt. Nonetheless, that was 3 months ago. And you did give them verbally a 2-week deadline. And again, verbally, his counsel volunteered to
All right,
submit
Ms.
the
Boone, I
application.
cannot enforce any verbal statements that were not in an order. I specifically put in the order because there was no motion at the time. We did address it, and I did want there to be note that we addressed it, but there is no specific order requiring Mr. Boone to do anything by any specified period of time. And by law, because there is no order, I cannot hold him in contempt for failing to comply with an order.
Is there a way that it's been 9 months that I've been asking from him to submit these visitation applications? There's no legitimate reason for him doing so. And I don't have any record of who he spoke to supposedly when he did try to contact DOC, and then also a confirmation that he's done it this time, 9 months later and under oath. How can I go about doing so to make sure that this is actually being done?
All right. With that, I am going to deny without prejudice the motion for contempt.
Bon appetit.
I do not find that there is any willful violation of a specific court order with regard to a visitation application.
So that motion for contempt was always going to be dead in the water. This one actually had some more merit. However, the way it's written and the things that it doesn't acknowledge completely undercuts all of it. She never once acknowledged that he got the storage unit, got her stuff out, paid for the storage unit consistently, put commissary in her account, bought her food packages. Of course, not at the frequency which she wanted, but these things happened, and she said he's done nothing this entire time since I was incarcerated. And if what she said was true, and as soon as she went to prison, he gave her nothing, didn't help her at all, just cut all ties and kept going, she would have a stronger argument. But he didn't. That's why she didn't find any willful violation, because he was making payments. There are receipts, there are acknowledgments from both sides. He's paid for every phone call. He pays for gifts for your son on your behalf. He does absolutely everything for you. Everything. So no, given these unique circumstances, this is not a willful violation of a court order. The only thing that he did wrong is he should have submitted that motion for modification the day after you were in prison. February 26th, he needed to sign that up on his lawyer and said, put that in there so I don't have to pay her anymore. If he had done that up front, she would be owed nothing. So in the future, she can't say she wasn't listened to. Everyone heard absolutely every complaint she could possibly lodge, and it held no merit whatsoever. She's just so offended by everyone calling her a murderer and a criminal that she wants everyone else to be deemed criminals as well. Well, he's breaking the law. It's unlawful for him not to pay me. Well, it's unlawful for you not to talk to me. Well, it's unlawful for you to take my lawyer away. And that's a projection that a lot of prisoners go through because of the labels that they now have to assume because of actions. Sometimes, very rare occasions, not rare occasions, I mean, I wish it were rarer, but in some instances, people are absolutely innocent and have to take these scarlet letters that aren't theirs. This ain't that.
For me, experiencing ever being arrested and after today, prison. For destroying my reputation and integrity. For my M for murderer scarlet letter.
She begged for her scarlet letter. 4. Request for attorney's fees. 45. Petitioner seeks an award of attorney's fees and costs. Specifically, petitioner seeks $12,050 in attorney's fees and costs through July 29, 2025, as well as fees and costs for the preparation and attendance at trial. 46. The court evaluates the following factors under Rosen v. Rosen, footnote 5. Ba-da-ba-ba. A. Financial resources of both parties. Petitioner is an out-of-work software developer, but he stipulated to imputed annual income of $60,000, where he owns real estate and has tangible assets. The extent of his liquid cash is $1,306 in a trust checking account.
Oh, trust checking account. You got your money. He got money. Get it all for him.
See petitioner's financial affidavit filed on April 25th, 2025. Respondent, no ongoing monthly income, but she is entitled to $22,220 in alimony arrears. See paragraphs 24 and 25. Guessing that was a typo. I meant 20,000 and not 22,000, but there's a lot of typos here. But yes, this is the section asking for attorney's fees. Because Brian waited until 2023 to send in his petition to modification, those 26 months were always going to be up in the air of something that they're going to have to either talk away or deal with. And the way that they're dealing with that is by asking if the child support payments and the attorney's fees can be used as credits to offset anything that they might potentially owe Sarah, which Sarah never truly got or didn't care to get and just wanted to talk around it, because the main arguments are Sarah's in prison, meaning her financial need has extremely substantially decreased, as well as we have had to pay so much to cover what she can't do. Linda, you never miss. That's exactly right. Brian's also arguing that we have paid for everything. Had to pay for everything dealing with the son, everything dealing with this trial, over 12,000. I thought he said 14,000 at trial, but that might be 12,000 plus the appearance fee at trial. Which, to be clear, Brian still had to pay that. Sarah wanted to frame her arguments against it as, I can't believe they're trying to charge me his attorney's fees when having an attorney is a choice.
Okay. In regards to attorney fees, is having an attorney a choice?
Yes.
G. Attorney's fees and costs. Respondent continues to attempt to understand her position of defense against the petitioner and his request to charge her with his attorney's fees. As in the supplemental petition, it states, due to not signing their joint stipulation and in their pretrial memorandum, quote, resulting from the chaos created by the respondent's criminal conduct. 1. The petitioner and his counsel did not ever, quote, attempt to come to a resolution on these issues with the former wife without the necessity of filing a contested supplemental petition for modification, as stated, nor, quote, the former wife would not sign the joint stipulation, which resulted in the filing of this action. This supplemental petition to modify was received via summons to the respondent with no other correspondence or notice of any kind provided prior, as suggested, to avoid any presumed cost incurred from this filing by the petitioner. To clarify the untruths for the court to fully understand their self-inflicted costs and confusion, the timeline is as follows.
Other than case law, Ms. Boone, did you have any other evidence that you wanted the court to consider?
Yes, I did. I had some other exhibits that I would like to have put into my evidence, and then I also was supposed to speak about the attorney's fees.
I've given you lots of time to speak about all the issues. The fact that you didn't take that opportunity instead of going into other issues is not what the court is going to address now. What specific exhibits do you would like to move into evidence?
Your Honor, forgive me, but I'm here on the phone trying to do all of this.
When I ask you what other exhibits that you want to put into evidence.
My number 10
is having an attorney a choice.
Yes.
Ooh, burn. You got him there. It's like the dumbest thing I've ever heard. You chose to have an attorney, so you should have to pay for your own fees, even though having the other side pay for legal fees is a regular thing that people ask for. Which is ironic because isn't it her side who keeps asking for the appointment of a free attorney? And like, how dare they not appoint me a free attorney in my family court, civil court trial?
I know there's no way that we're supposed to be waiting 60 damn days for this to be submitted, for her to review it, and then say, okay, now what? And then have pre-trial what? He's trying to push pre-trial or trial like 2 or 3 days afterwards.
A huge help here would be if we could get the judge to appoint you an attorney.
I'll trade in my life. Do you understand? Listen, I will trade in my life. I'll trade in my life. Do you understand? Listen, I will trade in my
Life in the Department of Corrections.
For the rest of it, whatever I need to do, please, God, see if you can get me an attorney. Please, God, see if you can get me an attorney. If I'm just please.
Yeah, so I think what we need to do is we need to ask the judge for the court's help.
Is it like a secret where, they don't just, they don't offer it because they don't want to pay for it? Or like, I don't understand why nothing's been done for me or anyone else in the past.
If they really wanted to be petty, I would have responded, is murdering someone a choice? Okay. The same thing with the child support. She's like, they're trying to charge me child support for this $300 when how are they going to know that I can make that much? She translated it as they are assuming she's going to have a job of minimum wage when she gets out, and that is what they are imputing what she should be charged now, because for some reason she still thought she was getting out. Not a single other soul ever thought that you were getting out. Not even New York thought you were getting out.
This one right here, I see your heart, and it's ruthless, it's black, it's ugly, and I know why you're in this
prison, honey.
Because you're a demon, and you're demon possessed.
Wow. From the beginning, we never believed your innocence, but we gave you the benefit of the doubt. That courtesy has run out. You are a murderer. You planned this. You locked someone in a suitcase, listened to him beg for his life, and did nothing. Then you tried to cover it up with a childish lie. You threw him down a flight of stairs, you beat him with a baseball bat and mocked him as he pleaded for his life. And this was all a plan. You wrote to George's brother that, quote, hide and seek you shall, well before this murder ever took place. The emails, the story, the timeline, it all exposes you. The world isn't stupid, Sarah. You are. If you need proof, just look at the simple fact that you could be out of jail by now if you took responsibility, showed remorse, and took a plea deal. But the demon that is inside of you wouldn't allow it. You've shown no remorse, no apology, no regret. You are dangerous. You should never see freedom again. Your son is better off without you in his life. And if you cared about him, Sarah, you'd put him first instead of dragging him through the shadow of your crimes. The point being, the amount of resources that have been expended over having to deal with this back and forth with her more than outweighs what he's asking for. B. Scope and history of the litigation. The initial dissolution proceeding took 197 days from the filing of the petition to the entry of a final judgment, which included the distribution of real property, equitable distribution, time-sharing, parenting plan issues, child support, and alimony. There was little to no activity in the court file from the entry of the final judgment until the filing of the modification petition. Footnote 6. There is a letter from the clerk's office to Respondent, quote, clerk's letter on April 12, 2021, wherein the clerk notified the parties that, quote, records indicate that the clerk of courts does not have a correct address for Respondent on file and is unable to send child support payments. The scope of the post-judgment proceedings involved relatively straightforward issues on child support and alimony modifications, terminations, as well as the temporary and permanent relocation to which Respondent eventually consented after years of objecting. She is saying, this shit was simple. Why did it take this long? C. Duration of the litigation. The post-judgment proceedings, for which petitioner is seeking attorney's fees, unnecessarily spanned 1,231 days from the date of the filing of the modification petition to the final hearing on relatively straightforward issues. And I think that's the part that annoyed Judge Jackson the most, that Sarah still hasn't picked up on today. The fact that these were such simple issues. The scope of the litigation, this isn't terminating her parental rights, which can get super messy and you have to dive into all these different issues. It is saying we are modifying the parenting plan that we both have been breaking for the past 5-6 years. However, we're not going to go through and redo the whole thing. We're just going to modify these little things, and that's the time sharing, the parental responsibility, the child support, and the alimony. In Sarah's mind, this trial was to take away everything she has, all of her minute life resources, because she likes to overinflate everything. She said multiple times, he's trying to take everything from me.
I am no longer going to willingly make it easy for former husband to advantageously rob me of my last and only minute life resources out of bitterness, greed, and spiteful opportunity.
And that's how she approached this case, as though everything was on the table. And then when she kept getting redirected again and again, saying we are just focusing on these issues, the whole relocation debacle, she kept hearing the word relocation, her eyes went red, and she kept saying, I thought we already agreed that everyone is moving, and she just couldn't get past it because she didn't want to take the time to understand what was happening. They explained it to her multiple times. And then has the audacity to get mad at Brian, and I guess the court being like, why is this being proposed, seeing how I am here? And Judge Jackson goes, pretty sure that's the whole point of this.
So the overall plan starts off with every other weekend from Friday evening until Sunday evening between the respondent and the minor child. How is any of this even applicable considering the fact I'm at DOC?
I think that's the whole point of this, ma'am.
I'm not sure what I'm supposed to do. And am I supposed to object to it? Because I object to it. It
We're
doesn't
here
make
for a
sense.
final hearing. Whether or not you object to it is not relevant at this time. The court is going to make a decision based on the evidence that is presented today. The court's question for you, do you have any additional questions for Mr. Boone regarding the proposed parenting plan, the request that the alimony be discontinued, or the request that the child support be discontinued, or the request for attorney fees?
If you could just give me a moment, please.
Okay.
Forgive me, I don't know what I'm supposed to be doing with this relocation. For the relocation parenting plan, which I was not aware of, this was on our to-do list today. I thought it was the original parenting plan. I don't know what I'm supposed to do or how I'm supposed to answer this. Brian, how can I exercise every other weekend from Friday evening until Sunday evening between the respondent and the minor child?
You can't.
How can a prisoner and respondent alternate winter break and Thanksgiving time sharing?
You can't?
Why has this been proposed in regards to relocation when I am here?
Exactly. You finally caught up to everyone else. What is the point of going through all of this when you are here? You forced everyone to draw this out year after year after year, and once we're finally here, you realize, well, this is dumb. Why are we wasting all this time? Yeah. She also never understood that this is just isolating parts. They're not looking at the entire parenting plan. That would take so much effort to redo all of that. They're just saying we're modifying these little things so that she can't complain, I have all this power and you need to be paying me. But as is, the parenting plan could not remain the same. There had to be some edits, but that does not mean that everything changed. You didn't need to fight this. You could have just mediated, and you both would have just been fine ignoring the parenting plan in general. All the things that would have to fundamentally change when one of the parents is incarcerated for life. And the relocation, if I said that. But it all goes hand in hand. It's just like her criminal case where she thought she had such a complex case. No one knew what they were walking in on, and there's a million fires all over the place, and no one's doing anything, and I have no idea what's going on with my case.
My case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, equals unfair. This does not mean my case can't equal success. All the while, I'm trying to figure out what's going on and why he's not answering any of my questions. Nothing was ever completed or accomplished or communicated, building 1,000 fires, waiting and needing to be put out before making another to be left ablaze. I was always ignored and in the dark.
There's nothing going on. You filmed yourself killing a man. That's it. Relatively very, very simple issues. Same simplicity with this family court case. You are behind bars for the rest of your life. You cannot raise your child anymore, meaning responsibility is currently 100% with the father and must remain so. 2, you do not deserve child support. You have not supported the child whatsoever. You have not had custody of the child whatsoever, meaning you should not determine whether that child can live X or live Y. Nor should you be getting money as though you are taking care of him. And then alimony. You are getting paid. Alimony is to help you transition into self-sufficiency while still maintaining a lifestyle similar to where you were living, so that it's not just we broke up and now I'm out on the street. But that's why there's a limited time on that, because it's a transitional period to financially stabilize yourself. You have been financially stabilized as financially stabilized you can get. All your essentials are taken care of. And if you want more money to add on your books and this and that, then you can actually get a job. You know how many people in prison have jobs? And not just prison jobs. Y'all know everyone likes to break the rules, get phones, do this, do that, side hustles. Get on it. That's what you should have been asking New York help for. How can I get this money through a job, not through harassing someone else?
How much longer is it gonna be? I don't know, I'm not psychic. Can I take your order, please? Yeah, I really don't like the attitude you've been talking to me with.
I'll have a veggie burger and a lemonade with little ice.
Okay, and sorry about the attitude, but I'm really not, but I'll tell you I am. You know how long this is taking? I'm already late for work, okay? It's taking forever. Okay, well, wow, hello to you too. You know I could call you something, but I call it to her through the glass. She's a bitch.
You have no issue hounding strangers to go harass your ex and child. You can use some of that initiative to get your own money working for it, not begging. But yeah, I don't know if your Honorable Miss Jackson has read. Actually, you do. I do know that because they're in the court record. She's read Sarah's letters. She sent over 16 letters to family court alone.
Judge Michael Dean, in all my attempts, 16 plus, to protect myself and help from the still ongoing hate, lies, slander, degradation, cruelty, and active abuse from former husband, Brian C. Boone, nothing has been improved, made better, corrected, relieved in any way for myself, the respondent, from former husband, the court, or judge. I have tried everything. I have made innumerable requests and sent many letters asking for aid from all with no success or assistance, listening, or care by anyone other than myself trying to relieve or altogether stop his inappropriateness, bitterness, anger, and wrongdoing. Please see list below of my letters sent to you and court per the Records Management Division of the Clerks of Courts when for the third time tried getting a copy of my active dissolution of marriage agreement I cannot have because they are wanting payment in order to receive, and I am in jail.
She sent just about that many or more to family court, to criminal court. But yeah, Judge Jackson would have had to read all of those and knows that she likes to count up days. And just like Judge Cranick did in his order taking away her right to free court-appointed counsel, he listed, this has gone on through 16 continuances for over 1,000 days. In one of the most clear-cut criminal cases that has probably ever graced Florida courts. Disgraced. And so he wrote the days in there, and then in her first pro se response letter, she got so mad being like, oh, look at you, mister, I can write letters too.
ZZ. As of February 9th, 2024, the instant case had been continued 16 times. AAA. As of June 26, 2024, this case has been pending 4 years, 3 months, 5 days from the date of the filing of the information on March 23rd, 2020. 7/11/23, 12 months, 365 days, 52 weeks summarized, 8 total months, 240 days and counting. Are with absolutely no communication in any form, completely inactive. Total amount of hours as court-appointed attorney, over 8,760. Total times met with client, me, 6. Total hours spent with client, 7. Total phone numbers given to client from attorney, 2. Numbers that work, 0. Total time speaking to client via phone, 0. Total number of 15-minute video visits with client, 4. Total number of letters sent to attorney trying to communicate, 8. Total number of letters to the judge trying to communicate my unsuccessful communication with my attorney in hopes he will communicate with him to communicate with me, 7. Letters to other parties to communicate, 3. Total times in court, 3. 1 was an attempted withdrawal. 2, carry over and over. The last time I saw my attorney, May 18th, 2023. Where is the progress after 1 entire complete year? Unknown. This case has been pending 4 years, 3 months, 5 days from the date of the filing of the information on March 23rd, 2020.
The post-judgment proceedings, for which petitioner is seeking attorney's fees, unnecessarily spanned 1,231 days from the date of the filing of the modification petition to the final hearing on relatively straightforward issues.
And I am defending myself against your inaccurate, libelous, I can write letters to order.
Because they use the same tactics she used. And that's one thing that I see in life, and it's really funny to me all the time. When people do those type of behaviors, and then when you turn it right back on them and they're like, how dare you insult me? How dare you do that? Oh, okay, so you did mean that to be insulting. You like to backtrack it when people call you out on said behavior, but once that behavior comes back to you, the exact same behavior, you take it as an insult because you meant it as an insult. And I know that's not the true, main reason, but I do not think that went over their heads while writing it. 197 days, so half a year, versus 1,231 days between her actual divorce, and she said dealing with substantive issues of everything you have to deal with the divorce, splitting all the assets, coming up with custody, coming up with this, coming up with that, versus 3.3 years over nothing. At least during the original divorce, she had arguments to make. We've been in this marriage for 13 years, so now we have to take the time to divide these up. And yet that took no time at all. But this took years. D. Merits of the respective positions. Petitioners raised meritorious issues in seeking the termination and/or modification of child support and alimony due to the respondent's incarceration for second-degree murder and lack of exercising time sharing. Likewise, petitioner's basis for his request for relocation, in part due to the media coverage of respondent's murder charges, which led to the minor child being bullied, was also meritorious. On the other hand, respondent's failure to acknowledge a substantial change in circumstances, her objections to the termination of child support, and her objections at least to the downward modification of alimony were without merit. Footnote 7. The court notes that there was some merit to the respondent's objections to petitioner's request for sole parental responsibility, although she confused and continues to confuse petitioner's request for sole parental responsibility with a request for the termination of her parental rights. However, even a meritorious defense on this issue did not justify 1,231 days of litigation. Damn. So basically, she is saying that the respondent had some merit to object to Brian automatically claiming 100% sole parental responsibility, meaning she had room to make some genuine arguments. However, she wanted to conflate even trying to limit any parts of her rights means you were terminating her parental rights, because she uses this big elevated language all the time. But in law, words mean things.
All right, and why do you want the court to consider this case?
Thank you, Your Honor. The court found that incarceration alone is not ground for termination of parental rights, and they still have the right to raise, contact, and participate in their child's life unless proven unfit on other grounds. And one more.
Before you continue, I have not heard any arguments or evidence that anybody's trying to terminate your rights. That's my understanding. That's not what's happening here. Is that correct?
Yeah, this is not a TPR proceeding. Yeah.
Got it. All right.
Hello?
All right. You said you have another case? All right. Actually, hold on. Before you go, Ms. Boone, I don't know if you heard the court. The court wanted clarification from counsel for petitioner. Based on everything that I've read and the testimony that I've heard here today, this is not an action to terminate your parental rights. Counsel confirmed for me that that is not what petitioner is seeking in this case. Okay? Now you can go ahead with your next case.
Yes, please. If I may comment on that. It is in regards to me speaking to my son one day a week for 30 minutes. And that's what I'm trying to
terminate. I understand that, ma'am. What I'm saying to you is the case, and the court does understand, and there is a distinction between terminating parental rights and requesting a specific parental responsibility. So, this case is not about terminating your parental rights. And the court is not considering a request to terminate your parental rights. But you can continue with your next case.
Okay. I'm just trying to clarify what my parental rights are.
So she is saying you are confusing these issues, and you continue to do so. So you can do that all you want. That doesn't mean this changes anything. Your parental rights have not been terminated. Your access to your child and resources has been. Okay, well, it hasn't, but it's been reduced. E, whether the litigation is brought or maintained primarily to harass, or whether a defense is raised mainly to frustrate or stall. After being incarcerated for a number of years, respondent continued maintaining her defenses to the modification of child support and alimony even after convicted of second-degree murder and sentenced to life in prison without the possibility of parole.
Ms. Boone, court sentences you to life in the Department of Corrections with credit time served that Madam Clerk will
Electric chair
to you momentarily.
She finally capitulated to the modification of child support at the final hearing, but continued to contest a financial change in circumstances and argued that she was entitled to $1,000 in alimony. And that's another thing that cut terribly against her. And the only defense she really had was the pre-conference trial meeting that Brian's lawyers was supposed to set up with Sarah and unrepresented parties, yada yada, to go through some things before trial. Nothing would have been resolved there, really, but I do think she probably would have agreed to the relocation and the child support, because those were two things she knew she could not change whatsoever. However, because Sarah's the way she is, she waited years and years to acknowledge that, still contested the relocation, or at least said, how could you approve that and go past me? And this is just another example of everyone ignoring me and no one caring about my side in things. So she was going to wait until the actual trial where she could not prolong it anymore to finally say yes to child support and the relocation. She could have done this at any time. And that's when Brian's lawyer got up there asking Brian, being like, hi, she just admitted that you talked about the relocation and the child support beforehand. She said, we discussed that when Judge Dean was on the bench. Surely did not. And Brian said the exact same thing. No, she didn't.
Now, Ms. Boone indicated in her opening statement that if people would have asked her, she would have been agreeable to some of the relief that we're seeking, basically, in essence, is what she said. I want to ask you, in all the calls that she made to your son, did she ever talk to you about settling this case?
In a way that would benefit her, yes.
Okay. Did she ever tell you that she would just agree to the relocation?
No.
Did she ever tell you that she would, well, I want to ask you this. She mentioned that you two had a conversation about the waiving of the child support. Did that conversation happen?
Not that I remember.
Okay. So there's never a time where she told you don't need to worry about the child support?
No. I don't remember that happening.
All right, they made a statement that there is approximately $4,000 that is sitting in the clerk of courts with regard to child support. They're asking that be returned to Mr. Boone so that he can use it to care for the child. Do you agree with that?
I do, only if he decides to include me, please, on some of the things that I would like to have my son to have also, and things that he had made mention to me that he would like to have in order to become more of an adult and his growth in his teenage years.
In any conversations that you had with Miss Boone, did she ever tell you that specifically that she didn't want you to move to, she objected to the relocation?
Yes.
Okay.
The conversation continued with me asking why he's telling his friend this, as nothing is set in stone and will be discussed when the time comes. My minor son being advantageously taken 4 times the lawful amount, 50 miles, to move away from me, the other parent. As far as I'm aware, which is rare in this case as no one includes me on anything, I still have my rights, custody of my son, and am owed alimony. Nothing has been made permanent or signed to state otherwise legally, or has been discussed again and needs to be. And like we said before, it's the whole everything will be discussed when the time is right. The time has to be right. The trial for her is when the time is finally right. And now we know from these calls she tried to extend that too. If she had gotten a lawyer and magically gotten a continuance, she still would have objected for however long that took to finally go to trial. And every single minute that she prolonged this cut against her in the end. And then she wouldn't acknowledge a financial change in circumstances. Another terrible hit against you. Well, in her mind, there was no financial change in circumstances. As embarrassing as it would be for anyone else to admit, she was solely dependent on Brian's alimony. As we've said in those clips multiple times, his alimony paid for her whole life.
I mean, my alimony and stuff basically pays for where they live. So, I mean, they didn't need a ton, but, I mean, she was always calling to borrow money.
So she never thought she needed to get a job. So the fact that she's in prison didn't change anything for her. She said, I wasn't working on the outside and I lived off of that $1,000 a month. I'm still not working on the inside. I should be living off that $1,000 a month. And those jailhouse lawyers will get you every time. Her friends who told her she needed to write that financial affidavit as though she had the $1,000.
So I'm not sure what's in the spreadsheet, but I think what you want to show is like,
All I'm putting are dollar signs. Like for under household, I can actually put food. and it's $400 a month. I went next door. They encouraged me to go next door, write down a 7-day menu of items that you think that you need to eat in regards to your low blood sugar and a normal meal, because they serve greasy food here, which upsets my stomach, which is what I take Protonics for, an actual medication, and then calculated everything for me. So that's what I'm trying to put with just food. They're going to want to know, why are you spending $400 on just food? And all of these are estimates, because it says that you can estimate anything on there.
Cut against her, she needed to go back. One, she needed to be amenable to anything. If she went up there and said, no, I can't, I understand not giving me the full $1,000, but even though I'm in here, I still need $500, half of that. I'm willing to mediate that. We do half of that a month, so that And he said that he was already giving her around $600 a month anyway. So they probably would have actually agreed to that. And even if they didn't, making that gesture would show a sign of good faith on your end, saying, I'm trying to come halfway here. I'm trying to work things out. Just don't take everything away from me. I still need support, but I understand circumstances have changed and you should not be giving me the full $1,000. Nope. Sarah says, doesn't matter. F, the existence and course of prior or pending litigation. As noted above, the prejudgment litigation lasted 197 days versus 1,236 days of litigation. Further, respondent continued to drag out the post-judgment proceedings even after she was convicted of second-degree murder and sentenced to life in prison without possibility of parole.
So what's your sentence for her?
Court sentences you to life
Electric chair.
in the Department of Corrections with credit time served that Madam Clerk will provide to you momentarily.
47. Upon evaluating the Rosen factors, the court finds that the majority of respondents' defendants in the post-judgment proceedings were frivolous or spurious, which resulted in unnecessary litigation. And that's essentially a kill shot right there of the court finds that most of the respondents' defenses are spurious and frivolous. And using the Rosen factors, this all cuts against you and says you did all this to enforce unnecessary litigation. And I was intrigued, so I actually looked into the Rosen decision just to see what was happening. And oh my goodness, this case is a mess. Which, let me preface real quick that I added these screenshots after the fact. What I'm explaining is kind of me riffing off of my head of what I remember reading. So make sure that you actually, take a moment, read the screenshots so that I can fill in any blanks and correct anything I might get wrong. So first of all, it went all the way to the Supreme Court. So it holds the highest weight of case law in Florida regarding these current issues. And basically, Rosen v. Rosen was this couple that was married for 9 years. They got a divorce in 1979. However, litigation and this decision didn't come out till 1997. So they were in litigation for double the length of their actual marriage. And it just kept going again and again and again. So they kept extending it. And that's when they had to come to these decisions of, if things are brought to just continue litigation, to be spurious, to be frivolous, to just amp up and to frustrate the other party, then we have to be able to cut that. Then we have to be able to counterbalance that. In the courts, it was just a mess. Like originally, she was given $2,000 in alimony. However, she was a stay-at-home mom who had the children with her, and so she needed alimony so that she could take care of her kids. As the years went on, the husband sent other reduction filings and motions, and it was actually reduced from $2,000 to $500 in one case, being like, you can get a job, you don't need all this money. However, she appealed that and it went to the appellate court, and they said they reversed that reduction because the employability status was known at the time of the original $2,000 awardment, meaning you can't look back at employability in order to decrease it from $2,000 to $500. Miss Rosen decided to petition even further for the court to enforce that $2,000 payment, and on top of that, she wanted to increase the child support from $2,000 to $2,750 per month. And that trial court said that there was a significant or a change in circumstances on her behalf, which required her, she, quote, definitely in need of alimony. So because of that, that trial court denied the husband's request for modifications and increased her monthly award. However, the trial court had those set as permanent monthly or periodic alimony payments. The appellate court of that trial hearing said, okay, we reaffirm this increase from $2,000 to $2,750. However, we're changing it from permanent periodic payments to rehabilitative payments, meaning this will run out because in 1995, since this lasted forever, the kids were going to finally be in college. You didn't have the same needs that you had because you were taking care of the children, full-time, stay-at-home mom, the works. Now that they aren't going to be there, your financial situations are about to change. So we're going to uphold this increase, but we're going to reverse this from permanent to rehabilitative. The Supreme Court above that said, while we understand the appellate court made good arguments there, however, because we affirm the wide discretion that trial courts have when determining attorney's fees and alimony based on the circumstances that are presented in front of them, the appellate court erred in reversing or altering that permanent to rehabilitative award because the original trial court had already considered these things or had the ability to consider these things and said that she was definitely in need of alimony. And because of that, the appellate court erred in changing that on its own. What it should have done is what the Supreme Court says. The appellate court should have done is reaffirm the trial court's rulings and denied without prejudice, and then tell Mr. Rosen that he needs to reapply because since the children will be moving out and not be living with her, he does have valid basis. However, at the time that the appellate court saw it, the appellate court can't just change those things because the trial court years earlier made those decisions. Just because circumstances have changed within the time it took to get to the appellate court does not mean you can make decisions as though it was coming to you for the first time. So you have to reject that and say reapply now that circumstances have or will in the near future change. Whew, that was a lot to explain. Hope that makes sense. And go ahead and drop a goat in the comments if that made sense to you. A goat or a crown. Or a goat with a crown. Anyway, I lost myself at some points, but you know, I gave it my best try. So let me know if that made sense, and feel free to politely correct me in the comments if I got something wrong. And also, while you're down there, give me a like. Look, we are 8.5 hours into this video. If you made it 8.5 hours into this video and you couldn't give me a like, what more do you want from me? Do you want me to beg? Okay, fine.
I'm begging you, please! Please! I'm begging you,
Okay, we're almost there. But basically, the end result was saying that you are allowed to take into consideration the circumstances that surround the case. And awarding attorney's fees used to be this split kind of mind of you can only focus on the financial respects of both parties, awarding attorney's fees based off of who can pay and what they can pay, and not based off of other factors outside of that to ensure that everyone has equal access, doesn't have to, can get legal representation, yada, yada, yada. And the concurring opinion was fearful was that that would make a lot more pro se defendants because they just couldn't afford to get the representation that they wanted because people aren't going to sign up to be their lawyer if there's no guaranteed in being paid. And if you aren't court appointed and you have no reasonable chance of getting attorney's fees, why would an attorney work with you for free? Sarah didn't realize the gift of a clown she got in Mr. Owens, but that is not common for lawyers to take on a losing case knowing they will get nothing but harassment out of it. And that's just a long, exaggerated way of saying she did this to herself by stalling. 48. Therefore, petitioner is entitled to reasonable attorney's fees and costs to provide justice and ensure equity between the parties. 49. The court finds that the $175 paralegal rate and $395 attorney rate are reasonable. 50. Petitioner has shown through competent, substantial evidence reasonable attorney's fees in the amount of $11,668 through July 29th, 2025. Footnote 8. See Petitioner's Exhibit Number 2. The court deduced $332.50 due to 1.9 hours of paralegal time that appeared to be clerical in nature. 51. The court finds that 8 hours of paralegal time and 8 hours of attorney time for the preparation for and attendance at the final hearing is reasonable for an additional award of $4,560. 52. Petitioner shall receive a credit of $16,228 from the alimony arrears owed to the respondent, leaving an alimony arrears balance of $3,992.
Damn!
Damn! I'm sorry.
Oh, you could have had 6,000. You could have had 5,000. You could have had a V8.
Wow, I could have had a V8. Wow, I could have had a V8.
Wow, I could have had a V8.
Wow, I could have had a V8.
Wow, I could have had a V8.
Wow, I could have had a V8.
But now you have $3,992. It is therefore ordered and adjudged that A. Petitioner's petition for modification is granted in part.
Bon appetit.
B. Petitioner's petition for relocation is granted.
Bon appetit.
C. Parental responsibility timeshare. The petitioner father shall have sole authority to make major decisions for the child and 100% time sharing with the minor child. D. Visitation. Beginning May 1st, 2026, mother shall be entitled to one telephone call per week with the minor child, as well as an additional call on the child's birthday, Thanksgiving, and Christmas. The holiday calls shall be in addition to the weekly calls, but each call shall be no longer than 30 minutes each unless otherwise agreed upon by the parties. Damn.
Yeah, double homicide.
Bitch.
I'm sorry.
And there it is. Did you hear that, Sarah? Unless both parties agree upon it. Not like the letter we reviewed at the very start of this odyssey into confusion, madness, disarray, and just audacity. She kept putting in there, well, we discussed these phone calls. I can't believe he didn't schedule this 15-minute visit that we discussed. We discussed this. D. Refused a pre-discussed 15-minute remote video visit on Christmas Day for the 6th consecutive year. E. Declined a pre-discussed in-person visit with the respondent, which was the last opportunity for the minor son to see her during his entire two-week holiday break before returning to school. Yeah, you discuss stuff with a mirror all the time. Doesn't mean that people agreed on it. Now it's in the order you must agree to it. Not you just get to ask for it and you get whatever you want. But damn, she gets one phone call a week. That is pretty much as low as you can go, especially for someone who, as we've covered before, was harassing them nonstop. 3 calls, 4 calls, 5, 6, 7, 8, 9, a million phone calls every night, multiple times a week. To son, I tried calling 9 times today, 8 yesterday.
his phone with so I can speak to him after trying 8 times over the weekend. I am floored. You nor he answered the phone after calling 3 times on each. Let me guess. I tried calling 2 more times today. Blank calls. I try calling you every night with no answer. Don't you know by now the evening time is when I am able to call you so you have your phone with you? I call every night. Every night. If you are choosing not to talk to me, I wish you'd just man up.
So then my stupid self called back in 30 minutes and nobody answered. So I called and then I called and I called and I called for like 6 hours afterwards and nobody answered.
And then give them a week or 2 of radio silence before berating them again and again. Now they have consistency. They can have a normal schedule to where the child can adjust to being like, hey, I won't get harassed 14 times in one day by my mom. I have it controlled. On Wednesday nights, I will talk to her, and then that'll be that. Or Saturday, Sunday, whatever. But that will help everyone's anxiety because you will have expectations and you will know what to expect. Because here's the thing, even though it is this one phone call a week, she's still gonna call anyway. She don't give a damn about a single rule or any regulation for anyone. She didn't care about anyone's boundaries but her own. She's gonna call more than once a week. And then they're gonna have to bring it back to court and saying, hi, she's still harassing us. Can you tell her you have to stop now? And that's how you have to be with her. You give her all the opportunity and all the chances in the world, and she will spit on them every single time. And when you finally take away every little opportunity, now she wants to comply. Now she wants to find solutions in this and that. Now you have one phone call a week because you didn't know how to act right. And even in other of the phone calls, that whole Easter saga we started with, in that same original phone call, she talks about because the son was excited about the record and how they had 4 calls in one night and how Brian got upset being like, okay, y'all need to stop talking. And the son was like, okay, call me back. But also, I don't know how much I believe the son said, call me back. As we know, she likes to push answers into her questions. And in other recorded phone calls, it's, can I call you back? When can I call you back? Will you be free in 30 minutes? She'll propose that. And if they say yes, then that's them asking her to call back. No. And this also means that she will have to plan out her phone call strategically of, I only have 30 minutes, so maybe for this 30 minutes, I'm not going to guilt my child for 27 minutes and then tell him, do you love me, yes or no, then pick up the phone and then hang up. Because now when you pull those tactics, those stunts, those berating abuses, you're done for the week. They don't owe you anything else besides that. And on the whole holidays, Miss Ma'am has been talking about every holiday as though she's entitled. I mean, she even asked in the resolutions, I want to be included on every holiday. 5. Include respondent in all holidays, including schooling and any other time minor child wants to include the respondent. School activity, school holiday break, or whatever. Again, she doesn't come with any reasonable offers. It is all or nothing. I want everything I can have to be in every aspect of my child's life. Order petitioner to facilitate 1. Telephone calls daily with funds added without interruption. 2. Tablet messages with credits to fully utilize features. 3. Virtual visits, TBD. 6. Compel petitioner to include respondent in all major decision-making regarding the minor child. 7. Enforce communication, regular correspondence of petitioner with respondent in all available options, including phone calls, tablet messages, letters, third-party representatives, any manner necessary she requests or uses at the time of her needed communication. 8. Enforce petitioner to keep respondent updated regarding minor child's proposed vacations, appointments, meetings, all happenings in his life so she is aware and included. Every time I hear that, it still just makes me cringe. Like, parents do not need to be in every aspect of their child's life and still think they'll have that close relationship as they get older. Even if she said, I want to be included on all major or national holidays, that would have been more, I don't know, at least something. But she's saying every holiday, undescript. We've seen her rage over Valentine's Day, over Mother's Day, over Easter, over New Year's. You told me when on the phone lying about everything when I was trying to check status of anything since returning from your vacation, that I was not permitted to see my son during any of the holidays, including Thanksgiving, Christmas, and New Year's, stating, quote, "It's my Christmas and holidays this year, Sarah." I'm still dumbfounded you are enforcing the parenting plan while I'm incarcerated. You've had him for all the holidays ever since I've been here. That was you being cruel and controlling and you throwing your weight around. There's a lot. And depriving me time with my son like you do with everything. Why? Beyond ridiculous. Why don't you enforce or abide by the alimony section of the agreement? To Brian, Sarah. Hot meals times 2. Why didn't you order, Brian? They just came without calling my name. And because you will not give me confirmation numbers to ask the rep, I again have nothing for New Year's nor for Christmas. Even after asking over and over and over and over, starting December 6th, today's the 27th, and you couldn't find 5 minutes to order? But keep telling me you would and were going to? Are your holidays complete and even merrier knowing you did nothing so I could have nothing again? Why are you continuously lying to me about everything? Lying about everything. It's just a hot meal that you permit me to have only about 2 times a year, not even for Christmas, but kept telling me you would and were going to. How many more times did you want me to ask? Not even a hot meal for Christmas. Thank you, Brian. Phone call confirmation, Easter. When being made to call you from no response to any of my now 105 messages, you are actively deciding to not answer and keep lying you will. You stated you did not schedule an Easter video visit for the 2nd year because you had, quote, other priorities and plans which I am not a part of. Arrogant, narcissistic, self-righteous father, husband, you reap what you sow. Undeniably, remember, see you soon. Enjoy the Easter holiday with our son. I'll be thinking about him and missing. I wish you would include me and let me see him. Life is beautiful no matter where you are, Brian. Tell son why I don't get to see him today so he knows. Do better, quote, Dad. He sees and knows what you are actively deciding to do with, to, and for his mother. Remember that. You're supposed to be better from his selfless act. Happy Easter. Wish I was included. Hope you like your package I made for you. I love you no matter how uncaring and nonchalant you are towards me. I wish you wouldn't be. Mother. None over her birthday. The fact that she gets mad at Brian for not getting her things on her birthday as though they are together. He don't like you. And honestly, I don't know if that's like a normal thing for divorced couples and situations. Even when you're co-parenting and you're trying to keep your child in each other's lives, I don't think there's this expectation that you're getting your ex a birthday gift. Maybe a birthday phone call, trying to make sure that the child sees you on your birthday. That makes sense. But she's like, you didn't even order me a hot meal on my birthday? Not even for Christmas? Not even for New Year's? No, sure didn't. And now this court order says you only get the child's birthday, his birthday, which I'm sure floored her, being like, well, what about my birthday? It's never about you. You are not entitled to being celebrated on your birthday. However, since you are that child's mother and you still have your parental rights, you are entitled to see him on his birthday or talk to him. And then Christmas makes sense. Thanksgiving also makes sense. Little random, but I just think that is so funny. The fact that she asked for every holiday and she got the barest of minimum. Your Honorable Judge Jackson has made it clear She does not like Sarah Catherine Boone Paulsen.
Excuse me.
Miss Jackson.
Where is he? Where is my son? Where the fuck is he? You're eating my peach. Help me!
And has given her literally the least amount of everything. The lowest amount of money that he can pay, giving him the highest amount of attorney's fees, credits that she can come up with, giving her the lowest amount of phone time that she asked and begged for.
When you originally signed up for this account in order to utilize the phone option, were you aware of the 13 cents per minute?
Yes, I have to pay for all the phone calls.
So you accepted the fact that it was 13 cents per minute.
You don't have a choice. That's the only way to have phone calls in the jail.
Yes or no. For most of my questions, it's just a simple yes or no.
I mean, what's the point of this questioning?
Because he's making it seem that it's a very expensive phone call for me to speak to my son, and it's just 13 cents a minute, and we don't utilize the full 30 minutes each time. So by him setting up this phone account for the 13 cents per minute and free phone calls.
The court has taken notes that it costs 13 cents a minute based on exhibit number 1. Your next question.
Okay.
It's only 13 cents a minute, and we don't always use the 13 cents a minute. But now you admitted that sometimes you use over that. 4 phone calls, that $5 a call is $20 for you to harass your child in one night. And Brian has to pay for all of it.
Like, he's really into it, and I don't think he tells Brian any of this, which is why he gets so overly excited about telling me these things on the phone. So, like yesterday, Brian got so mad, Peter, that we had almost 4 phone calls, and Brian is like yelling at to get off the phone because we kept talking to each other.
Why does Brian care?
Because he has to pay for it.
Oh.
I mean, ask me if I care, and clearly doesn't either. So he's like, Mom, just call me back. So I did. So just
ask me if I care. Now guess what? Brian gets to pick up the phone and you get to say, I haven't talked to my son in days, and he can go, ask me if I care. And we would be remiss not to revisit this whole saga when she blew up in that letter over the Mother's Day card and Valentine's Day card, because Brian said that the son had made handmade Mother's Day and Valentine's Day cards and sent them to her. However, most prisons and jails do not accept hand created cards because you can sneak anything in there. What is it? There's been people who have snuck drugs in glue that has been used on the cards just to make it look crafty. So people try to sneak in things in all different types of ways. So yes, having a haphazard homemade card from your child, odds are, is not going to get through. Did she accept that explanation? Of course not. It's, they lied to me. Jumping Java, food packages. Previously, you were going to order, and I would like also, especially blank, received, Valentine's Day most recent, and my son wants to send me blank. Thanks for the Valentine's Day blank. Have decided to make them for me after telling me you'd think about it, blank year, with you lying to me with your adult father. Exactly. Adult father. As in, you are talking to a child right now with the specific purpose to hurt me. And even if that were true, it's only true because you keep hounding them. Like, how embarrassing is it to say, are you sending me a Valentine's Day? Are you sending me a Mother's Day card? And then talk about it for over a year. Being so upset the fact that you didn't get these cards that you keep harassing him for the next year to try to guilt him into making sure that he sends you one the following year. And then he doesn't do that, and you are shocked, befuddled yet again. But anyway, I always thought it was so funny to go through this part, and I still love that the user only fan created this metal rock version of me reading that section. I don't know how that came up in their mind, but I thank you, and I'm glad it exists. So we're bringing that back.
9. Have former husband, Brian C. Boone, explain why he lies about sending anything for my son. A. February 14th, 2023, Valentine's Day card. Former husband collaborated with my 12-year-old son to lie to me about making me a card. Both said they went to craft store and bought supplies. My gift to son. Had son sit down Sunday afternoon, quote, and make, then mailed the completed card the next day. I was told my son wrote me a letter and drew something nice for me. I was really going to like it. It was all a lie. They never went or did any of it. What an awful, unnecessary lie for no reason. Nonetheless, former husband had my son part of the awful lie. How disgusting and hurtful. No card ever. B. May 14th, 2023. Mother's Day card. Former husband has told me 3 times now my son has mailed my created card. Nothing has come. Another despicable lie. Why? So hurtful, and son included.
Two, beginning May 1st, 2026, or within 30 days of the minor child being approved as a visitor, whichever occurs first, mother shall be entitled to one weekend visit per month with for 2 hours per visit at the Lowell Correctional Institution main unit in Ocala, Florida. Congratulations, Sarah. This is one of your biggest wins yet. You have been begging and pleading for him to submit that visiting application, which, to be fair, for 9 months, almost a year, he didn't do. And he said he'll do it when he feels like it, this or that. And then him finally resubmitting an application the Friday before the Monday when trial happened. I live for that kind of shade, so I love it, but he was doing a lot to dodge it.
The first of which is a respondent's motion for contempt and to compel petitioner to submit visitation application immediately that was filed with the court on August 20th of 2025. If I recall correctly, one of the last times we were here, the petitioner indicated that he had filed something with the Department of Corrections regarding the visitation. They were slow to react, and he was going to follow up. Did the court remember that correctly?
More or less. I had sent them something.
Hold up, Ms. Boone.
I never heard anything back from them about it. So I guess they never got that one. I have since submitted it.
All right. When did you submit something?
The end of last week.
You have a date you can give?
I think it was Friday.
Friday, which would have been the 22nd, I believe.
Correct.
All right, Ms. Boone, Mr. Boone has indicated that he attempted to follow up after one of our last hearings regarding the status of the application for visitation. He never heard anything, so he submitted another one on Friday, August 22nd.
And that's when she made up the 2-week deadline that you verbally gave them on the thing or whatever.
Your Honor, am I allowed to expound on that?
Yes, you are.
Well, I know for a fact that I'm actually in the classifications department now, and as of this date, no visitation applications have been received on his end for himself or for my son, and no attempts also have been made in order for him to try to do so in the meantime. I know that our pre-trial conference was on May 29th, and you gave them a 2-week deadline to submit, and I believe also that his attorney even volunteered to submit them himself due to the prolongation of time for the now ongoing 9 months that I've been trying to get him to submit for no reason of him withholding submitting the visitation application. So that's why I put in my cross notice and again my motion for contempt at this point, because they have disregarded your verbal order or instructions to submit them within the 2 weeks as of May 29th.
But now you officially have a timeline that is written in the order. Within 20 days of yada yada yada, you shall be signed up as a visitor to visit this woman. That is saying, shall, you cannot avoid, you must do it, or else we will have some problems. Because she's like, I'm tired of hearing this shit. Put in the application so you can do this once a month visit, which is very, very kind. So I think that's great. I think that's more than enough. Like literally going to prison 12 times a year is enough to rattle any child. If it were up to Sarah, she'd have him coming 24, 36, 52 times a year and see not a single developmental issue with that. I can bet a lot that if the son really wanted to see her that bad, that he would have put in the application sooner. But that's just my conjecture. I don't know either way. But yes, on every phone call, he still hasn't submitted the application, and it's killing me. Everything, all I do is think about him now, and I just want to see him and this and that.
Listen, I have to tell you this on top of everything else. Like, my pretrial is May 28th, 60 days from when I originally did all of this. So I have to wait 60 more days. Still hasn't put in the application, and it's killing me. Like, it's killing me.
You guys are killing me right now. I don't know how you want me to say it.
That he won't put the application in.
But he doesn't, does he have to or no? Because you put the contempt in and then they put a continuance in.
What are you talking about? I'm talking about my son's visitation application to come see me.
Right, but I know that he's stopped following his modification.
Say anywhere, though, that I'm not allowed to see him. And phone calls and everything, there's nothing like that in there. It's just stupid alimony and just, like...
I thought that, didn't he say that he wants full custody and to end all your custody rights? Which would then change all the visitation?
That doesn't change visitation. It's his choice. Nothing's been set in stone, and he won't let me see my son, and I swear to God, like, he better hope he doesn't ever see me in person. He better hope he doesn't ever see me in person, because this is really killing me, and I just want to see him, and he wants to see me really bad, and just, I'm really going crazy. Like, I really am going crazy. Really going crazy. I'm still trying to wait to see if Brian actually submitted his, and because he had until June 12th, and today's the 22nd, and I've not received any confirmation that they've been approved.
Save your money on the lawyers, and this is what I'm willing to settle for. But if you don't want to do it, that's
okay.
Just
hold on 1 second. I know, and I'm being respectful of what you're telling me. I understand. It's constructive criticism, and my ears are open. But my thing is, though, you weren't on the call with me for the hearing, but, they make it seem like is standing there, with his, gnawing on the tips of his fingertips with tears in his eyes streaming down his face, settled, worried out of his mind and, just a blob of, insecurity and sadness. What does know about any of this? Is not in any of this. That's why I don't understand why people keep bringing up. He's got nothing to do with it. He just does what Dad tells him to do and then calls it done. Brett just asks if he can come see Mom. Why haven't you filled out my application? And his response always is, I'll get to it when I get to it. So if anybody's doing anything to him, it's and I have to tell you too, like, everything reminds me of like, everything reminds me of and it's like the devil, man. It's just like everything reminds me of so it's just, you know what it is? It's like, and he keeps telling me he's going to. He keeps telling me he did. He doesn't respond to me on the tablet for 5 years, and just they both keep lying to me and just called me names on the phone the other day, and I think he's just really angry at me. And then we ended up having a really good conversation, and I want you to know too, like I say, and tearfully pled to fill out the application for, and he said that he did it on February 7th. He should have been approved already, and they're not even on my list. The only people showing up, believe it or not, listen, is all the way in effing Australia, you and the two people that took care of my 2 dead dogs. So it's just like, where is everybody?
It just, the amount of pressure that puts on a child, you are basically saying, once I see my child, I'm putting all the weight on my child to fix my life. I will be completely better once I see my kid. And that is not a crazy feeling to have, not at all. But when you're forcing that and you feel entitled and demand that, that's when that pressure becomes abusive. And that's not expressing love, that's demanding care from a child who's just trying to make it through an impossible situation you put them in. But still, congrats to her. She got the monthly visit with the full time allowed, the full 2 hours, because I think it's like half an hour to 2 hours is the max. So she got all the time she can get. She only got one visit because she wouldn't answer. She kept saying, I want 1 to 2 monthly visits.
Thank you, Your Honor. My request that I put in my pretrial statement were to have daily telephone calls if I would like to have them. If I would like to have them with my son, which he would like to have as well. The in-person visits, I put 1 to 2 per month with the maximum allowable time afforded by the correctional facility, please.
You're saying 2 in-person, hold up, stop. I just want to make sure I understand. You're requesting 2 in-person visits for the maximum time allowed?
1 to 2.
Okay.
What does that mean? Just say, I want 2. If you say 1 to 2, they could give you 1 visit for the rest of your life or until he's an adult, and that would still be following your guidelines of 1 to 2, when in reality, you wanted 2. But then also, you probably didn't want to because you are very flaky and sometimes you want to overwhelm. I mean, this has been your parenting theme motif throughout his entire life of when you give him the attention, you demand the attention. When you don't want the attention, you give him nothing. And that's why it's in the best interest of everyone to have a very consistent schedule, not a whole week, 2 weeks, month of love bombing, then going silent, then blaming you for being silent during her silence. Too much. I love you, 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 I love you. No one listens to me. I have made the active decision to not call for an undetermined length of time so I can take a break from the beratement. I can only take the terrors inflicted by former husband in doses. Right now, I've gotten my fill from both of them. If my son wants to speak to me, he can write or schedule a visit, which I doubt will happen from the lack of encouragement and inclusion of me to have a relationship with our son by former husband.
When was the last time he was upset?
Probably about a week ago, because you didn't call all last week.
Do you know my schedule of work while I'm located at DOC?
No, of course I don't.
What?
You understand the majority of him being, in quotes, upset is because you withhold him coming to see me, and he's had to wait over 9 months now that he has the opportunity to, and you continuously lie to him and me about, and the court, filling out the application.
Okay. Not at all what he tells me. You specifically, the way you talk to him is what upsets him.
And the real reason she's upset is because we found out that no one has come to see her. All these phone calls where we hear her complaining or asking New York.
Pretty much I will let
Sarah
know that she is a fat
and a bitch and not a mother.
And I think
Sarah
is just a disgrace. She's a disgrace to humanity, and she's a disgrace to women who are actually beautiful and classy, and she just doesn't have the vernacular that she thinks she possesses.
When are you going to come see me? When are y'all coming down? When have you put this? Your approved visitor, that, da 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 da. And the whole time, no one has gone to see her.
Come see me next month,
Mm-hmm.
please. It's crazy how, like, nobody's actually come to see me yet. It's just crazy. And I'm still trying to wait to see if Brian actually submitted his, and because he had until June 12th, and today's the 22nd, and I've not received any confirmation that they've been approved. And just like, me and talked yesterday, and he's like, Mom, I want to come see you at least once a month, and just, when are you guys going to come see me?
I'm really gunning for the first week in August. Would that be okay with you?
Listen, I'm with you guys. I go to this trial supposedly on August 25th. So whatever it is, however it is you guys need to do it, then that's fine. Just,
Okay.
I'm not breathing down your neck. It's just
No, you need to see a friendly face. Keep staying true to yourself. Don't fall into those traps.
I'm not. So just
Good.
know that I'm always going to be a blinding beacon. So everybody will definitely know that it's me when you see the bright light. So just know that. And
Didn't want to tell you guys. The reason why I'm so stressful about this 60 days, y'all need to do your applications for this visitation is because I have $11.25 in my account, and I'm so hungry. I had to hold onto the railing the other day because my blood sugar got so low that I couldn't walk up the hill to go back to work. You guys can't do anything until you're an approved visitor.
Okay, so we got to be approved so I know he's been calling every day and working on that. So once we get approved.
Look, and if you're asking me, look, I'm going to be honest with you. Like, I have the capability to download music and watch real movies, and I haven't done that yet. And I really want to.
Okay.
I don't understand why nobody's being approved. And I know Julian said that his was because he's probably been incarcerated before, but he's not even showing up on my list. I don't understand. Like, if you can call me and say, listen, I filled it out on this date. Why am I not approved yet? And then is very spastic about it also because she keeps sending me these screenshots that says that she is approved, but she can't even send me $25. So, like, I don't understand what they're doing, or if they just don't give two shits, or if it's because, like, one of my friends said that it's because I'm an, in quotes, high-profile case. I said, no, that has nothing to do with that. I'm just another inmate like everybody else. And I think that I'm pissing this off because I send her an inmate request form every single week for updates of who is on my list and who is actually approved. Should have been here and should have already been scheduled to come see me. It's just wild. And then Julian told me that you and he are planning to come see me. I think my life will change. Our life will change together with the three of us going forward futuristically and everything if we were to see each other in person and hug each other.
Yeah.
No, I need that for a fact.
Yeah.
Oh, okay. So really quick before I forget. Please, if anything, may I have one hot meal? May I have a hot meal in between of all the visitations?
Yes, but we got to get on that list first to be able to do that.
I'm just glad my prayers have been answered and I can permanently distance myself from you, your trouble and danger. If you play with dogs, you're going to catch fleas. Focus on God, not your failures. I am proud of myself to say I lived through George Torres, his family, the justice system, so much more, and now Peter, Julian, Delpine Creatives. Again, I am my own best advocate and will never conform, staying true to who I am. I really hope everything works out for you all. I'm better without Delphine Creative, or whoever you are. God's got me and my son. Cheer up, smiley face. I hope your day gets better. Sarah Boone.
Like, it's just crazy to me that nobody's come to see me yet. So I just want you guys to know that I'm very much looking forward to it.
And I think that was the biggest communicator that she should have taken, that New York and Julian were not her real friends.
Somebody lied to her several times and told her that she was fly, hot, and sexy and beautiful, and she's nothing like that. She's nothing of the sort.
If they really, really were about that life, they would have come and seen you. But they're like, we'll help you out from a distance and we'll come see you when I can come see you. But yeah, it made me laugh a little bit to find out not a single person has gone to visit her, and she doesn't realize that's because of the way she treats people. I mean, we've seen even Shonda Vander Ark, who I will 10 toes down say is absolutely a worse and more evil individual than Sarah Catherine Boone Paulsen.
Cupcake. I don't want a peach. Cupcake.
And a worse mother. Congratulations, Sarah. There are a few people in this world who are worse than you. Shonda Vander Ark is one of them. And even she has some friends come and visit her. Even after knowing how putrid, horrible, nasty, sadistic, and cruel she is, she still has a few people out there who keep in touch. And you can't get nobody to come visit you? Damn.
Yeah, double homicide.
Bitch.
No, I'm sorry.
3. The transportation cost for weekend visits shall be allocated to father. 4. All other provisions of the parenting plan approved by the final judgment, not expressly modified herein, shall remain in full effect. E. Alimony modification. 1. Effective March 1st, 2020, petitioner's alimony obligation is hereby modified downward to $145. 2. All other provisions of the marital settlement agreement approved by the final judgment, not expressly modified herein, shall remain in full effect, including the length of the award of the durational alimony. As a result, petitioner's durational alimony terminated on April 2nd, 2025. 3. Petitioner shall receive a credit of $16,228 for his award of attorney's fees in accordance with paragraph F below. As such, the alimony arrears amount is reset to $3,992. 4. The $3,992 balance of the alimony arrears shall be paid in seven installments deposited into Respondent's inmate trust account. 5. Within 20 days of entry of this final judgment, petitioner shall apply to be an individual who, pursuant to Rule 30 of the Florida Administrative Code, is identified on the respondent's automated visiting record. 6. Petitioner shall make the following deposits to respondent's inmate trust. A. Within 90 days of petitioner being identified on Sarah K. Boone's automated visiting record with a current, quote, approved status pursuant to Rule petitioner shall make payment number 1 in the amount of $600. B. On or before December 1st, 2026, petitioner shall make payment number 2 in the amount of $392. C. On or before March 1st, 2027, petitioner shall make payment number 3 in the amount of $600. D. On or before June 1st, 2027, petitioner shall make payment number 4 in the amount of $600. E. On or before September 1st, 2027, petitioner shall make payment number 5 in the amount of $600. F. On or before December 1st, 2027, petitioner shall make payment number 6 of the amount of $600. 7. All alimony payments deposited shall be made by cashier's check, money order, or certified bank draft made payable to correct pay and mailed with a deposit slip by the due date above to FDC Inmate Deposits P.O. G. Child support termination. I. Father's child support obligation shall be terminated.
Bon appetit!
Retroactively to February 25th, 2020. 2. Father is entitled to the return of any funds being held by the clerk of courts for overpayment of child support. 3. The new child support arrears are $0 effective April 7th, 2026. 4. The clerk is directed to return any and all funds being held for child support to petitioner Brian C. Boone. F. Attorney's fees. Petitioner is awarded $16,228 in attorney's fees and costs and shall receive a credit of this amount from the unpaid alimony arrears. G. Relocation. Petitioner is permitted to permanently relocate. H. all other provisions of the final judgment, marital settlement agreement, and parenting plan not expressly modified herein shall remain in full effect. I. The court reserves jurisdiction to modify this supplemental final judgment. Done and ordered at Orange County, Florida, this 7th day of April, 2026. Your Honorable LaShonda K. Jackson. Whew. She ate with that one. Alrighty, wow. After 9 hours, we finally made it through the entire 17-page final order. But we're not done yet.
Who said that? Who said that? Who said that?
Because while working on this, and you know, it's taking me forever to get through this, as it always does. And Sarah, no rest for the wicked. She is always cranking out letter after letter, dropped another letter after the final judgment called a motion for clarification. So let's go ahead and go through that. And then we will finally wrap up. Linda, I know we are almost there. We can do this. Motion for judicial clarification and/or rehearing regarding alimony arrears stated in the supplemental final judgment. Comes now, pro se respondent, Sarah K. Boone, pursuant to Florida Rule of Civil Procedure, and respectfully moves this honorable court for judicial clarification and/or rehearing regarding alimony arrears stated in the supplemental final judgment. In support of this motion, the respondent states, 1. On April 7, 2026, this court entered its supplemental final judgment in this matter after the trial was held on August 25, 2025. 2. In the supplemental final judgment, the court states alimony was not paid by the petitioner to the respondent during the time period of February 2020, date of respondent's incarceration, to April 2022, date of petitioner's modification filing. 3. Both parties acknowledged in their closing arguments submitted to the court there are 26 months of unpaid alimony by the petitioner. 4. Missed monthly alimony payments were granted by this court to be enforced in the amount of $1,000, page 11, paragraph 44. 5. Based on the aforementioned data, the arrearage amounts should equal $26,000, 1,000 times 26 months. 6. In the supplemental final judgment, the monthly total reflects only 15 months of arrears are owed, equaling $15,000. Page 10, paragraph 41. 7. This creates a clear inconsistency within the judgment, as the number of months found by the court does not align with the arrearage amount awarded. 8. The discrepancies throughout appear to be the result of mathematical or inadvertent errors, which materially affect the proper outcome of this case, and result overall in prejudice to the respondent. 9. Judicial clarification and/or correction of alimony arrears stated in the supplemental final judgment is necessary to ensure lawful accuracy and final resolution in this manner. Wherefore, pro se respondent Sarah K. Boone respectfully requests this honorable court to A. Grant a rehearing regarding the necessary clarification of alimony arrears to be awarded to the respondent by the petitioner as stated in the supplemental final judgment. B. In the event the court determines the correct arrearage amount to be awarded is in fact $26,000, amend any and all appropriate sections of the supplemental final judgment necessary to accurately reflect the corrected time and dollar amount, including the adjusted total amount to be awarded and paid to the respondent by the petitioner, or alternately. C. Clarify the basis for the proposed $15,000 for 15 months as stated. D. Grant such further relief as this honorable court deems just and proper. Respectfully submitted this 16th day of April, 2026. Sarah Boone, Sarah Boone. All right, I hate to say it, but She's not wrong. Kinda. And we'll jump into what I think about the month disparity in a second. But do you notice what's missing from this whole thing? This case has been going on for years and years and years, and she's pulled out every excuse in the book and manipulated someone specifically more than anyone else in this world to try to get what she wants. Yet that individual is nowhere to be found. And who is that? We'll say it on three. 3, 2, 1. Her son. Where is her son? That whole 17-page final judgment went through all of this, and all of this, that. She complained, everything I'm doing is for my son, my son, my son, my son. She just had her parenting time officially limited to 1 phone call a week, a few phone calls on holidays, and 1 monthly visit. She didn't say shit, nothing about any of that. She wants to say, I want to be in my son's life for this. I want that. I need to be in my son's life. That is the only reason I'm fighting this much. And what does she talk about when she responds to the judge? Only about the money. This is the true Sarah. A few things. Let's finish up this point first, and then we'll go back. But out of everything in that judgment, she focused on the one thing that was noticeably incorrect, that meant the most to her, and that was the money. You owe me money. I don't care about my pawn son anymore. I lost that. He didn't give me what I wanted. I used him to get as much as I can, and you are now messing with my money. Correct the numbers so I can get paid. Oh, and my child, okay, I'll deal with that later. It's just wild to me how she used him as a shield and a crux in all of this, says she wants him to be involved in this and that. What would our son say? How would he feel knowing the truth? I am also fully dedicated and devoted to my son and his rights. His uninfluenced feedback should be included, and it is only fair to him to know the extent of the situation and the cruel attempts of his father to his mother. And doesn't bring him up once? Not that it would matter, not that she has any actual arguments to support, but you think there would be some consistency there. But moreover, and is connected to this motion is written well. For once, it took us 5-6 years to get to a proper, well-written motion that isn't condescending, that doesn't have these two-handed insults all embedded in it, that actually follow the proper protocols. We're in the margins, we're properly formatted, we're citing proper Florida rules and civil procedures. All of her points are nice and concise and clear. What does this tell you? She could have done this from the beginning. All of these motions, all of this, and this, that has been a choice. Because if she wanted to, if she actually wanted to be taken seriously, she would have written one like this from the start. But only after she's officially gotten everything taken away from her, in prison for life.
Ms. Boone, court sentences you to life in the Department of Corrections.
Girl, prison, honey.
No friends, no resources, no money, no marriage, no son time. But you know what she is going to get? She's going to get that money, because that's the only thing she has ever truly cared about. I'll be fair and definitely give her props on the quality of this motion in comparison to her other motions. But this one, even though it is as proper as possible, reveals more than any of these other motions, all about this superfluous, flowery language. I just want to be included in my son's life. He should know what his father is trying to do. I'm trying to be my son's best advocate for myself.
When I'm trying to speak to him solely in regards to my son, I'm doing everything that I possibly can for my son. One fear enforcement incident does not define me as a person or my entire existence. And I'm trying to be my son's best advocate for myself.
Unless there's another motion that she filed soon after this regarding her son, which she may have. I won't put that past her yet. But if this is the only thing she responded to, she 100% confirmed that this is the only thing that was important to her. Why? Because she even says it, that this needs to be altered and corrected for the proper outcome of this case. Sorry, that's wrong. She said to ensure lawful accuracy and final resolution of this case. which is essentially the same thing, meaning you correct this and I'll say it's done. She didn't say, if you correct my time sharing, if you correct the amount of phone calls I'm allowed to have, if you correct 100% parental responsibility, which that just reminded me of that. She didn't talk about the parental responsibility whatsoever. She lost 100% parental responsibility, and she says nothing about it. Meaning to her, if you correct the money and give her the $26,000, then this case will have concluded properly. Her son be damned. Yeah, that's wild. Okay, so now let's tackle why I think there is that month disparity. Because Sarah is technically right. It should be around $26,000 and not $15,000. However, it was stipulated in trial that it was $15,000. Judge Jackson asked Brian point blank directly, is it 15 months of unpaid alimony for $15,000? Is that what we're agreeing upon? And then Mr. Martell answered, well, he's going to testify that he made some payments of $600 here and there. And then the judge cuts him off saying, okay.
Am I understanding that petitioner concedes there is 15 months of alimony that should have been paid? And so there is a amount that's owed, I believe it's $1,000 per month, so that would be $15,000?
Well, we're going to be arguing that he did make other payments if Mr. Boone's going to testify that he made payments to an average of $600 a month during that period of time. So
we're agreeing that he did not make $15,000 worth of direct alimony payments that were ordered pursuant to the final judgment.
That is correct.
But we are agreeing he did not pay 15 months of unpaid alimony arrears. $15,000. They said yes. You hear that silence? That was Sarah Catherine Boone Paulsen's response. She said nothing about it. That is when she needed to say, I object. Actually, it's $26,000. And then they would have gone back and forth and said, oh, wow, okay, well, let's look into this a little more. She said nothing, so she gets nothing. If she were a lawyer, she would know that you are supposed to object to any established fact if you do not agree with it. Whether the judge sides in your favor, you object to retain that issue on appeal so that you get to bring it up after the fact saying, actually, I objected at trial, you ignored me, the math is wrong, correct the math. But Judge Jackson stated a number. Maybe that was a number that they wrote down previously because it was just a cleaner number. Because sometimes you just have to have stuff to prove this, and it's probably easier to prove 15 months than the other months when Brian is saying, well, I did pay her some things and I did do this, and it could just be messy. And in the final judgment, she said that although his donations or whatever does not absolve him of his alimony arrearages, this does come into play, and they agreed on $15,000. No objection means that is the facts of the evidence. And Sarah did bring this up in closing arguments. She didn't make it that strong, but she brought up that she wanted $28 whatever $1,000 in the end, because originally she's been asking for $67,000, but then after trial and she realized, oh wow, I really have no claim to any of this, so let me just say I'll take the $20,000+, please. For all foregoing reasons, the respondent, Sarah K. Boone, respectfully requests this court find the petitioner in civil contempt for violating the court-ordered payments he was ordered to pay while he was employed, and order the petition to pay $26,000 in alimony and $2,314 in interest payable under Florida law. B. Deny the petitioner's request that he, quote, calls even, that imputes an income to the respondent for child support. C. Deny the petitioner's proposed parenting plan and grant the respondent's in place of. Respectfully submitted on this 2nd day of September 2025, and in all gratitude of this honorable court's patience, Sarah K. Boone, pro se respondent. Okay. But we have a key difference here. Order the petitioner to pay $26,000 in alimony, and $2,314 in interest payable under Florida law. Well, that's not what you said in your pretrial statement. In your pretrial statement, you were trying to go for the whole $62,000. You were trying to drop that number, flip it, and reverse it.
Let me work it. I put my thing down, flip it and reverse it.
Not $26,000. You asked for $62,000 plus interest, which I think brought it up to $67,000. In addition, respondent respectfully requests 5. Sanction petitioner and his counsel for their willful violations of the court's orders of alimony payments to the respondent with active agreements and undermining its authority of consequences for their ongoing noncompliance. 6. Enforce original alimony obligation regardless of respondent's current circumstances.
Court sentences you to life in the Department of Corrections.
And order petitioner to pay $2,000 as estimated and calculated minus appropriate costs deemed just and ordered by the court. 62 months times 1,000 ordered payments per month equal A, including while located at OCCD without sentence. B, with open active court-ordered agreement. C, no judgment made to any modifications proposed by petitioner. D, no permission granted to petitioner to reduce, terminate payments. E, no stipulations in any agreements regarding incarceration. 5 years plus duration while located at OCCD to present equals petitioner is basing on completion of his 84 ordered payments per agreements April, which is to date and obviously incomplete. 7. Hold petitioner accountable for interest occurred on arrears as a matter of equity, law, and appropriate authority calculated as follows per Florida law. Quote, Florida law imposes interest on unpaid child support and alimony at a statutory rate. As of July 1st, 2025, the interest rate for unpaid support is set at 8.9% per year and may vary annually. Interest begins accruing on the overdue balance as soon as a payment is missed and means the longer arrears go unpaid, the higher the balance grows due to compounding interest. In many cases, interest can become a significant part of the arrears balance, so it's important to address unpaid support as soon as possible. 9.8% interest, Florida law, times 62 months incarceration equals $5,518.
Come on, math.
$5,518 interest plus $62,000 arrears, total owed by petitioner pre-deductions from the court of $67,518.
Come on, math.
9. Respondent is requesting $300 to be deposited by the petitioner in her DOC inmate account on the first day of every month until debt is satisfied, and other arrangements have been made at her request pending her appeal. Which it will never not blow my mind that she asked for $300 a month, which is the max that she can get under her closed management status in prison, until the balance is paid, until the balance of $67,000 is paid. We did quick math in like a prior video. That's over 18 years.
Yeah. Double homicide, 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 double homicide. Bitch. No, I'm sorry.
She tried to lock him in. She wanted to lock him in for the length of another child.
18 years, she got one of your kids, got you for 18 years.
For 18 years, he would have had to deposit $300 into her account every single month because she cannot accept more than that if she were to get that awarded in the first place. Just wild. And that's such an abuser tactic, never letting your victims go. However, she put that in closing arguments not during the trial. There's kind of like an order of operations where testimony during the live trial is considered the highest of evidence. Then you have the evidence that they submit. I'd like to submit these court records into evidence. I'd like to submit this financial affidavit into evidence. And then closing arguments. Because closing arguments are, in essence, how you interpret the evidence. This is my position. After all the things that we have presented, both sides have presented, this is my interpretation and why you should side with me. You can't just bring up new facts in a closing argument and have that be argued as equally as the established evidence at trial. Now, did Sarah Catherine Boone Paulsen know that? Probably not. Yes, Linda, you are right like always. She definitely didn't know. But she also didn't ask, so sorry about it. But this is why you have a lawyer, someone who is versed in the, quote, science of law.
Even the intelligent and educated layman has small and sometimes no skill in the science of law. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. You took a video.
Who has studied all these things and understands the proper procedures, when to interrupt, interject, and make your claims. But you, Sarah Catherine Boone Paulsen, decide to terrorize all of your lawyers, pushing them away or saying that you're better than them, claiming they do no work, none of them can help you, and this is why you needed one. You should have zipped your lip, said thank you for anyone helping me with my family trial in addition to my criminal court case, and then this probably wouldn't have happened. And that also happened with New York.
Like I could come to you because I always respected your hairline on television. Okay. For real, for real.
And Julian were trying to get her a lawyer for so many months, so many years probably, for this family court trial. And then in one of the release calls with Julian, which we will get to Julian's call because he is funny. But in that call, he talks about how the lawyer they had set up and met with her for 2 hours after meeting with her now doesn't want to work with her. Apparently, this woman was the wife of someone and she didn't really know what Sarah's case was about. So she said, okay, maybe considering the facts of the case, I'll sit down and we'll see if I can work with you. After sitting down with Sarah for 2 hours, she said, nope, I cannot work with her.
The direction that we're going right now, you will not achieve your goal.
How so? Where's your crystal ball?
Because,
so you want me to conform?
Because, okay, let's do an exercise real quick, just for the hell of it, okay? We had an attorney prepared to come and defend us. For whatever reason, she has a conversation with you, and now she's gone. Because for whatever reason, she didn't get a sense from you that she wanted to work and fight for you.
Think that's me? Do you think that that's me? Think that's me? Do you think that that's me? And I said something?
No,
I told you she sighed the entire time.
That's what we have to change. Because we want her, who gives a fuck if she sighs?
Because that means that she doesn't care enough. That means that she doesn't care enough. But that doesn't, I got the vibe she didn't care enough. That's why I was like, why do
I can guarantee you, so going forward, we're not going to make those assumptions anymore. Listen, you went through 8 on the first time around. We just went through 1 right now. You got to believe me.
No,
when you
have to settle.
You're going to have to fucking settle.
No, man.
You want to achieve your goals.
One way or another, obviously, yes.
Okay. In order for you to achieve your goals, you are going to have to settle. They go hand in hand.
Okay, so wait. So my understanding is from both of those comments, number 1 about Kate, it was my fault, and number 2, all of my other.
Why do you immediately do that? You immediately say, I'm saying it's your fault. No.
Because you're not explaining the reason why. I don't even know the conversation that you and Kate had between one another.
It doesn't matter the reason why.
It does, because I sit here wondering, thinking it's me.
The outcome is what matters, not the reason why.
The last thing out of her mouth. The last thing out of her mouth was, I'm willing to take this. And yes, you have a lot of options.
Yeah, well, she changed her
That's
mind.
what I don't understand, because my confusion is, what did you say? That's why I'm like, well, how?
Nothing. I didn't even speak to her. I got a text message. She called me afterwards. She just said, I just don't feel comfortable going for it, because her and I had a good rapport. Then she called me and she says, another part of the reason is don't want any publicity around my family and my kids and all that. And I said, okay, that's fair.
Well, she should have thought about that beforehand.
She didn't know you beforehand. It was her husband who knew. She didn't know a thing about you. She doesn't do social media. She doesn't do all that other, all that shit.
Didn't tell her?
When you say your name, you figure she knew. She's an attorney
So you
for
guys
you.
just assumed.
Huh?
You guys just assumed that she knew.
Same thing that you do. So yeah, I did assume.
So the whole thing was a waste of time. The whole thing was everybody's waste of time.
And attorneys are a rare breed. They don't want too much work.
Clearly. And then they lie to get off the phone with you because they're afraid of what you might ask them next to do. That's what Kate did.
And Sarah said that up top that she sighed or scoffed or something, and she didn't care and she didn't do this, and so that's why she pushed her away. Same thing with what she did with Miss Cashman, Esquire. When she said, our first meeting, I told her her snotty attitude is unappreciated.
I don't understand what it is that she has against me. I have told her from day one that her snotty attitude was inappropriate, and I try very hard to bear with her and her attitude. I don't know what it is that I'm doing wrong to her. I have told her from day one that her snotty attitude was inappropriate.
She actually thought she had any power to control anyone in this situation while behind bars. And it's that insistent, defiant attitude, that insistent, I know everything, I'm a straight A student.
I mean, I've always been a straight A student.
I'm a perfect mom.
I am an outstanding mother to my son.
I'm better than you.
I am better than you. I am better than you in every single way imaginable. I am a better lawyer, a better lover, a better mother, which is something you will never, ever be, you infertile, career-obsessed bitch.
That leads you to this situation. If you're going to talk that talk, if you're going to be bowdy, then be that one. But now she gets mad because she steps in it every time, and she's making mistake after mistake and not catching these things, and then wants to throw her hands up and say it's everyone else's fault. No, she's mad that the judge isn't going out of her way to give her unfair treatment. She doesn't understand judges are neutral parties. They're not there to help either side. They're there to create a fair opportunity for both sides. When she asked Brian, do you stipulate to this number? If he said yes and you thought no, you should have said it there. That was your open time. They're not going to say, now, Sarah, do you agree with this? Okay, now, because then that's being unequal to Brian and being partial to you, which would also mean she would have to go to Brian anytime you speak and say, well, Brian, do you object to this? And no one has time for that. You have the opportunity. She's going to say, I was over the phone. It was unfair. Who cares? You were present. This is in a post-quarantine world. Zoom appearances, phone appearances are very normal in the court of law. It's about whether you were there and had the fair opportunity to object. She also wrote a motion to appear there in person, and then when she got at the trial, she withdrew the motion. She said, no, well, I'm already on the telephone, so it doesn't really matter.
All right, there was another motion that was filed by you, Ms. Boone, respondent's motion to appear in person for trial that was also filed on August 20th. I will hear you on that motion.
Respondent's motion to appear in person for trial comes now pro se respondent Sarah K. Boone, and respectfully moves this honorable court to issue an order for her transport to rightfully and properly represent herself by being included in person for the final hearing in her family law trial on August 25th, 2025. In support of the respondent's request for equal, full inclusion, 1. Respondent has been ordered by the court without hearing, July 28, 2025, to appear and participate telephonically in this trial due to her incarceration. 2. By, quote, appearing via telephone for this trial, life-changing trial, the respondent's rights and position are heavily impaired, increasing an unfavorable outcome in her self-representation by being excluded in the courtroom with all other parties, in which she is and should be included as such. 3. In-person representation is crucial for the respondent to ensure meaningful access to the court by having the ability to present evidence for her defense, cross-examine witnesses, respond appropriately to arguments made by the petitioner, and accurately perceive the dynamic of the courtroom as a whole. 4. As a self-represented, pro se, litigant, the respondent is at a significant disadvantage when, quote, appearing by phone, especially in a complex trial setting where immediate review and understanding of documents, real-time responses to developments as they arise, communication with the court, presentation of exhibits, observing the opposing party's demeanor is necessary. It is essential for her to engage in all court proceedings for this trial. 5. Remote participation impedes the respondent's ability to fully advocate for her position and interests, particularly given her documented difficulties in accessing legal materials, submitting and receiving documents from the court and opposing counsel, and communicating effectively from within the correctional facility. 6. The respondent's physical presence and participation greatly minimizes the risk of technical difficulties, which can delay, interrupt, or obscure communication, and allows the respondent to interact directly, clearly, timely, preserving the court's invaluable time. 7. The respondent's transport to the court and proper inclusion in the courtroom serves the legal interest of due process, increasing her ability to be rightfully understood as a serious and committed party in this case in respect for the court, ensuring fairness and justice under her extraordinary circumstances. The Florida and United States Constitutions. Wherefore, pro se respondent Sarah K. Boone respectfully requests from this honorable court to enter an order for transport to fully have the ability to represent herself in this family law trial, and after her continued determination, eagerness, hard-fought effort to do so for a hopeful legal and just outcome for over five years. Respectfully submitted this 8th day of August 2025, Sarah K. Boone.
Well, I'm on the telephone, so it does me no good at this point, Your Honor.
All right, are you withdrawing that motion?
I am.
Okay, that was your time to complain, so you can't say I was on the telephone and I didn't want to be there when you withdrew your motion.
And then just my motion for transport.
Okay. I thought they weren't transporting you.
They weren't transporting me. And to be honest with you, Peter, if you're asking me, I'm so torn between this. Like, I'm hoping, okay, I don't want to be transported, but I do want to be transported. If I do get transported, of course I am in the courtroom and it's a completely different experience. If I'm not in the courtroom, I save my bed, I save my position in the program, I save everything here. And don't get me wrong, and Alimony are worth, uprooting and so on and so forth. For no doubt, no question. But my thing is, though, for me to have to go all the way to county jail, all this and everything, and I think right now at this point, because it has to be scheduled so far in advance, I think I'm past the point of even having the possibility of being transported. So my thing is, with me sending this transport motion, I think if anything, it just shows my determination and eagerness to the judge and the world, and eventually he'll see it also, or hear about it, that it's a good faith effort yet again on my part trying to be included in my case. So what are your thoughts?
His thoughts are, it's the dumbest thing he ever heard. All you do is complain about not being involved enough, everyone always oppressing you and making sure you're not included and this and that, and secretly the whole time you don't want to be included anyway. Same thing with being a lawyer. You didn't know what you were doing. You freaked out being like, I have no idea how to apply this, but then act like you know more than everyone. This stuff just annoys me to no end. And she says it shows that I'm putting in a good faith effort. No, it shows the exact opposite. Again, that motion is written snotty and condescending and rude, which we know by this motion was unnecessary. She never had to do it. She could have always written properly, respectfully, and professionally since moment one. But no, she decides to write just horrible catty motions, being like, how dare you ask me to be over the telephone? I have to do this, I have to do that. It will prejudice me. It will be the end of the world if I am not there. This life-changing trial to adequately defend myself and save time and this and that. Actually, I don't really want to be transported. But I want people to think I want to be transported so that they think higher of me. When again, it backfired and people think less of you. And that's why New York is quiet. Because it's like, she has her flying monkeys and her fans that she wants them to enable her and to agree with her on everything, and a lot of them do. But at certain points, New York especially will just go quiet when he doesn't agree with things, and it's like, I don't know how to get around this, because she's just going to repeat it until you agree with it. Or you actually object and say, well, no, you probably should try to be there. And I'm pretty sure after this he goes, well, if they're going to transport you, you need to go. And then she switches up being like, yeah, that's what my heart was telling me. I knew that the whole time.
So what are your thoughts?
I hear the conundrum, I guess is the word.
Yeah.
I would say if you can, I would go.
Yes, of course I would. If she, if it happened, then of course I would.
Yeah, I mean, if they want you to go, you're going to go. But I mean, I would, if I had a choice, I'd try and make every effort to go.
Yep. Okay, well, that's what my heart was telling me at the same time also. And I would love to know also the court on its own motion. Why would you do that? And I don't know if it's because she was confused on how to do a transport order or what's going on or whatever else it is. I don't know why.
Girl, it's because the prison... That's exactly right, Linda. It's because the prison don't like your ass. They were not going to pay to transport you. And again, this is what I'm talking about. How insulting. I don't know if that dumbass judge didn't know what the fuck she was doing, or she's too stupid to know how to write a transportation order. I just don't get it. It's because this is a civil proceeding, and transporting you from Lowell to Orange County, which is like 90 minutes, an hour and a half away, would take so many resources. They would have to pay to transport you, pay for the mileage, pay for the security guards to transport a violent criminal offender, meaning you have different security protocols than someone else. They have to stay at the courthouse all day and sit with you for hours on end. All of this is overtime pay, by the way. And the processing of leaving the prison and coming back to it would also take all of this time and resources. It would easily be over $1,000 just to transport her, have all of these things, and to get her back. And for what? This is a civil proceeding, not a criminal trial. In civil court, you don't have a constitutional right to be present. You have the right to have access. She did. She does. And plus, we know from the trial that Judge Jackson tried to get her there when Correctional Officer Santiago butted in, and it was so cringe because she wasn't under oath or anything. So it's like, why are you talking in court right now?
I'm sorry. My classifications department is speaking to me. Hold on one moment, please. I'm sorry.
Hello, excuse me. Your Honor.
Oh no, this is so cringe. Yikes, this is not going to end well.
Hello, Your Honor.
Yes.
This is Classification Officer Santiago. I work at Lowell Correctional Institution. Due to our procedural operations over here, she's going to need to be off the phone at 4:50 in 5 minutes. And I just thought that I would come on here and let you know.
Your Honor, may
then, and then
Okay.
also for future court appearances, they are requesting that communications go through the classification officer so that we can make sure that these she has plenty of time to complete all of this, so that we're not having to rush her off the phone.
Right. Information was sent regarding this final hearing. And we, my office has been in contact with the Department of Corrections for quite some time over the last couple of months trying to get this set up, because we had initially requested that she be transported to Orlando for this hearing. So there has been contact. All right, but right now you are slowing us down and trying to get this finished. So give me just a minute. Hold on.
And you could see that Judge Jackson was upset that she wasn't able to come down here, but she understands why. If Sarah was in Orange County Jail like she was before going to prison, it wouldn't have been an issue at all. But she stalled and stalled until the end of her criminal case. She lost.
We, the jury, find the defendant guilty of murder in the second degree.
Sentenced to life in prison.
Ms. Boone, court sentences you.
Electric chair.
Holy shit. God damn it.
Electrocute that bitch. And I want you to pour some water on her first.
Life in the Department of Corrections.
And now has a new forever home in Lowell Prison. Lowell Prison, wherever. Because if she was set free and she was in Orange County, she would have just already been there. But no, her actions always have consequences, and those consequences create hurdles.
Well, if it isn't the consequences of my own actions. What's up? What's up? Trying to...
Or if she doesn't want me in the courtroom because of the insanity of social media and everything that we've already forewarned them about.
I think that's what's happening. Like we talked about the last.
But she can't do that to me. She can't do that to me.
No, you wanted him to say, that's right, just put in a good faith effort, give him hell, put in motions you don't even want, just like the bond. I want to use my rights to get a bond, even if I can't pay for it. I want this, I want that. The Holy Spirit is pushing me to do, even if I don't get one. I can officially say I tried, since no one else would for me.
Sarah Boone? 42-year-old Sarah Boone faced a judge Wednesday morning charged with second-degree murder. Detectives say she left her boyfriend, 42-year-old Jorge Torres Jr.
The autopsy findings, which include significant evidence of trauma to multiple sites on the victim's body.
The state asked for no bond. The state asked for no bond. No bond. Bond. The judge agreed. The judge agreed. In Orange County, Alex Villarreal, West 2 News.
Don't give me rights if you don't want me to fully maximize them. Be the revolution. It's just your address. So if I do achieve a bond, I will need to be at the address. I'm a good roomie. That's even if I get the bond and can even pay. Doubtful. But who knows? From all my cheerleaders out there, maybe a GoFundMe page will be made for me by my loyal, quote, fans. At least the world will see my efforts, and I believe if I am denied would be in my favor anyway, as everyone knows how exploited my case is and the illegal happenings daily with everything on the internet.
Sending this transport motion, I think if anything, it just shows my determination and eagerness to the judge and the world, and eventually he'll see it also, or hear about it, that it's a good faith effort yet again on my part trying to be included in my case.
Just another example of it. She complains and asks for things she doesn't even want just to say she did it. And the most troubling part is that end saying that she knows her son will see this eventually. So she's been cognizant that her whole criminal and family court process will be uploaded publicly and her son will one day see it. Even though she doesn't want him on the computer and gets mad when he says, oh, she's a second-degree murderer, and then loses her mind. But she's aware that her son will see how she behaves. How do you think he is going to feel once he hears how you were at that trial? There's no way his mom and his dad are at trial, and it's filmed, and it's publicized that he's not going to watch. And all he's going to hear is you use him to manipulate people again and again, to speak for him, to speak against what he actually said, to put words in his mouth. in order to get what you want, not to actually protect your child like you claim you're trying to do. And then says, well, of course, son and alimony are absolutely worth uprooting for. Absolutely. But if I don't have to and I can keep all of my luxury here, I could have been living comfortably and I can keep that.
It's like I'm in this fabulous dorm and everything, but I just have nothing in my drawer but rust and the old newspapers that the previous girl left. And if to be paying me something, or at least, just something, I would have something in my drawer. And it's just like out of $61,000, I'm supposed to settle for what he's trying to throw at me or nothing? Like, I could have been living comfortably.
Then I just want to stay. And then I can complain after saying no one understood me. Marty the motorcycle has had it as well. He says he can see clearly, plain as day, that this is just another endless manipulation pattern that will fall flat, or it did fall flat, but is only there so that she can further complain later on. Ridiculous. That was not going to be addressed beforehand. This is the time where motions get addressed, during hearings. It just so happened your hearing was the final hearing. Now, Linda has a lot to say about this because she can already see the games Sarah's going to play about this. And she can be mad about it if she wants, but... And that silence was when you were supposed to object. So anything you say after the fact does not overrule what was established in trial. Whew, that was a wordy way to say that, but I hope that made sense. And this is just another one of those differences between criminal and civil court, where criminal court is more steeped in the facts and beyond a reasonable doubt, and you really want to adhere to everything I present is correct. All the numbers need to be in order, and if I need to go back and make corrections, I'm going to make sure that I make the right objections that allow me to make those corrections later on. Civil court is mainly trying to resolve issues. That number was proposed, it was agreed upon, there was met with silence, there's no issue. You bringing up an issue now after the judgment is a no-go. But she's gonna try anyway. Alrighty, now we have officially reached the end of this video. This has been a mammoth of a project and we have gone down every possible road imaginable. I have no thoughts left in me. Well, that's a lie, but I have no strength to get out those thoughts left in me in this video. So this is where we're going to have to cut it. All in all, this is pretty much the best outcome that Brian could have hoped for. Yes, she still gets paid something, so she can't say that she was completely steamrolled and got nothing, but her own actions, as always, dictated her results. If she did not elongate this, if she mediated, if she did not stretch this out, she would have gotten way more money. She would have actually been entitled to that $20,000+. But given the circumstances of her behaviors, her antagonism, her frivolous defenses, you are more than entitled to reasonable attorney's fees that will counterbalance anything you owed her. And, and that's brilliant of, I'm willing to waste all of this money and give this money to someone else just so I don't have to give this to you. When, if you were a nice person who actually tried to work with people and didn't just insult them 24/7, that money probably could have gone to you. But now you're left with $3,000, just under $4,000, to be paid over 7 installments. That's a lot. Which is just, it's funny because it's like you're going to have to really budget that if you're only getting these $600 here and there. She likes to waste all this money on stamps, paper, envelopes, pens, things to just continue her harassment and not to actually continue her livelihood. But it'll be all hers, just like that life sentence is all hers. She went down every path she wanted to go down. She extended it, she fought, she quote unquote properly defended herself, and tried to exert as much power and control that she no longer has as possible. And in the end, ultimately, in conclusion, at the end of the day, once and for all, she did this to herself. And with that, if you enjoyed this video, remember to like, comment, subscribe, dislike if you're feeling it. Until next time.